Tommy, I'm updating this one. We're going to make sure Jess is going to work with the adapter.
Presented.
All right.
To prove that Desmond Jones is guilty beyond a reasonable doubt, and obviously, in closing statements, that's what they're going to be attempting to show, is that the state did not meet their burden, and we'll see. And obviously, the prosecution is going to say that they did meet their burden. Clearly, they're going to use Desmond Jones's 6 statements that he made to the authorities against him. So, hold on. They're saying audio's off, folks. Oh, okay. So, do I need to repeat all that, folks? All right, I'm going to start over because the audio was off. Okay. First of all, I'm Tanya Eiserer, an investigative reporter here at Channel 8. Justin Moore, the lawyer person who's going to be joining me, is still stuck in traffic. So I'm going to be by myself for a little bit. So if you guys have some questions, is my mic? Can y'all hear me? Folks, can y'all hear me? They can all hear me. Okay. So anyway, let's see. Both sides rested. Desmond Jones, the judge is reading the charge. Let's listen.
Applicable in this case. You are instructed that you may read these instructions as a whole. Offense definitions. A person commits the offense of engaging in organized criminal activity if, with the intent to establish, maintain, or participate in a combination or in the profits of a combination, he commits murder or aggravated kidnapping. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual or intends to cause serious bodily injury and commits an act clearly dangerous to human life that can cause the death of an individual. A person commits kidnapping if he intentionally or knowingly abducts another person. A person commits the offense of aggravated kidnapping when he intentionally or knowingly abducts another person and uses or exhibits a deadly weapon during the commission of the offense. Term definitions. Abduct means to restrain a person with the intent to prevent his liberation by secreting or holding him in a place where he is not likely to be found or using or threatening to use deadly force. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Attempt to commit an offense occurs if, with the specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Combination means 3 or more persons who collaborate in carrying on criminal activities, although participants may not know each other's identity, membership in the combination may change from time to time, and participants may stand in a wholesaler, retailer, or other arm's length relationship in illicit distribution operations. Conduct means an act or omission and its accompanying mental state. Consent means assent in fact, whether express or apparent. Conspires to commit means that a person agrees with one or more persons that they or one or more of them engage in conduct that would constitute the offense, and that person and one or more of them perform an overt act in pursuance of the agreement. An agreement constituting conspiring to commit may be inferred from the act of the parties. Deadly force means force that is intended or known by the actor to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Individual means a human being who has been born and is alive. Person means an individual. Restrain means to restrict a person's movement without consent so as to interfere substantially with the person's liberty by moving the person from one place to another or by confining the person. Restraint is without consent if it is accomplished by force, intimidation, or deception, or by any means including acquiescence of the victim if the victim is a child who is less than 14 years of age. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Mental state definitions. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Criminal responsibility. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with commission of the offense. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he aids or attempts to aid the other person to commit the offense. Defenses excluded. It is no defense to the prosecution for engaging in organized criminal activity that one or more members of the combination are not criminally responsible for murder or aggravated kidnapping, or one or more members of the combination have been acquitted, have not been prosecuted or convicted, have been convicted of a different offense, or are immune from prosecution, or a person has been charged with, acquitted, or convicted of murder or aggravated kidnapping, or once the initial combination of 3 or more persons is formed, there is a change in the number or identity of persons in the combination, as long as 2 or more persons remain in the combination and are involved in a continuing course of conduct constituting murder or aggravated kidnapping. Engaging in organized criminal activity. This is the application paragraph. Now, bearing in mind the foregoing instructions, you must determine whether the state has proved beyond a reasonable doubt that the defendant committed the offense of engaging in organized criminal activity as charged in the indictment. If you unanimously find from the evidence beyond a reasonable doubt that on or about and between June 26, 2017 and July 1, 2017, in Dallas County, Texas, the defendant did then and there, with the intent to establish, maintain, and participate in a combination and in the profits of a combination, unlawfully commit one or more of the following offenses. Murder, in that the defendant did then and there intentionally and knowingly cause the death of an individual, namely Shavon Randle, by shooting Shavon Randle with a firearm, a deadly weapon, or murder, in that another person did then and there intentionally and knowingly cause the death of an individual, namely Shavon Randle, by shooting Shavon Randle with a firearm, a deadly weapon, and you further find that the defendant, acting with the intent to promote or assist the commission of the murder, did aid or attempt to aid another in the commission of the murder, or murder, in that the defendant did then and there, with the intent to cause serious bodily injury to Shavon Randle, committed act clearly dangerous to human life that caused the death of Shavon Randle, an individual, by shooting Shavon Randle with a firearm, a deadly weapon, or murder, in that another person did then and there, with the intent to cause serious bodily injury to Shavon Randle, commit an act clearly dangerous to human life that caused the death of Shavon Randle, an individual, by shooting Shavon Randle with a firearm, a deadly weapon, and you further find that the defendant, acting with the intent to promote or assist the commission of the murder, did aid or attempt to aid another in the commission of the murder, or aggravated kidnapping, in that the defendant did then and there intentionally and knowingly abduct Shavon Randle, in that the defendant restrained Shavon Randle by confining her and by moving her from one place to another, or by secreting and holding Shavon Randle in a place where she was not likely to be found, or by threatening to use deadly force, and defendant used or exhibited a deadly weapon, namely a firearm, during the commission of the offense and abduction, or aggravated kidnapping, in that another person did then and there intentionally and knowingly abduct Shavon Randle, in that another person restrained Shavon Randle by confining her and by moving her from one place to another, or by secreting and holding Shavon Randle in a place where she was not likely to be found, or by threatening to use deadly force, and that person used or exhibited a deadly weapon, namely a firearm, during the commission of the offense and abduction, and you further find that the defendant, acting with the intent to promote or assist the commission of the aggravated kidnapping, did aid or attempt to aid another in the commission of the aggravated kidnapping, then you will find the defendant guilty of engaging in organized criminal activity as charged in the indictment, and you will not consider whether the defendant is guilty of any lesser included offense. You must all agree that the state has proved beyond a reasonable doubt that the defendant committed the offense of murder or aggravated kidnapping, but you do not have to be unanimous as to which offense the state has proved. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the lesser included offenses of murder or aggravated kidnapping as instructed below. Murder application paragraph. Bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about and between June 26, 2017 and July 1, 2017 in Dallas County, Texas, the defendant intentionally or knowingly caused the death of an individual, namely Shavon Randle, by shooting Shavon Randle with a firearm, a deadly weapon, or with intent to cause serious bodily injury to Shavon Randle, committed an act clearly dangerous to human life that caused the death of Shavon Randle, an individual, by shooting Shavon Randle with a firearm, a deadly weapon, then you will find the defendant guilty of murder as included in the indictment. Or, if you find from the evidence beyond a reasonable doubt that on or about and between June 26, 2017 and July 1, 2017 in Dallas County, Texas, another person intentionally or knowingly caused the death of an individual, namely Shavon Randle, by shooting Shavon Randle with a firearm, a deadly weapon, or with intent to cause serious bodily injury to Shavon Randle, committed an act clearly dangerous to human life that caused the death of Shavon Randle, an individual, by shooting Shavon Randle with a firearm, a deadly weapon, and you further find that the defendant, acting with the intent to promote or assist the commission of the murder, did aid or attempt to aid another in the commission of the murder, you will find the defendant guilty of murder as included in the indictment. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of if you find from the evidence beyond a reasonable doubt that the defendant is either guilty of engaging in organized criminal activity or murder, but you have a reasonable doubt as to which offense he is guilty, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the lesser included offense of murder. If you do not so find, or if you have a reasonable doubt thereof, or if you are unable to agree, you shall next consider whether the defendant is guilty of aggravated kidnapping as included in the indictment as instructed below. Aggravated kidnapping application paragraph. Bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about and between June 26, 2017 and July 1, 2017 in Dallas County, Texas, the defendant intentionally or knowingly abducted Shavon Randle, hereinafter called complainant, in that the defendant restrained the complainant by confining the complainant and by moving the complainant from one place to another, or by secreting and holding the complainant in a place where the complainant was not likely to be found, or by threatening to use deadly force, and the defendant used or exhibited a deadly weapon, namely a firearm, during the commission of the offense and abduction, then you will find the defendant guilty of aggravated kidnapping as included in the indictment. Or, if you find from the evidence beyond a reasonable doubt that on or about and between June 26, 2017 and July 1, 2017 in Dallas County, Texas, another person intentionally or knowingly abducted Shavon Randle, hereinafter called complainant, in that another person restrained complainant by confining the complainant and moving the complainant from one place to another, or by secreting and holding the complainant in a place where the complainant was not likely to be found, or by threatening to use deadly force, and that person used or exhibited a deadly weapon, namely a firearm, during the commission of the offense and abduction, and you further find that the defendant, acting with intent to promote or assist the commission of the murder, did aid or attempt to aid another in the commission of the murder, then you will find the defendant, or you will find during the commission of the offense and abduction, you further find the defendant acting with the intent to promote or assist the commission. Let me see the lawyers up here, I'm sorry. Sorry. All right, that's a typo, members of the jury. It should say, during the commission of the offense and abduction, and you further find that the defendant acting with the intent to promote or assist the commission of the aggravated kidnapping did attempt to aid another in the commission of the aggravated kidnapping. You will find the defendant guilty of aggravated kidnapping as charged in the indictment. If you should find from the evidence beyond a reasonable doubt that the defendant is either guilty of the charged offense of engaging in organized criminal activity or of the lesser included offense of aggravated kidnapping, but you have a reasonable doubt as to which offense he is guilty, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the lesser included offense of aggravated kidnapping. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, you will acquit the defendant and say by your verdict, not guilty. Duress. It is an affirmative defense to the prosecution for any offense that the person charged engaged in the proscribed conduct because he was compelled to do so by the threat of imminent death or serious bodily injury to himself or another. Such compulsion exists only if the threat of force is such as would render a person of reasonable firmness incapable of resisting the pressure. The defense of duress is unavailable if the actor intentionally, knowingly, or recklessly placed himself in a situation in which it was probable that he would be subjected to compulsion. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to circumstances surrounding his conduct when he is aware that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the actor's standpoint. The burden of proof for the affirmative defense of duress rests upon the defendant. To establish such defense, the defendant must prove by a preponderance of evidence. By the term preponderance of the evidence is meant the greater weight and degree of the credible evidence in this case. If you should find from the evidence beyond a reasonable doubt that the defendant is either guilty of the offense, of the charged offense of engaging in organized criminal activity, or the lesser included offense of murder or aggravated kidnapping, but you further find by a preponderance of the evidence that the defendant participated in the offense because he was compelled to do so by the threat of imminent death or serious bodily injury to himself or another, then you should acquit the defendant on the grounds of duress and say by your verdict not guilty. Alternatively, if you should find from the evidence beyond a reasonable doubt that the defendant is either guilty of the charged offense of engaging in organized criminal activity or of the lesser included offense of murder or aggravated kidnapping, but you further find that the defendant intentionally, knowingly, or recklessly placed himself in a situation in which it was probable that he would be subjected to compulsion, then you will find the defense of duress unavailable to the defendant and return a verdict of guilty. Extraneous conduct. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed any crime, wrong, or act other than the offense alleged against him in the indictment in this case, you cannot consider that testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other crime, wrong, or act. Even then, you may only consider it in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, lack of accident, or state of mind of the defendant, and for no other purpose. Indictment. An indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense does not give rise to any inference of guilt at his trial. Presumption of innocence. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or to produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all of the evidence in the case. Burden of proof. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all of the evidence before you in these instructions, you will acquit him and say by your verdict not guilty. Evidentiary instructions. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence nor passes on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. Concluding instructions. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is herein given you, and be governed thereby. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as the presiding juror. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. After you retire, you may communicate with this court in writing through the officer who has you in charge. Your communication must be signed by the presiding juror. No one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause and restrict your deliberations solely to the issue of guilt or innocence of the defendant. Following arguments of counsel, you are retired to consider your verdict. After you have reached a unanimous verdict, or if you desire to communicate with the court, please press the red button close to the door and the bailiff will respond. It's signed by me, Tracy Holmes, Judge of the 363rd Judicial District Court. And the final pages of the verdict forms, and they read as follows. We, the jury, unanimously find the defendant, Desmond Armand Jones, guilty of engaging in criminal organized activity as charged in the indictment, with a signature line for the presiding juror to sign and print his or her name. Or we, the jury, find the defendant, Desmond Armand Jones, guilty of murder as included in the indictment with signature lines. Or we, the jury, find the defendant, Desmond Armand Jones, guilty of aggravated kidnapping as included in the indictment. Or we, the jury, find the defendant, Desmond Armand Jones, not guilty with signature lines. Mr. Adams.
May it please the court.
Thank you, sir.
Opposing counsel. Your Honor, may I please have a 10-minute warning?
When you've spoken 7 minutes?
10 minutes, Your Honor.
I'm sorry?
Yes, ma'am, 10 minutes?
After you've spoken 10 minutes?
Yes, Your Honor. May I proceed?
Yes, sir.
Thank you. In this tonight, does Special Agent Mahan's words to the defendant back on July 1st, 2017? I want those words to stick with the 14 of you. Because just as Special Agent Mahan told that to the defendant, those are the words that need to carry with the 14 of you and the 12 of you that go back into that deliberation room. This is your opportunity to finally end this. This is your opportunity to give justice to the family and Shavon Randle, and to hold Desmond Jones accountable for his actions. You know, we talked a lot during Fort Iron, and I know you've heard a lot of evidence. It's been overwhelming, but I've watched each and every one of you, from your physical reactions when you saw the DNA reports, to your reactions when the description of the crime scene was told, to how you paid attention to each and every detail of those cell phone records. We talked during Fort Iron about engaging in organized criminal activity. And I gave this hypothetical to you of the Ocean's 11 movies. And I used my co-counsel, Ms. Falk, and Ms. Biggins about if we committed these crimes and if I was the mastermind and I never went there. If we had somebody inside the casino and all they did was keep a lookout, right? And they never took part in the actual robbery of the Bellagio. And each one of you told me, given those facts, you could hold each and every single person in that organization criminally responsible. And that's the facts we've brought you. Because there's no facts that Darius Fields was ever there when Shavon Randle was kidnapped or brutally murdered. But those are the facts that you have before you. Each person has a unique role in this criminal organization. And what I want you to pay attention to is that it's to maintain or to establish, maintain, or participate in that combination, right? When we talk about what a combination is, it's 3 or more people. Well, you've got Darius Fields, you've got Devontae Owens, you've got Laquan Wilkerson, you've got Mike Tice, you've got Desmond Jones, you've got the 3 or more, right? Well, they're not establishing this criminal organization. It's already been established. Because Darius Fields is already out there selling dope. He's already getting 100 pounds of marijuana delivered to him. He's got his muscle. The criminal organization is already established. And I don't disagree that Mike Titus and Desmond, they're probably towards the bottom. They're not Darius Fields as far as the guy who never goes, who was ordering the weed. But was this criminal activity, of kidnapping Shavon Randle, was it to maintain this criminal organization? Did they try to get their weed back? Was that what the 5 of them were working towards? can't tell me he was not involved in this criminal organization when he's in the hotel room of Darius Fields with 100 pounds of marijuana, flashing cash. You can't tell me he's not a part of it. Each and every single person in this organization is criminally responsible and just as guilty as the other. Although they had different roles and took different actions, each one of you promised me, just as you promised the defendant you could give him a fair trial, you promised me that given those facts, you would hold that person criminally responsible. We talked about the law of parties. Anybody who aids or attempts to aid in the commission of a crime, right? Mere presence alone is not enough. I can't just be one of those bystanders in the casino. That's not enough. But did I provide the car? That was the exact example that one of the jurors gave me. Providing the car, providing the weapon. Providing the weapon, you are just as guilty as providing the car, which the defendant did in this case. He is just as guilty as part of that organization based on the law of parties. Each individual is equally criminally responsible. I'm going to point out to you on page number 8, where we talk about duress. You know, there's certain laws that are there to protect good people like yourself. People that get up, go to work, take care of their kids, take care of their family. There's certain laws there that are there to protect us. And we talk about what is duress. Well, duress is a situation where somebody puts a gun to my head and says, if you don't do this, I'm going to kill you. Or puts a gun to my family's head and says, if you don't do this, I'm going to kill your family. That's duress, right? It's the defendant, let me go back one slide. Compelled to do so either by threat of imminent death or serious bodily injury to himself or another. He's compelled to do something. And I'm going to talk about that duress here in a second because this is ridiculous. It's in the charge. You can read it, but it's ridiculous. Because the compulsion has to exist that would render a person of reasonable firmness and capable of resisting the pressure. That's a whole bunch of legal terms, right? Would a person of reasonable firmness, would you think it's reasonable over the 26th, the 27th, the 28th, the 29th, the 30th to keep going in this, to keep acting on this aggravated kidnapping, to keep acting on taking this child, this 13-year-old girl? Because you know from the evidence, and Ms. Falk is going to talk to you a lot about the specific facts that come up regarding duress. But think about the time, and this calendar, and the timeline, and all the opportunities that Desmond had that he could have removed himself from the situation, all those phone calls that he made throughout all this, the times when he was alone. Was it imminent? Did he have a gun to his head? Was his family being held at gunpoint? No, duress is there for when you and I go home at night and somebody points a gun to our head and says, go in and take something from this gas station or I'm going to kill you. That's duress. You don't get duress, and the law specifically says you don't get duress in this situation. It's not for the drug dealers. It's not for the people running around with 100 pounds of weed. Because what the law says is unavailable if the actor intentionally, and that's the defendant, Desmond Jones, it is unavailable if the actor intentionally, knowingly, or recklessly placed himself in that situation. And defense counsel cross-examined Special Agent Mahan about inventory control. That's ridiculous. That is absolute inventory control. That's what we're going to call this, kidnapping a 13-year-old girl and executing her, putting 4 shots in her. Inventory control. No. This man does not get the benefit of duress. He doesn't get duress. He doesn't get to associate himself with Darius Fields, Devontae Owens, Laquan Wilkerson, and Michael Tice, and then say that this was duress after the fact, right? Because the only person we hear duress from is from this man. It's not duress. He placed himself in that situation. That's an occupational hazard, folks. That's what the law says. If you intentionally place yourself in that situation, or if you know that there might be some compulsion, or if you're just reckless about it, guess what? If I get involved with the cartel, I should expect some bad things might happen. I might be compelled to do some things I don't want to do, right? It's bad business. But that's the duress he wants you to believe, that he was so scared and so concerned over those 5 days. And this is why it's important. Because the 12 of you, the 14 of you, are the sole judges of the credibility of the witnesses. You get to look at each piece of evidence, all 700 and however many. You get to listen to the testimony, and you get to decide how you want to apply it to this law. That's all that matters. What you've heard and what's been admitted in front of you in this law. That's all you can consider in this. When we talk about the credibility of a witness, you get to determine everybody's credibility. And I'm sure the defense will want to say something about our witnesses. You get to decide whether or not you believe that witness. And that includes Desmond Jones' own statements. There's a lot of them in there. You can go back and watch them. We made a decision not to play every single video, but you have them. You have the transcripts. Y'all can sit back there and read them if you want to. But you get to go back there and decide his credibility. Was he credible? Did he have a motive to lie? Did he have a motive to lie? Did he have a motive at the beginning to minimize his role? Right? You don't check your life experiences at the door. We talked about that. And we talked about you use your life experiences, you use the things that you've learned through life, and you go back there and you deliberate. What was his motive? What was his motive to give almost no information whatsoever and slowly begins to build on what he gives? And that's important because to believe duress, you have to believe this man. You have to believe him. And you have to believe that he didn't intentionally or knowingly or recklessly place himself in that situation where he could be compelled to do something. Now it's in the charge. You can consider it, or you can say, you know what, that's absolutely ridiculous. I'm not going to consider duress. That's not this case. There are cases where duress is appropriate, but this isn't it. You get to look at and see whether or not his story makes sense. Whether those stories, as they keep continuing on, do they make sense, or are there holes in them? Does he contradict himself? Does his timeline not make sense? Is it consistent with other witnesses? Well, you've heard a whole lot of scientific evidence. Cell phones, DNA, firearms. Does it make sense? And Ms. Falk is going to talk to you a lot about the specific facts, but is it consistent with the science? Is it consistent with the cell phones? Is it consistent with what the autopsy showed? And is it corroborated by anything? You have to judge his credibility in those statements just as you do any other witness. Ladies and gentlemen, when we started out talking, I asked that you be open and honest with me about your feelings about the law. And I talked to you about aggravated kidnapping, and I talked to you about murder, and I said you know it when you see it. The hypothetical for aggravated kidnapping, one of the jurors told me was somebody grabs somebody and they throw them in a car or a van and they take them off. Well, this is a case where a 13-year-old girl was taken from her home. A pillowcase was placed over her head. Her arms were bound behind her back. And she was taken to a drug house in the middle of summer when most 13-year-olds should be outside playing in the street. She's getting ready for 7th grade. She's in her pajamas. Just got done FaceTiming her mom. We don't know how long she spent in that trap house, and we never will, before they placed that first bullet in her. Before she had that bullet enter into her stomach, multiple shots to her head. You know aggravated kidnapping when you see it. You know murder when you see it. This is a group of individuals who went and took an innocent 13-year-old girl over 100 pounds of marijuana. I'm asking that you go back there and end this for the family, for Shavon, find Desmond Jones guilty.
Thank you, Mr. Adams. Mr. Lane?
May it please court, counsel. I wanted to clear up something preliminarily. There has been some confusion around this video. And maybe it's just confusion in my mind. But I want to make sure that it's not in your mind too. So I got to clear this up real quick. I don't know how to work this so that I can fast forward it, so we're just going to take a second. That man right there is not Desmond Jones. Okay? That's what I wanted to clear up. If it was Desmond Jones, you dang sure would have heard about it, wouldn't you? Now I want to get to the evidence, and I want to start by saying that contrary to what my learned counsel here said, this does not end today. This does not end today. Regardless of your verdict, it doesn't end. Because Darius Fields, Laquan Wilkerson, and Devontae Owens are really the guys who are responsible for the murders of 2 people, and Titus is responsible too. Those guys have not been held to account for this. They will be. And, you know, we've been hearing a lot about puzzle pieces in hindsight, and I agree that the pieces of the puzzle have come together, and then we can look back on what occurred in this week in June. And you know what happened? The state proved beyond a reasonable doubt that Darius Fields, Mike Titus, Devontae Owens, and Laquan Wilkerson are guilty as hell. They are guilty as hell of taking that little girl from everybody. And they're also guilty of taking Mike Titus. They're guilty. And you saw the well of this courtroom chock full. You couldn't walk through here for all the evidence. For all the evidence that was collected by the FBI. Right? What ties Desmond Jones maybe to this drug conspiracy? One picture. We don't know where it came from. We don't know when it was taken. Is that beyond reasonable doubt? They don't even know. But it's this one picture. That one picture that ties in the drug conspiracy. Fingerprint evidence. Tommy said that there's a lot of physical evidence and scientific evidence. I agree, there's tons of it. But none of it comes back to Desmond. There's no fingerprint evidence on Desmond. Not in any relevant place. DNA, we had a ton of DNA evidence. None of it comes back to Desmond Jones, except in the Ford 500. We all know that he was driving the Ford. We all know it's his girlfriend's. He borrowed it from her. There's no other DNA evidence in Desmond Jones in any relevant place. None. The shoe print evidence. You know, and one of the things that I want to touch on at this point is the credibility of the witnesses. And I got to tell you, those FBI agents displayed an amount of candor and honesty that should make them proud and that should make all of us proud. Because in this day and age, we're not seeing a lot of it, but we saw it from them. They were honest. They told you the truth, and they answered my questions truthfully, every single one. Dr. Tread told us that that shoe print could have been made by any similar shoe of the same size. Okay? He didn't tell you that Desmond Jones made that print because he was honest. And that's where I want to clean something else up. The bloody shoe print, and this confounded me, and I still don't understand why it wasn't done. But the bloody shoe print over on Keys, y'all can take this back. This is State's 420. All right? That bloody shoe print looks an awful lot like it was made by that shoe. Now, they didn't send this to Dr. Tread. I don't know why. But I wanted to clean that up for you. So that's going to be 420 and 385. Going through the cellular telephone evidence. There's no evidence that you received, no real evidence, no testimony, no real testimony that you received from this witness stand that indicated that that number, that 9766 number, was connected to Desmond. Remember Kiana Bell, his girlfriend? Do you remember how they had to force her to remember that phone number? Nobody knows how that phone number got associated with Desmond Jones. Nobody knows. There are a whole lot of people investigating, there are a whole lot of people involved, and nobody can tell you where that number came from. No one. Except that that number is associated with T.D. Owens Barbecue. That we know, right? A guy named Simmons. Who's that? Nobody went to look for him. Nobody even asked. Nobody went to go get a sandwich and say, hey, you guys got a guy named Simmons around here? That didn't happen. It didn't happen. That would have been corroboration, right? Or talk to Kiana Bell and say, hey, when did Desmond send you or call you and say I'm going to bring the car back? When did that happen? And then we'll go look at the phone records. Look at Kiana Bell's phone records and see what number Desmond called her from. They didn't do that. They took that from you. Okay? They did not provide that to you. And I don't know why. But it's something you should think about. Rohag, Mahan, and others had at least 3 other numbers for Desmond. Or none at all. Some of the witnesses said Desmond didn't have a phone. Didn't even have one. He used Facebook Messenger. Desmond gave him the login to his account. Where's that information? You don't have it. Because they didn't give it to you. All this mountain of evidence, and they didn't give it to you. The Jones phone didn't show up until after the robbery. We know it was born on June 15th of 2017. But it doesn't show up in any of the slides until after the robbery. At the same time, Mike Titus's phone goes away. So who was using the phone? They can't tell you, right? Because that's a limitation of the science. They can't tell you. But the other reason they can't tell you is because they, with all the hindsight in the world, the federal government's power and money, they didn't do that job to corroborate that phone being in Desmond Jones' hand. They didn't do that. And now they expect you to convict him with that information. Talk about the photograph. Jones is at the Motel 6, maybe, right? Because we don't know where that photograph came from. If it had been taken on a cell phone, there may have been GPS data on it with a timestamp and where it was taken. We don't have that because they didn't give it to you. Owens and Jones' phone are not in the same car as the kidnappers. There's a conference call. You heard from Special Agent Sedgwick. Again, incredibly candid and honest. He was, right? He was. And, you know, he said, I have a lot of experience with bank robberies, and it looks like Owens was a lookout because there's a 700-second call, which is like a little over 10 minutes, right? And in the midst of that, there's a call to another number, right? That's the conference call. That's when Mike Titus and Laquan Wilkerson are inside that house, and they call up to the boss to say, hey, guess what? Ladouris isn't here. And he says, take whoever you can find. Because they're evil bastards. All right? Make no mistake about that. Wilkerson and Owens and Fields are evil people. And finally, Special Agent Sedgwick, at the end of our conversation, he said he would not want to be convicted on information like this. He was honest. So what are we left with? Well, you heard Kiana Bell testify. You heard what she said. She was on the phone with Desmond. Desmond passed the phone to Mike Titus. I promise we're bringing the car back, and all of a sudden it's snatched up by Devontae Owens. And she cleaned it up. All right? And Tommy was talking about corroboration. Corroboration of the duress. Corroboration of, I don't want to be here. What did Devontae Owens tell Kiana Bell? I mean, he's so brash. What did he tell her? He said, these aren't going anywhere until I get my shit back. Whose? My shit. Not Desmond Jones. Not Mike Titus. Devontae's. Darius. And Laquan was the muscle. Ladies and gentlemen, this does not end today, regardless of what you do. And let me tell you else, regardless of what you do, it doesn't end for him, because he lived it. This is the car being returned, by the way, on Friday at 1 a.m. Desmond goes home and pours his heart out finally, because he's finally been released. He's just seen his best friend get shot in the head. Kind of a bad day. And then, miracle of miracles, all of a sudden on Saturday, they find Desmond. They didn't find Desmond. Desmond's mom called. And what did he do? What did Desmond do? He told them where the bodies were. And then over the next 7 days, what did he do? He told them who did what and when. Once the FBI told him he'd be safe, he told them who did what and when. And he told the truth. Now they're going to get up here and call him a liar. But the only story that you have that is corroborated by all the physical evidence and all the rest of the evidence you've seen, the Desmond story. It's not one. What I would suggest you do is this. You have a lot of information and a lot of material. You've got every single one of Desmond's statements. And I want you to actually play them in your mind in the correct order. Okay? Remember what Special Agent Mulligan said? Remember what Detective Rohack said? People who work in child abuse? It said that disclosure is a process. Mulligan said in her experience, you get a little bit more each time you talk to somebody. I want you to look at those statements in the correct order. And you'll see that bit by bit by bit, drip after drip, he tells them exactly what happened. And then on the 7th, he tells him everything. The dam breaks, and he tells him everything.
to talk to you about these 5 statements because in here you'll find the truth. In here you'll find the truth about what happened to Shavon Randle and the truth about what happened to Michael Titus. And you'll find the truth about why Desmond Jones acted the way he did. You will find in here the truth is that he did not act as part of a criminal conspiracy, the drug conspiracy. He acted because he was compelled to act by that conspiracy. You will see that, as Mr. Lehman just said, as you look through these, all 5 of them, that there is a process of disclosure going on. Mr. Jones is afraid to speak at first. And as he gradually goes on through the days, he tells more and more of what actually happened. And until on the 7th, he told everything. And you know he told the truth about what happened to Shavon Randle and Mike Titus because it's corroborated by all of the evidence. The fact of the matter is the state did prove beyond a reasonable doubt that Mike Titus murdered Shavon Randle. The state did prove beyond a reasonable doubt that Mr. Wilkerson murdered Mr. Titus. And you also learned why all of that happened. This was a business, and they did have a method of inventory control. That's what it is, because that's how they look at it. It's just a business. And when we lose $250,000 worth of inventory, we can't call the police. We have to either write it off or get it back using self-help. They chose the latter method. You know Mr. Jones is telling the truth because everything in these statements that I'm telling you is there. That you know that the decision was made by Fields and Owens to recover the marijuana by first looking for Kendall Perkins. When they couldn't find him, kidnapping his girlfriend, believing that if they got his significant other, the mother of his children, the woman whom he lived with, that he would give their inventory back. We know when that didn't work out because Mr. Jones told us how it happened. We know there was an opportunity displayed to these evil people. And Mr. Wilkerson and Mr. Titus were instructed, directed by Mr. Owens from the car at the end of the street to take Miss Randle. And so they did. I want to point out one thing, going back to before the robbery itself. As you read these transcripts, which you now have all of them, you will find in the transcripts that this picture right here, because there is a whole lot of evidence, but I found it last night. And you can find it in there because you have access to all 5 of these transcripts. And they really don't take that long to read. And it really becomes faster reading as you go because Desmond Jones is starting to explain more and more and more about what happened and why it happened and how it happened. And you'll find toward the beginning, maybe it's not toward the beginning, but in one of them, one of the agents, or it could have been Detective Rohack, asked him, well, what about this picture? And you'll read in the transcript that Mr. Jones explained this picture. This guy's 20 years old. And his 21 or 22-year-old buddy, Mike Titus, calls him up, gets a hold of him somehow, however they communicate, and says, look, I'm sitting on 100 pounds of very expensive marijuana over here in this motel room. You should come and take a look. And Desmond tells him, you can't resist that. It's in the transcript. So he goes over there. That's when you see the picture of Titus. And that's when Desmond Jones had this picture taken of him in the money. And he put it on Facebook. And when he put this picture right here on Facebook, guess who saw it? Fields and Owens and Wilkerson. And they immediately suspected Mr. Jones, whom they just met a week ago, according to Ms. Falk in her opening statement. A week ago. This 20-year-old kid they were introduced to a week ago, they see this picture on Facebook, and they figured that he's working with Titus. And so Mr. Jones becomes the suspect, along with Mr. Titus. That's what happened. That's the truth. This is probably a multi-million-dollar operation, this drug conspiracy. These people, Fields and Titus, they go to Los Angeles to get huge amounts or buy it, huge amounts of marijuana or order it, however they do it, in their distribution pipeline, and they have it brought back to Dallas. They're not going to let some 20-year-old kid they met a week ago in on that. And in fact, you will see in the transcripts that when Mr. Jones went over to the motel room, he got all excited too. And he said to Mr. Titus, "Hey, let me in on this." And Mr. Titus said, "No, my people don't know you. It's in here. They don't trust you. And they certainly don't trust him after they see this picture." So what happens next? It's all in here. The truth about what the drug conspiracy looks like and what it does when all that kind of inventory is stolen. That's up to $250,000 worth of marijuana. What are they going to do? Well, they start to investigate and they ascertain that Kendall Perkins was part of it. They believe Titus did something because he was in touch with Kendall Perkins. And so they connect Titus to Kendall Perkins because these guys stab each other in the back. They play cops and robbers. I steal mine and sell. I steal yours and sell it. You steal mine and sell it. That's what they're doing out there right now, you guys. That is what they do. So they suspect Titus because he is the one, for some reason, they didn't have a buyer for all that. So Titus calls Perkins and Perkins says, "Sure." Titus magically absents himself from the motel room when the robbery takes place. So of course they suspect him and they blame him for it. And they suspect Mr. Jones because he knows Mr. Titus. So they are immediately put under the thumb of Fields and Owens and Wilkerson. Titus and Mr. Jones. They're not riding around together because they're all cooperating as in furtherance of the drug operation, looking for Mr. Perkins. What they're doing with Mr. Jones and Mr. Titus, and certainly Mr. Jones, is he has to be there. We're not letting him out of our sight. So right there you begin to see the real reason that Mr. Jones acted the way he did. And as you go through these, you will see why he was doing that, why he was where he was, because they wouldn't let him out of the sight. They made him sit in the back seat of the car while they were going around investigating how to find Perkins and then how to find Shavon Randle. Mr. Jones was acting not in furtherance of the drug conspiracy. He was in the car in the back seat because he was compelled to be back there, because they weren't going to let him out of their sight. So then you will see in here when they went to Spectrum to look for Ladoris, because that's where she worked. Owens and Fields and Wilkerson determined through their investigation that they could find Ladoris there, so that's where they went. And Mr. Jones was in the car because that's where Mr. Jones had to be. And when he saw Miss Perkins come out and to go home, Mr. Jones saw her, but he didn't tell the others. He sat quiet. That's the truth. And you know, this business about the lookout, this business about at the time of the kidnapping that Mr. Owens and Mr. Fields were up the street being a lookout. Lookout for what? What are they going to do if someone peeks through their curtains and calls the police? What are they going to do if the police come up the street? Are they going to tell them to get out of there right quick? They're in that house putting a bag over Miss Randle's head and marching her out the front door in broad daylight. That's how brazen they are, and you know that's how they are. You need a lookout. Tell you what Mr. Owens was looking out for. He was looking out to make sure that nothing else went wrong. Titus is already on the hook. And he already knows he's dead too, doesn't he? Because right around then is when he gets that message out to his girlfriend, if I turn up dead in 3 days, it's Darius Fields who did it. How come Darius Fields isn't charged with murder of Mike Titus? Because Mike Titus doesn't matter.
Judge, I object. That's improper argument and also a misstatement.
Sustained.
There's no murder indictment for Mr. Fields anywhere on this earth for these people. Not now, not ever. And so, then what happens that you know is the truth? Because Mr. Jones tells you. And as the process goes on, the agents begin to believe him more and more. Read these. That doesn't take that long. This is all the evidence that you need to decide this case. Read these transcripts and discuss them. They begin to believe him because he's becoming more forthcoming. Remember, he was cooperative, but not forthcoming. And he gradually began telling more and more as he began to feel more and more safe because the agents promised him protection. It's in here. Putting him in a protection program is in one of these statements. They were going to help him because they didn't want anything to happen to him either. So you know what Desmond Jones is telling us all and telling the prosecutors and the agents is the truth because they acted on what he said. Their entire case is built around these statements. He told the truth about Fields and Owens and Wilkerson and Titus and their activities. He told the truth in these statements that he didn't even know these guys really. He told the truth in these statements. They wouldn't let me in on it. They don't trust me. He told the truth in the statements when he said, they made me get in the car. They made me drive around. I couldn't go anywhere. It's in the statements. They would have popped me, meaning they would have shot me. They wouldn't let me talk. If you say anything, you're going to get hurt. That's in here too. And they made him and Titus sleep in the car. The night they made him and Titus sleep in the car, Owens and Wilkerson went into Owens' house to go to sleep. That's after they were conducting surveillance on Ladoris Randle's whereabouts. And they went home around 1 a.m. They made these two guys sleep in the car. Well, why didn't you just get out of the car and run? They would have got us. We slept in the car because they would have killed us. And you know it's true because they killed Titus. We know it's true what happened inside the house because the physical evidence shows that Mr. Jones was telling the truth about how Miss Randle died and Mr. Titus died. Why, they asked, didn't you run away when you were standing at that doorway? His footprints aren't inside that house. His DNA is not inside that house. He described truthfully how Miss Randle was bound and how it was untied now. And everything in the room was described. He described where the gun was that Mr. Titus was shot with, how these evil people tried to make it look like a suicide because he was hearing what they were saying. But Mr. Jones is standing at the door. Why didn't he run off? It's in the statements. He explains why. It's in the July 7th, the second one. I froze. I was too scared. There was nothing I could do. I knew I was going to be next. But instead, what happened? He was so afraid that he couldn't even move. Now let's go back and talk about the car. Did Mr. Jones voluntarily loan his girlfriend's car to the drug conspiracy to kidnap Ladoris and later Shavon? Was that act in furtherance of his membership in the conspiracy? No. We're using your car. They don't want their cars to be identified. They don't want to take the time to go steal one so it won't be identified as being involved in the kidnapping. We're going to use yours. And so they did. And then when it was over, the kidnapping was complete. Miss Bell has to get her car back. This is getting out of hand. You heard from the witness stand, so the phone call was made. And the car's taken back. And when the car's taken back, you have another piece of corroboration about Mr. Jones being compelled under the threat of death. It's in here. Puda, you heard the name all week. Miss Falk and I together in cooperation with one another tried to find Puda because we both wanted to have her sit on the witness stand. I wanted to ask her about what was in here. What did Mr. Owens say when Puda asked her, hey, where's Mr. Titus? Oh, he's nearby. You could probably hear him. And by the way, they're not coming back, meaning Mr. Jones or anybody else, until I get my marijuana back. And Mr. Jones had to get back in the car. He was compelled to loan the car. He was compelled to be there because they weren't going to let him out of their sight. And so what happens? Why did they finally let him go? Mainly because criminals are always stupid, no matter how clever they are. If they were smart, they would have killed him too, but they're not. They figured when they had him running around all week with them, they came to learn that he had not been involved in the robbery. Owens made that determination, and Wilkerson. And as Mr. Jones put it, they, quote, faded back after that. Meaning they decided not to kill him. They decided not to kill him because he was not involved in their robbery. And then they let him go. If he was a member of this criminal conspiracy, why would they let him go? Why wouldn't they just all go back together and then disperse to go home? They released him. They released him in the middle of the night. And he was knocking on Kiana's door and she didn't answer. She called his mother, Sonia, instead, who came and picked him up. And he was quiet for a long time. But he finally told his mother what happened because he wasn't acting right. Wasn't acting like himself. And when he told her, they called the police. And the police came. And they talked for hours with Agent Mahan, and he led them to the bodies. The first person that he could tell, that he felt safe enough to tell, he told his mom. In one of these statements, you should read all of them. I think it might have been Agent Mayhem, or it could have been Detective Rohack, asked Mr. Jones, do you need anything? He said, I need my mama. Mr. Jones did not act, was not a member of the conspiracy. And so the actions he took, which are all explained in here, are because he was compelled to do so under an ongoing threat of death. The same one that Mr. Titus was undergoing all throughout that week. Now I'd like to talk to you a little bit before I sit down about the jury charge. at the very beginning of it, it tells you that you must or may consider these instructions as a whole. What that instruction is telling you is that you don't have to start in any particular place. You can start with kidnapping, you can start with murder, you can start with organized crime. You don't have to consider them in the order they're presented in here. You can deliberate on one thing if you want, whatever it is, and reach a verdict on that if you choose. One thing I want you to remember, though, is that duress applies to all of them. It cuts across everything. Now, reasonable doubt's not defined. Each of you can have an individual definition. I suggest to you that when you're considering the crimes that are in this instruction, that each of you talk about what reasonable doubt means to you and see if you all can agree on a definition that all 12 of you can live by. Because you've got to analyze their evidence to a standard, and so you have to establish it. One of you may have one that's different from 11. 6 may agree on one, 6 may not. There could be 12 different ones. I suggest to you that no matter how many different definitions you agree upon, that every time you decide a fact, that when you discuss it, let's say you're talking about a particular fact, please remind the other members of the jury what your definition of reasonable doubt is and how you're applying that fact to that definition to explain how you got there. Otherwise, this can entirely break down. So discuss what reasonable doubt is, try to reach an agreement on how to do it, and if you don't, each of you discuss everything you are doing and remind each other constantly of your definition of reasonable doubt. That is the only way to proceed, and you all promised you would give Desmond Jones a fair trial, that you could and that you would. You looked right in his eyes. That has to be part of this process. Now, the affirmative defense of duress has been in the law forever, way before we were a country. Common law in England, it's an ancient doctrine. It has always been excused conduct that would be criminal if it was done under compulsion of imminent threat of death or serious bodily injury. And it's been a long, long time that the rule has been that the defendant bears the burden of persuasion on that. In these statements is the affirmative defense of duress. In order to acquit Desmond Jones on duress, you must find by preponderance of the evidence that these statements have shown that it exists, along with the corroboration of Ms. Bell and Puda, which is also in these statements. That means that it's just a little bit more likely than not that Mr. Jones was acting under duress, and whatever you find that he did that might indicate to you that he was acting as a party. If you reach an agreement that, yeah, it's a little bit more likely than not that he was under duress, and you find him not guilty of everything, as you promised him you would when you said that you would give him a fair trial. Now, the last thing I want to say about this is that you do have Fields and you do have Owens and you do have Wilkerson awaiting trial. They can be convicted.
Judge, I'm going to object that this is improper argument.
Mr. Jones, the elected district attorney, Mr. Crozeau, has the power to cause Mr. Jones to testify
Judge,
against.
I object again, this is improper argument.
It doesn't have to be over. It doesn't have to be over for those three. And Desmond Jones can help. I appreciate your attention, and I expect, as Mr. Jones does, that you will consider the evidence, and especially these statements. Every time I read them, and I must have read them 100 times by now, maybe more, I seem to find something new They do all connect together, and they tell the story from the beginning to the end. The existence of the conspiracy, who the members are, and why Mr. Jones acted the way he did. You should find Mr. Jones not guilty. Thank you.
May I proceed? Your Honor?
Yes, ma'am.
Mr. Jones has done absolutely nothing but help himself for almost 3 years. When Mr. Fishburne tried to tell you that there aren't indictments for murder, that is not true. There is an indictment for engaging in organized criminal activity, for the kidnapping of Shavon Randle, for the murder of Shavon Randle, for the murder of Mike Titus on, guess what? Laquan Wilkerson, he's next. Devontae Owens, he's next. And then Darius Fields. And we will try every single one of them. Because Mr. Jones has done nothing but lie to every member in this audience, but lie to every member of this jury, but lie to every person he talks to. And I can't wait until I show you how. We talked a week ago on Monday about how this was a puzzle, right? So we're gonna have puzzles on Laquan. We're gonna have puzzles on Darius. We're gonna have puzzles on Devontae. We keep talking about them because it's how we prove they're a crew. It's how we prove that they're a combination. It's how we prove they're a clique. But I am done talking about them, and today we talk about Desmond Jones. The first thing we need to know is what happened. On Sunday, June 25th, guess who's there with all that money? I did a quick count after we looked at this lead picture. I count, those are all 20s. They are all fresh, crisp 20s. It ain't Monopoly money. It ain't dollar bills tucked in there. It is thousands of dollars that Mr. Jones is flashing. You know why? Because he benefits from the proceeds. He gets the profit. He's part of the combination. And it may be that he gets tied in through Mike T originally, because that's his boy. But by June 25th, he has become part of this crew, part of this combination, part of this clique. He is in the Motel 6 room where all of that weed is. He is in the Motel 6 room where LaPortia Polly is. He is in the Motel 6 room where the guns are kept and the drugs are kept. Weed, money, guns. We move then to Monday, June 26th. We have spent so much time going through everything that happened that I want to move past this. Because what's important about the robbery, we all know LaPortia got robbed. We all know that Mike T either set it up or made a rookie move by leaving with Laquan and leaving that dope basically unsecured. He may have been in on the robbery with KP, or he may have just made a mistake. And it was a costly mistake. And it may have cost Mike T his life, but it cost every one of them the life of Shavon Randle. What's important about the robbery that we learned yesterday is that KP immediately, literally by 8:45, the crew knows who has their dope, because KP starts getting calls from Fields, Titus, and Owens right away. So the crew, who Mr. Jones is a part of, starts figuring out, what are we gonna do, right? This isn't like if I lose a pen at my office. This is a big deal. And not only do they want to get their money back, but they need to guarantee that they never get robbed again. Because if they show weakness in the street, guess who's getting hit every time they get a delivery? That crew. And Darius Fields, Devontae Owens, Laquan Wilkerson, Mike Titus, and Desmond Jones need to send a message and fix that mistake. So Tuesday, June 27th, they start planning. Mr. Jones, in his own car, goes to the meetup. We know that they're all there at Village Fair because we have phones, right? Because we have video, right? And because we have them all in their own cars. So this whole I was forced to do it, you could have driven away. You could have called the police. You could have told anyone, because I guarantee you that everyone in our entire county, other than these 4 evil people, would have jumped in and done whatever they could have done to make it right. Just like we have done all day, every day this week. Just like we have done for the past 3 years. To bring you the pieces of the puzzle. So Jones drives up in his own car to meet up for them to start talking in person, because phones have wiretaps. Phones document things so they can decide what's our next move. KP's gone. He's left East Texas. He has booked it like the wuss he is, right? He's not going to own up on his mistake. He's going to let somebody else take the fall for it. He's going to let somebody else get kidnapped for it, including his girlfriend, the mother of his 3 children, either her or her family members. And he knows the rules of this game. He knows how baseball is played. It is overstood what happens when you rob from the wrong people. You heard from Ladoris, that is all he does. She benefits from it, right? I mean, she sat there just as straight as can be, being like, well, I mean, he robs people. Who do you think pays for her shoes? Who do you think pays for her car? Who do you think pays for her purses? All the people who get robbed by KP, right? So this planning meeting occurs at Village Fair, and then we get forward to the surveillance. We have all of the phones, Mr. Jones's phone, and we're going to talk about that here in a second, but y'all, we know it's his phone. We know it's his phone. They are all doing surveillance over at Ladoris's job late at night. She does not work nights, so let's think about that for a second. They're doing surveillance from 10:30 to 11:20. Those 4 are there, and then there's multiple calls back and forth. And the reason we keep highlighting that there's calls in between them is to show you that they're not all in one car, right? So if I'm Darius Fields, I'm not in the car with all the other people holding Desmond Jones at gunpoint. Desmond is driving his own car to be part of this crew, trying to do whatever he can to make sure that he's okay, but also whatever he can to stay part of this crew, because that is a lot of money. And if he can maintain this, he is on the hook to make a lot more money in the future. They don't, in this lifestyle, finish this activity and then say, you know, I'm gonna go apply for a job at Starbucks. I'm gonna go get my associate's degree. They choose the street life, and that is exactly why duress is written the way Mr. Adams told you, the way that the judge told you, the way that that law reads. Duress is for you and I. It is not for people who sign up for this life. He doesn't get to say like, well, I want all the money and the guns, and I watched everybody's eye, every lady especially, their eye pick up how he views women and what they're good for in that statement, right? Just returning a trick on. Those are all the perks of the lifestyle that he signed up for, and what that means is he now can't claim, I wasn't really part of it, but if I was, it's because I was forced, I had to be there. No. His own car, his own phone, is doing surveillance at Spectrum, and then they move down to south of Dallas in Lancaster. They go to the victim's house thinking that Ladoris is there because it's her mom's house. Fields calls KP again during this time. All 3 phones are down there. Mr. Jones is all up in it. He is all up in it Monday. He is all up in it Tuesday, Wednesday, Thursday, Friday, Saturday. So Wednesday is when the kidnapping happens. This is all that Agent Sedgwick testified to yesterday. Jones's phone is there, Owen's phone is there, Wilkerson's phone is there. They are all at that house where Shavon is kidnapped from. And then immediately after, her phone has activity and her phone is with them. They're all going up 35, and you know where they're going. They're going to a trap house off of Keast. It may have been the final trap house. It may have been the first one. He does nothing but lie, so we'll never know. But we know that they all head up 35, and Fields is calling all the shots from Ovilla. Look at the times, 9:51 to 9:58. They're coming up 35. Not 1 hour later, Fields has now joined them. Of course, he's got 2 phones, and all of them are where the bodies were recovered. All of their phones. Mr. Jones, his phone, his body, his person is there where they have a 13-year-old little girl. A 13-year-old little girl with her hands bound by a blue internet cord, with a brown pillowcase over her face, with her Star Wars fuzzy pajama pants on. Because she was on summer break. Because she was getting excited about her 13th birthday party. So all of our people in this crew are there right after she's kidnapped. And then we fast forward. We will never have all of the pieces, because the people who hold the pieces to this case are either dead or their defendants. So Saturday, July 1st, and Mr. Fishburne just said that Desmond called the police. That is 1,000% not only inaccurate, but a lie. That is not true. You heard from Special Agent Mahan, who said, I had to go find it. I found Puda, that we figured out where he was, and we went to where he was, which was with his godmother, some tea lady, Sonia Williams, some lady who acts as his godmother, not a godmother like you and I have, just some lady who's taken him in that day. She doesn't help him end it tonight. She doesn't say, oh my gosh, what have you done? It's all over the news. Everyone is praying that we will find Shavon. Many are praying that we will find Mike Titus. He does not call and report it himself. Mahan goes and finds him. And he doesn't volunteer and say, come on, let's go. I gotta do the right thing. I haven't been able to sleep in days. I can't live with myself. I'm disgusted. I feel so bad. Nope. Mahan begs and pleads for 3.5 hours. Let's end this tonight. Desmond, come on, man, let's end this tonight. Mahan knows in his heart of hearts what he's trying to end is finding the body of a little girl. Not a live body, but a dead body. Because we all know that after that Amber Alert goes out, and as the hours tick past, as the days tick past, we are never getting Shavon back. And I pray that the family had the hope that they would still find her, but everyone in the suits in the front knew it wasn't going to happen. And you know who else knew? Desmond Jones. So after 3.5 hours of begging by Special Agent Mahan, by begging of Special Agent Crystal Offray, by begging of Officer Beecham from Lancaster PD, of the godmother lady, of the random man that was there, finally he says, all right, let's go. And this is what he takes them to. Now that we know what happened, let's walk through the pieces that show us how. I cannot thank you all enough, and the court and opposing counsel, for how much work has been put in this week. I can tell you that in any other court, this trial would have taken much longer, because you have had so much information come at you, and it has been as smooth as possible, but it is still a bunch of almost a foreign language sometimes. So I'm going to take everything we talked about on Wednesday and some of yesterday and put it in plain English, right? We went through all of that DNA evidence because we have to do a thorough investigation. If we left one stone unturned, that could be the one stone that would provide you a puzzle piece that would be important to you. Some of you may have been sitting here on Monday at like 1 o'clock thinking he's guilty. But my job is to put on every single piece I have, because you deserve it. This is a hard decision, and I understand that, but it is my job to make it easy for you. So the cell phones are our first real multiple pieces of evidence, and we're only talking about Desmond's phone. The defense was trying to say that he didn't have, so you'll have all the numbers, but the 9766 number, that Kiki didn't know that number. No. Back in July of 2017, Kiki pulled out her phone. She read out the phone number to the agent. That was that piece of paper that he had scribbled the phone number on. She may not remember it now, 2.5 years later, and you know what? If I had been dating him, I would want to forget everything too. If my name, if my face was wrapped up in all this for the past 2.5 years, I would want to forget too. But once she was shown the piece of paper, she remembered that Desmond Jones had a 318 number that ended in 9766. The defense wants to talk about how that number, the birth date of it, came back to a residence over at T.D. Owens Barbecue, which of course is Devontae Owens' family. Devontae and Darius are cousins, is all their family business, all right? Devontae gave Desmond the phone. Desmond said it himself. This is not an aha. This is not a gotcha. That shows you it was before the kidnapping, because Kiki already had the phone number, right? She's calling it when he borrows her car back on Monday, Tuesday. So he had already become friendly with Devontae. Friendly enough, and part of the crew enough to where Devontae was like, hey man, I got you, here's a phone. That's how Kiki has that phone number before 6/27. Desmond says Devontae gave him a phone. This is not some gotcha. Kiki says that it was Desmond's phone, which means that Devontae gave him that phone before 6:27. It cannot be that he got the phone number afterwards because Kiki gave us the number in advance, all right? So definitely his phone, we're done with that. Here's what the cell phone activity means. They are all in different cars because if Crystal and I are riding together to dinner, we don't talk to each other on the phone, right? If we're driving separate cars and I'm getting lost trying to go to where we're going, then I'm calling her, right? So that's what it tells us. And it shows us that they are in different cars because no one calls each other, both during the surveillance on Tuesday and the kidnapping on Wednesday morning. Here are all the phones going north on 35. You can see that they are calling each other up at the top. They are in multiple cars. Desmond has his own car. All he has to do is peel off and do the right thing. Desmond Jones had 1, 2, 3, 4, 5, 6 days, just like he had 6 statements, to do the right thing. And he didn't, and he won't, and he never will. The DNA, the Star Wars fuzzy pajama pants, the DNA was a lot because we have to uncover every stone. But what the DNA told us is that those sweet little pajama pants, I won't reshow the photo, we all know what Shavon was found wearing. These were her pants. This is her DNA. This necktie was used to bind her. It was. And Laquan Wilkerson's DNA is all over it. And her DNA is all over it. Like, they couldn't just tell a 13-year-old to sit there. She's terrified. She has been drug out of her home. She has been bound, and they continue to have her bound. That is terrifying. And here's the second binding. And I want you to look specifically at what it is. It's a little t-shirt that they have taken off and they have wrapped around. And based off the size of it, they probably put it over her eyes as a blindfold. That is her blood all over it. And I am sorry that all of you have to look at this, and I am livid that that man has put me in a position to do it. But he has, because he is in this. Now the other DNA, it shows us that Desmond Jones was all up in that white Ford and Laquan Wilkerson was all up in that black Lexus. And I can guarantee you, because I've tried a lot of cases, that if I didn't have that DNA, they'd be trying to say he was never in that white car. If I didn't have that officer from Midlothian who gave him a traffic ticket, just serendipitously the day before, they'd be trying to say he wasn't in that white car, because that white car is a big deal. Now the footprint. There is like a principle out there called Occam's razor, all right, which is fancy pants for what is the most obvious and makes the most sense, makes the most sense, all right? This is not an Air Jordan 11 that everybody on the street has. This is a Nike Lunar Force duck boot. What you heard is that the only person in this group wearing a Nike Lunar Force duck boot was Desmond Jones. And this is important because, again, we'll walk through the statements here in a minute, but it shows what a liar he is. Because in the black Lexus, so now he's in another car, right? So like he's got his own car, he could leave at any time, but now he's buddying up in another car. He's in Laquan's black Lexus with bleach all over his foot, and we know where the bleach came from. It came from the cleanup attempt of the body of Shavon Randle, not of Mike Titus, of Shavon. They douse her in bleach so that they don't leave DNA behind. And it worked pretty well because we don't have DNA. He, Desmond Jones, in his Nike Lunar Force duck boot sneakers, walks right through the bleach, right over to the black Lexus, sits down in the front passenger side, and leaves a mark right there. The expert testified that they could be a match. Not that they weren't, not that they're eliminated, probably not, but they could be a match. Does it make more sense that some other unknown person was in that home with the bleach and then got in Laquan's car wearing the exact same Nike Lunar Force duck boot sneakers? What is most obvious is what it is. These are his. That's his footprint. He was all up in the bleach. He was right there with the bodies. He is helping in the cleanup because he is part of the crew. Now the firearms, plain English, the only thing that we needed to take away from April Kendrick, other than everyone has scary guns, is this .40 caliber Bersa. So the gun that was found in Mike T's hand, you know, after he's shot himself twice in the back of the head, the gun that's in his hand matches the bullets from Shavon. It matches all of the firearms evidence in the house, and it matches the bullets that went through Mike T. This is the murder weapon. This is the murder weapon of Shavon Randle. It is the murder weapon of Mike Titus. They want to put it in his hands, but we know that he didn't murder himself. And I'm going to argue to you here in a minute how we know he didn't murder Shavon Randle either. The gunshot residue. You heard from David Spence, who told you that when a gun is fired, it releases these invisible little particles. You wouldn't see them to know to believe them. And guess who had that gunshot residue on him? Desmond Jones, who says he's never anywhere near any shooting. Yet he has gunshot residue inside his waistband. You know, where you tuck a gun. On the top back of his shorts, and on the back of his black tank top that he's wearing. The white car, there is no dispute that it is his girlfriend's. We have his DNA, and there's a traffic ticket of him in it. And if we didn't have those three things, you absolutely would have heard that it wasn't his car, he had nothing to do with it. That's why we keep hammering this home. That's why we keep giving you all these pieces of the puzzle over and over and over again. Corey Green. Corey was important to me because he's, one, just a good guy, right? I don't know what he was doing hanging out with Desmond Jones. They said that they kind of grew up together and they've known each other a long time through his sister, Huda, who is such a peach that she came here to help him, right? They have subpoena power too. They can get and call any witness they want, but we didn't hear from Huda. So Corey Green testifies that on Tuesday, it's like any other Tuesday. Corey gets a haircut every Tuesday, and guess who drives him to it? Desmond Jones. Desmond is not with the rest of the crew at gunpoint being forced to do all these evil things. Desmond is doing what Desmond does on a Tuesday, hanging out with his friend, taking Corey for a ride to get a haircut, and then leaving him there, right? You know what a good person would have done? A person of reasonable firmness would have done? He would have said, man, I'm up in it. I don't know what to do. I need help. I think someone's about to get kidnapped. I think not another drug dealer or robber. A woman is about to get kidnapped. Because at this point, Ladoris is the target. By Tuesday morning, afternoon, Ladoris is the target because KP has booked it. Also a peach, right? Desmond doesn't do any of that because he's all in. He's going to get money out of this. He's going to get street cred out of this, and he's going to get a job out of this. His statements. I get so riled up when I listen to his statements, and that's why we started with the end, because all he does is lie. And you don't know that he's lying until the very end. You don't know that he's lying until you weed and wade through all of the physical evidence, all the scientific evidence, what everyone else says, what the cell phones show us can't be the truth. So let's start with his statements. On July 1st, going into the 2nd, he does the, Mike T had the white car the whole time, and if we didn't have his DNA, if we didn't have Kiki, if we didn't have the traffic ticket, that would still be his defense, I can guarantee you. So he goes with Mike T had the white car the whole time. I don't know those other people. I may have heard Devontae's name like a week before, but I don't know any of them. I'm not scared of anyone. I'm not scared to die, and I can stand my own ground. That is a quote out of that statement. He ain't afraid. Then July 3rd, the first half, he sticks with, well, Mike T had the car. And after 3.5 hours, they finally get him to change a little bit, but he denies, and he is adamant. Man, I had nothing to do with that kidnapping. I denied any part of that kidnapping. And his only concern, y'all, is not about this little girl. It's not about Mike T's family. It's not about our entire community grieving. He doesn't want to be a snitch. That's what he cares about. Because the rules of the game that he plays, the only rule, really, is not snitching. That's all he cares about. So this is the line that I want everyone to remember, and I put it there, page 55, but this is obviously from my transcript. You can go back and triple check my work. In this statement, he's talking about how he was trying to convince Mike T, like, how to get out of it. Like, bitch, lie on the stand, bro. You were forced. You were forced. So just lie. Just say you were forced. And guess what Mr. Jones has done here? He thinks that each and every one of you are a fool and are dumb enough to fall for it. He thinks that he can say, I signed up for this game, and then I'll just lie. I'll lie to the cops, I'll lie on the stand, we'll just say we were forced, and we'll be okay. And that is the moment when I knew definitively that I could never trust anything Desmond Jones said. In statement number 4 on July 6th, it's more lies, it's more minimizing, and it's more self-serving stories. They're not statements, they're stories. His next statement, more lies, more minimizing, more self-serving stories. Not statements, just stories. And then it takes us to our final statement, and this was the one that turned it. This is the one because he finally told a little bit more. I wouldn't say the truth, but a little bit more. And he finally makes himself go from witness to suspect, from that chair to that chair. We can quibble over the word looking out all we want. 2 pages before he says Devontae is the lookout, he says I was watching during the kidnapping. That's looking out.
I'm so sorry.
That's looking out. Watching to see if anything happens. And here's how we know that he is an additional lookout, not in the same car with Devontae. Special Agent Sedgwick talked yesterday about criminals keeping an open line, right? So if I see the 5-0 coming down the street, I can say, hey, get out. Or, in this situation, stay. Don't open the door. Because if a 5-0 comes rolling down the street and I'm walking a little girl out with a pillowcase over her head, it's certainly going to pique their interest. So they keep an open line. Devontae Owens has a 700-second long call with Wilkerson. And during that call, because you can look, it's 9:31, so 12 minutes later, that call would have ended at 9:43, but in the middle, somebody beeps in. Desmond Jones. Because he's watching from a very close by location, but not the same car, along with Devontae. He is actively participating in the most despicable way because he is an evil person. He is evil just like Darius Fields. He is evil just like Laquan Wilkerson, and he is evil just like Devontae Owens. So he acts as the lookout, watching. He says during the surveillance, the day before, he says, and that's why I made y'all kind of like perk up a little bit when I said it was at nighttime when LaDoris doesn't even work. He is trying to make himself look good. He's trying to make himself look not evil. He's telling the cops all these self-serving lies, and he says, not only was I not really involved, and this is all that they did, but I saw LaDoris come out of the spectrum, and I basically saved her life because I didn't point her out. He gets no medal because that is a lie. She was at home, said her phone was having activity at home. She didn't work that shift. She wasn't there that night. Lie, lie, lie. And then that gets us to the murders. He wanted to paint you a picture, to sell you this story about how these murders happened. I want you to think about it, okay? So if I am the head of the crew, and Mike T has done one of 2 things. He's either been dumb enough for me to lose $250,000 worth of high-grade marijuana, and he's put my girl's life in danger because she got guns pulled on her. Or worse, he set it up. What do you think that I do at that point? You think that I trust Mike T? You think that I let him have a cell phone? You think that I let him have a gun? You think that I let him have what is maybe one of the most offensive things I've heard, but an inventory control method? A little girl? No. No. Mike T doesn't get a gun. If he's really that desperate, if he's messed up that bad and he knows he's messed up that bad, he's just gonna shoot me, right? If I give him a phone, he's just gonna call somebody. If I give him the girl, he's gonna mess that up too. So what do you think is more likely? What do you think is more probable? What do you think happened is exactly what happened. They all go kidnap Shavon Randle on Wednesday, June 28th. That Amber Alert goes out Wednesday afternoon, and the crew realizes that they are in it. That this isn't just going to be a side exchange over at a 7-Eleven where they get their dope back or their money back and they work out some deal. The laws have been called, and it's all over the news. And at this point, and when you dig through the photos from Best Western, somebody pops up on that cell phone saying, just get back the girl, just get back the girl, just get back the girl. Y'all, she's dead at this point. Because on Wednesday, June 28th, she gets kidnapped, and then the Amber Alert goes out, and they all know that they're in it. Mike T, I really don't think he kills her. You know why? Because he wouldn't have had the gun, and he definitely wouldn't have been left alone with the girl. There's just no way. So you know what is more likely? They all went in that room at 2208 East Keast, at Keast in Sunnyvale, 1 block behind Skylark. That disgusting trap house that Shavon Randle got to spend her last minutes and got to take her last breaths in. And they shoot her. And then they have Mike, and probably Chuck, because he's the muscle and a hit or two, pick up her body and shove it into that closet, into that bathroom. They strip off her clothes so they can pour her down with bleach to try to get rid of any evidence. And then they go back and have Mike T start cleaning it up, and that's how they then execute him. The glove that he's wearing has her blood because she had just been shot and was bleeding, and his blood because he was also shot and is bleeding into that pool. And I want each of you to think about it. How many times was Shavon Randle shot? How many suspects do we have left? 4. Laquan Wilkerson, Devontae Owens, Darius Fields, and Desmond Jones. If he was a weak link like Mike Titus, there would have been 3 shots on Shavon Randle, and he would have been killed too. But instead, we have 4 suspects left. We have 4 shots into a 13-year-old little girl's body, 3 into her head, 1 into her stomach, and then she is treated like trash and just dumped into the other room after she's stripped. That is what makes the most sense. And let me be very clear about the message that it sends to the community, to their dirtbag, evil, drug-dealing, robbing, murdering community that they live in. When there are 4 shots and 4 suspects, 1, it means no one can snitch, and 2, it tells everyone else, you don't steal from our crew. From the crew that Desmond Jones has now forever cemented himself as a part of, because he has been all in it for each and every one of these days. I told you on Monday that this was, through the course of the investigation and the week that this happens, thousands of puzzle pieces are coming in through that tip line, through that email tip line. And half of the puzzle pieces don't even belong in this puzzle, so we've had to weed through all of them. We've had meeting after meeting, hour after hour, phone call after phone call, early mornings, late nights, to present to you the puzzle pieces together. Because on June 28th of 2017, we went from a missing little girl, a 13-year-old, who the night or 2 before had gotten to have a hotel party, because they have a pool at the hotel, who had turned 13 6 days before, whose family loved and loves her, went from a missing girl to a murdered girl. And each of you has the final puzzle piece. You do. The final puzzle piece is finding him guilty of doing what we all know he did, joining this crew, signing up for it, and doing what is the worst of the worst. There are rules on the street when you deal and you steal. And one of the rules is that if I steal from you, I owe you, not my kids. This is a different type of evil. This is a different type of puzzle. And you hold the final different type of puzzle piece. It is on each of you to end this today.
Members of the jury, we stand in recess until you've reached a unanimous verdict.
All rise.
Let me see the lawyers. Please, go ahead and take them back to the jury room and they'll tell you what to do.
So don't get on it.
Members of the jury, everybody leave your jury charges in the seats. We're just going to have the one jury charge that is the official jury charge, and I'm going to ask the alternates to go back to the jury room with the jury, please.
Yes.
The gallery may be seated. Court's in recess.
Wow, folks, that was a really powerful closing argument by lead prosecutor Jennifer Falk. I thought this puzzle that they've shown this puzzle throughout the trial, but asking the jurors, telling the jurors, you can put the final pieces in this puzzle. What did you think of that, Justin?
Oh, to put an argument in a very tight visual representation, I think that's something that speaks well to a lot of jurors, especially since the case is so complex. I mean, this is a circumstantial evidence case, so I think it's better to look at it from the standpoint of we're piecing together the pieces of a puzzle, and once you get through the entire argument that you're presenting, you say, this is the last piece, this is how we can put it into all of this, and this is how you apply it.
Right.
So
she actually said that basically this is the final puzzle piece. The final puzzle piece is finding him guilty of what we all know he did.
Right. I think Jen Falk is a brilliant prosecutor, and the fact that she put that together for this particular case shows how adroit she is at understanding how complex a case can be, but also reading the jurors in a panel. So I think she did an awesome job. Bang up.
Well, what we're going to do here is there's a lot talked about in these closing statements, but I want to back up to the jury charge. So the first thing that the judge did was read this jury charge. Essentially, the jury can find him guilty or not guilty of engaging in organized crime, or they could do one or both lesser included offenses of murder and aggravated kidnapping. And explain, because we had to look up in the penal code to make sure we understood what the difference is. What is the difference here if they find him guilty of engaging versus the other lesser includeds?
Right. I mean, I think it's important to note that the engaging provides an enhancement to the other two charges. So if they find that the criminal activity was either the murder or the kidnapping, which they probably will, because, I mean, there's physical evidence of both, the enhancement, the gang enhancement, provides an extra added minimum of 15 years as opposed to being only 5 years for the underlying offenses. So if he gets convicted of the engaging in criminal activity, he's going to be facing at least 15 years of prison time.
At minimum, right?
At minimum.
So
as opposed to 5.
Right. So and so that's where the enhancement comes in, because we had to suddenly, at least I had to suddenly look up the penal code to make sure I understood what the difference was when you talk about a lesser included, because they're all first degree felonies. All
first degree felonies, and it's important, especially when you saw the defense's closing argument. They tried to deconstruct this notion that Desmond Jones was a part of this gang. And the prosecution is honing in on this notion that he actively participated in not only the gang activity in general, but also in the criminal acts that came from this particular situation.
Right, and then that, I think it was Jennifer Falk that made the point that on Tuesday, when there's this meeting at this arcade to plan this kidnapping, when they're originally going to go, allegedly, according to testimony, kidnap Ladoris Randle, that he has an opportunity at that point to call 911, tell somebody, and what prosecutors are saying, he made the affirmative decision, the active decision not to do something. And so, what do you think of the defense trying to claim he's under duress here?
I mean, that's all they have.
It's pretty like a Hail Mary, right?
Right. Well, I wouldn't call it a Hail Mary. I think there are some points through the testimony that was presented, that the state presented, that there's a piece of wiggle room there for him to say that I was under duress.
But for 5 days?
But it's a reach, and it is a reach. It is a reach. I'm trying to be balanced for both sides. But I think that's all the defense really has. That's all they have to go on. And they talk about how he went home after the incident occurred throughout
told his mama.
and told his mother, and his mother called the police. So it's really, I mean, it sounds like it's a reach, but that's the only thing that they can latch on to. So I don't know how that's going to play over with the jury. Maybe they find him to be sympathetic because he goes home after this 5. How many days was it?
Well, it starts basically the dope is stolen on Monday.
Right.
They plan on Tuesday, according to testimony. On Wednesday, the kidnapping goes down, and they go to the house.
Right.
According to testimony. So I keep saying that because nobody's been convicted yet, and I have to be very careful.
Right.
So they go. According to testimony, they went to the house on Wednesday looking for Ladoris.
Right.
Don't find her. And so they take Shavon.
Right.
And I think prosecutors are making the point, you see
this unfolding.
You see it unfolding. You have opportunities along the way to do something,
right,
and you don't.
Right. And I mean, it really boils down to, did he bite off more than he could chew, or was he an active participant throughout the entire crime? And I could totally see the defense stating that, well, initially they thought they were going to be kidnapping Ladoris, then it turned into them kidnapping a 13-year-old
Which doesn't
child.
make it
make it much better.
It's still a crime.
But it's still a crime. But I mean, how active or how long was he consenting to all of this? I mean, we could say that, since he was there the entire time and never called the police, it was full consent throughout the entire course of this entire criminal situation. Or the defense is going to say that there were certain points where he actively started to say, well, I don't feel too comfortable about this. That's why he told his mother after the fact, and that's why his mother called the police. I still think that's a reach. There were multiple opportunities for him to put an end to this, and he didn't. But we're going to see if the defense's argument is going to resonate with the jurors.
And I think both sides agree that he's not the kingpin here, right? I mean, nobody's making him out to be.
He was the peon,
right?
Of the entire organization.
Right, exactly. Nobody's making it seem like he's the guy. I mean, and I think that both sides agree that both have said that Devontae Owens and Darius Fields are the kingpins of this group,
right,
according to testimony, and Laquan Wilkerson is the muscle, right. So. And it does seem like he.
Well, this is all based off of Desmond Jones's.
Well, right, yeah, and that's the thing. Of course, we've talked about this throughout the week that Desmond Jones, from all we've heard this week, talks himself into these charges.
Right.
The more he talks, the deeper he digs his hole.
Right. And does that make him more credible? I mean, the state is trying to paint him as someone who doesn't deserve to have this have any modicum of veracity for his statements. But he's the person who really put all this together.
And he does lead them to the bodies. So, someone who's an active participant in such a gruesome crime involving a 13-year-old. Of course, you can't just be an idiot.
You can't just, but stupidity is not a defense, at least not in the state of Texas.
Well, I will say this, that over the years, I've got comments up. I try to keep an eye on these. Over the years, I've been shocked when I would request a jail interview with somebody. The people that would talk to me. I've had people confess to me. I've had people tell me things, and I'm sitting there looking at them going, I've got a camera rolling. I've got, I'm recording you. Why are you telling me this? But some people have this innate desire to explain.
Sometimes,
and as they explain, they are digging their hole.
Sometimes people find religion in dark places, or sometimes they just like to talk to cameras.
And the reality is, I am happy to let them to talk to me.
Right.
And what I think what we saw when they played these audio interviews earlier in the week was that they were very much keeping him talking. Very solicitous. I mean, it was, and that's when I know when I interview people, I take the same tactic. I want to keep people talking. I don't yell at them or scream at them.
Yeah.
I want them to keep telling me things.
Right.
Earlier in the week, and I want to let's talk about duress. So, the prosecutors are saying, would it be reasonable to think it's duress if this is going on the 26th, the 27th, the 28th, the 29th, the 30th, and they're basically saying, think about all the opportunities he had to do something, and we talked a little bit about that, but then they brought up again. Something that the defense attorney Alan Fishburne had brought up when he was questioning Michael Mahon, the FBI agent, earlier in the week, and basically Alan Fishburne had essentially said that they were engaged in inventory control here, right? I mean, how do you think that kind of thing is going to play with the jury? I mean, those are harsh words to me to use when you're talking about something that involves the kidnap and murder of a 13-year-old girl,
Right.
kidnap and killing,
Right.
of a 13-year-old girl.
Well, I mean, if you look at duress, just what it means under the statute. I mean, if he was knowingly or intentionally or recklessly involved in a situation that resulted in this type of result, I mean, duress is not available for him. And the argument is that, from the state at least, is that he actively placed himself in each of these particular situations throughout the course of the kidnapping and ultimate murder of Shavon Randle. So I don't know if duress is going to be something that he'll be able to use to fight back against a lot of what the state is trying to pile onto him. It's going to be tough.
Justin, I hate to make light, because certainly this is not a light situation, but one of our regular viewers, Mocha Love 98, is offering to be your wife.
Really?
I remember this happened last time in the
Yeah.
Amber Geiger trial where we had people that were offering.
She's offering to be my wife.
I
okay.
know, and I mean, as I told folks the last time, he's
Yeah.
single, so.
I am single, but not looking to get married anytime soon.
Folks, if you've got questions for Justin that y'all want to ask, we'll certainly want to answer those. In your mind, what were the key points in the defense's argument here today?
The key points, like I said, their entire job was to show that he was under duress the entire time.
And a bit player, basically.
Yeah, in a very small, played a very small role in whatever happened. The key points they made, I think it was just the totality of their argument was that, he met these guys a week before, he bit off more than he could chew, and ultimately after the entire crime was committed, he ran home to his mother and, basically, confessed to her the entire scope of what happened. And, and I would package it together that he and his mother felt compelled to work and cooperate with the police. Because ultimately he did cooperate with the police, led them to the bodies, gave them all, the statements to really kind of tie all this thing together.
But if they convict him, does that become more of an issue in punishment? In other words, the jury may be saying, "Hey,
yeah, for sure.
While he's in this up to his eyeballs, we're going to cut him some slack on the punishment end of
Well,
things."
punishment is typically contextual things, right? So, what type of person was this guy, or how actively was he involved in the crime? So that's always a punishment issue. But since we're dealing with a case that's primarily circumstantial, I think that comes into play too here as well. Because we're talking about him being under duress and not actively being a participant in the crime. And he's saying that as soon as I got the chance to get away from these guys, I immediately worked with the police.
Right.
That's the argument.
Except for on Tuesday when he goes and apparently gets his hair cut and he doesn't call and say, "Hey, they're planning to go kidnap Ladoris." So
right.
That's Shavon's cousin. Hey, folks keep asking about, and I don't know if you saw Ladoris's testimony, so I'll kind of recount it. So earlier in the week, okay, let me back up. So Kendall Perkins is Ladoris's boyfriend, the father of her children. He, according to, is told by Michael Titus about this pot, this 100 pounds of pot, this a massive amount of marijuana, and because there were, apparently Kendall was going to buy it.
Right.
Well, rather than buying it, Kendall, according to testimony, goes and steals it.
Right.
And of course, LaPortia Polly's there, makes everybody upset. Okay, so that sets in motion this string
Right.
of events. Shavon gets kidnapped, and Ladoris begins to get ransom calls, and is told basically, give us our dope back, or we're going to kill her. And she
don't go to the authorities.
Right, and don't go to the authorities. But in the course of all this, she gets the names of Darius Fields and Devontae Owens. So rather than she acknowledged this on the stand, that she didn't tell the authorities everything she knew.
Right.
Not until later does she tell them. And so she doesn't give them Devontae Owens' name or Darius Fields' name. So the cops are,
They're just
scrambling
running around,
they're running
right.
around trying to piece this mess together, because they don't know the backstory.
Right.
Not yet.
Right.
They're going to find out the backstory, but not immediately.
Right.
So everybody out there in Facebook and YouTube land keeps asking, should Ladoris be charged with a crime? I've had several legal experts basically say that they can't.
Well, you could say that she was under duress.
Yeah, and they can't really see what the charge would be.
Right. Aiding and abetting.
I don't know. They all of them are
Omission. So she omitted information that she knew about when she called the police.
Yeah, but and
Right.
I don't know. I mean, in
So
some
it's a transferred intent. Law of parties. You heard the
would it
prosecutor.
be a stretch to charge her?
I think it would.
That's what the others have said too.
I think it would be. I mean,
And I could see the moral aspects of
and
it.
this is her daughter, right?
No, it's her cousin.
Her cousin. So I mean, she calls the police, lets them know that her cousin is missing, but
Her aunt. I'm sorry,
aunt
her mother does. Her mother does.
right.
But she doesn't tell them everything they need to know as they're starting to investigate
Right.
and try to find out who did this.
I mean, that's an interesting proposition. I mean, she kind of leads them on a wild goose chase. But then again, I mean, if they do charge her, I could see her defense being that she was under duress.
I was afraid. I was scared. That's what she said on the stand.
Right.
Okay, so I got an email from Alban asking, did anyone else get indicted for murder? I missed the beginnings of the proceedings. How did law enforcement catch the defendants? Okay, I'm going to give you the quick rundown. There are 4 people that have been indicted in connection with the kidnapping and killing of Shavon Randle. Desmond Jones is the first of those to go on trial. There are 3 others who are, 2 others who are scheduled for trial. A third person is currently in federal prison for 18 years with gun charges, and so I don't know when he'll be tried, but he's. And then, and how was each caught? Well, Desmond goes home to his mom, tells his mom, and then it all kind of just goes from there. And I think they get cell phone records. It's all kind of like, there's a lot of things happening simultaneously that leads to all these people getting caught. And one of the things that the defense pointed out was, well, my client's DNA wasn't in the house. Anybody could have been wearing those shoes. The cell phones don't really show that he really had the phone.
Right.
You think that the jury's going to buy any of that?
I don't know. I mean, I've seen jurors buy things that I thought were stretches of the imagination, but I mean, as we mentioned earlier, the defense, they don't have much to go on. And I think it was really smart of them to not present their case in chief and just say, oh, well, the prosecution, the state, they didn't do their job.
They didn't meet their burden.
They didn't meet their burden, so we're not even going to present anything, and we're just going to poke away, provide some perforations in some in their case in chief, and all we need is a scintilla of doubt, and you need to let our guy go.
Right.
So they're just poking holes at every piece of evidence.
What do you think the likelihood is of that?
I've seen stranger results come in cases that I thought were slam dunks. The evidence is clear that he was there. He was an active participant. The question is, was he under duress? That seems like, I don't see a jury saying or finding that to be a viable defense for him. But then again, we just talked about him going to his mother for the past 5 minutes, and that being the reason why the FBI, I think they were the initial investigating organization.
They were called in, obviously, because it was a child,
Right.
given all the circumstances. And they have,
Right.
they've got the firepower, so to speak, in terms
Right.
of the ability to track phones and all that kind of stuff.
I mean, on that hunt, he was the bloodhound that led them to the bodies.
Right.
So, I mean, how much credibility will that lend him when it comes to jurors determining if he was an active participant or not, if he was under duress?
Sunshine Buchanan wants to know, so why exactly was Mike Titus killed? Did he, in fact, double-cross Darius Fields? Well, I don't think we'll ever really know why he was killed. All we have on that is what Desmond Jones said. Desmond
Right.
Jones says that Michael Titus was killed because the dope was taken and because Desmond claims that Michael Titus killed Shavon because she saw his face.
Right.
But there's no way to know if Desmond's telling the truth about that or not.
Right, yeah. I mean, Desmond is someone who's putting out statements to save his own hide, so to speak. So you got to take what he's saying with, with a grain of salt. But if his testimony corroborates with physical evidence, then I think that bodes well for him. But there's not a lot of physical evidence outside of just proof that there was a crime that was committed. Now, as far as the criminal activity and the nexus of that, it's really hard to piece those things together because nobody is really talking outside of Desmond Jones. So
Right.
for all we know, he could have been the ringleader, you know? I mean, we're saying that it's more likely than not that he wasn't, but that's based off of his testimony and his statements.
Right. Well, and what the prosecution is saying is that basically in his statements, he's placing himself right in the middle of all this, placing himself in that car, serving as a lookout, while while Laquan Wilkerson and I think Darius Fields go into the house and take Shavon. So that's how they're and he acknowledges in their statements that they move her from one location to another location. She's
Yeah.
taken to one trap house and then taken
Right.
to another. According to him, now, I mean,
Yeah.
they never identified the first trap house. So,
Right.
So basically Alan Fishburne said there's truth in his statements. He did not act as a part of the drug conspiracy. He acted because he was compelled to act by that conspiracy.
Right.
I mean, that's what they're claiming. They're claiming,
Right.
well, if our guy was all in the middle of it,
Right. They're saying
there'd be
that,
more physical evidence.
right. They're saying the conspiracy coerced him to be a part or be involved or be at the scene of these activities. It's almost like a meta argument. Like, yeah, I wasn't in the conspiracy. I was just there because the conspiracy that was acting free and clear of my actions compelled me to be here.
Right. It seems hard to believe that the jury will buy that, though.
Yeah, that's a
real stretch.
That's a logic game for sure for those who took the LSAT.
Right. Well, and again, as the prosecution pointed out, they plan this kidnapping. They're going to kidnap Ladoris on Tuesday, and he has time by himself.
Right.
Gets his hair cut and does some other things.
Right.
So it's not like.
When you're getting a haircut, you're not under duress.
Right. Exactly.
Yeah.
I mean, I guess, and so it's hard to buy
Unless
that.
they forced him to go get a haircut.
Right. I mean, exactly. So it's hard to buy that, you're under duress when you've got the time to go do these things. One of the things that
But wait, he got the haircut. This was before Shavon was kidnapped.
Right, but the initial target was Ladoris,
Right.
the cousin, the girlfriend of Kendall Perkins,
Right.
who, is said to have taken all this dope. What did you think when the defense attorney said basically, why'd they let him go, and then basically said that it's because they had determined that he wasn't involved in the taking of the dope, and then he said if they were smart, they would have killed him too.
Yeah. I mean, I think that works against their interest there, because if he wasn't an active participant, he probably would have been murdered as well.
Right.
So I mean, I thought And when he was explaining that in his argument, I was thinking, why are you even mentioning this? This is somewhere that you should not be going as far as why did they let him go. But I guess he needed to find something to explain away the fact that he was able to, leave the conspiracy and not be killed. I didn't think he did. I don't think he did a good job at explaining that.
Sunshine Buchanan's still asking about Ladoris. I mean, it's very clear that people want her to be charged with something. I mean, that's been a consistent refrain throughout all the testimony. But one of the things that Stephanie Alvarado pointed out yesterday is that they got 5 years. So they could charge her with something.
Right.
But right now, they need her to testify more in these trials.
They have 3 more trials where more information can be uncovered.
So they'd rather have her testimony at the moment than be charged.
Well, do they have
with
enough
something.
to indict her at the moment? I think they might.
Maybe. I mean, I don't know. It's a.
But what did Rick Perry say a long time ago? You can indict a ham sandwich.
Well, this is true, and I've known of cases where people have been under indictment for years, but that doesn't mean that they get convicted
Right.
of anything.
You don't want to be indicting all
So-
willy-nilly.
Now we're gonna take a break here pretty soon, folks. Do y'all have any other questions y'all want answered? Let's see. I'm kind of going through my notes. If you had to, Justin, if you were summing up prosecution side, sum up the prosecution side, sum up the defense's side. What are their main arguments here?
Main arguments from the defense was that their client, Mr. Jones, acted completely under duress, that he wasn't an active participant in the criminal activity. They talk about how as soon as the criminal actions or the nexus of or the scope of which were discontinued, he immediately went home and confessed to his mother, and he began to cooperate with law enforcement. I think that's going to be compelling for their argument when it comes to the jurors deliberating, because that's really all they have. The state, there's not a lot of physical evidence linking him to
Right, there's physical evidence for a lot of the other people.
for a
DNA,
lot of the other people, right.
But not him. Do you think that's going to sway the jury?
Well, I mean, their biggest contention is that even though there's not a lot of physical evidence, he was still a part of the engaging criminal conduct component. And we didn't see a lot of statements that put him a part of the gang or the crew, as Jen Falk referred to them as. But nevertheless, I think just going through the evidence, being a juror sitting there watching, these interviews, looking at these photos, seeing how a 13-year-old was slaughtered the way that she was. I mean, listening to the FBI agents, was it Mahan?
We had Mahan. We had a whole bunch of FBI agents that testified.
But they said it was one of the most gruesome scenes that he's ever seen.
Right. We had one FBI agent that described when she got to the scene, I think her name was Jennifer Brigham, basically said that when she got to the scene, the smell of decomposition just nearly knocked her down.
I mean, my God. I think, and as you see with all of these cases, they try to play to jurors' emotions, especially when you have a victim so sympathetic. I mean, it's not like this victim had some type of part in the drug deal or the drug conspiracy. This was an innocent 13-year-old girl. And I think it was important that Jen Falk used this puzzle diagram, so to speak, to basically say, well, there's pieces missing, but you can actively find a piece that's off the board, which is Desmond Jones. He's not even off the board. He's like a piece just kind of meandering. We have to determine, was he an active participant or was he under duress? Their argument is well, maybe we were on the fence, but that's still a piece that's there that looks like it might fit. And we gave you enough today or this week to say that this piece fits right here. So it's up to you to put the piece with the rest of the puzzle pieces. So I think that was compelling, and I think that's strong. We'll see how the jurors respond to it. But
it would be hard to see the jury after this week's testimony being hung up or something.
Right.
I mean, this is pretty.
I'm really on the fence on whether it was a good strategic move by the defense to waive their case in chief.
You think they should have done something?
Well,
What would you have done?
they're saying that it was duress, that he was under duress. That's why he was there.
So do you put him on the stand?
I think you put him on the stand. You put his mother on the stand.
To describe what he's like when he comes home.
Right.
My baby was.
If you're saying that, oh my
terrified.
God, I mean, I was with these guys for a number of days, and they just had me scared out of my mind. I didn't want to be there, Mom. You know.
So you put mom, for sure, mom.
For sure, Mom. You got to explain the duress. You got to explain the mental state. They don't explain that.
Yeah, and maybe they're hoping that the jurors will get that from the statements, but.
Yeah. And I mean, as you know, anytime you put a defendant on the stand, you put him in the line of fire.
Well, and this guy's given 6 statements.
He's given 6 statements.
Each one a little more detailed. Obviously, each one attempting to mitigate
Right.
his.
Right. So if you
role.
don't put him on, you put Mom on, or somebody that could, speak to or provide some type of supplemental testimony for his state of duress that they're claiming that he was under. But at this point, I mean, it's still open-ended. You don't know truly if he's under duress or not. It's just the theory it's just a defense that's available by the statute.
Right.
So it's like, are you just using it because it's there, or are you using it because he actually felt that?
Well, and can you be under duress at one point, but then eventually kind of become a part of it? See what I'm saying?
Right.
Like, I mean.
Right. Or also, can you consent to something and then pull your consent as you're involved in
Well,
it?
and he, I don't necessarily think that he wasn't not scared of these guys,
Yeah.
right? But I don't know that that's enough.
Right. If it meets the threshold of I'm scared now, I can't even function.
Again, he goes and gets his haircut on Tuesday.
Right.
He could have
If
very
you're-
easily called the police and said, "Oh my God, I've gotten wrapped up with some guys that I shouldn't have gotten wrapped up with.
Mm-hmm.
There's a bunch of dope that's been stolen from a motel room. They are mad. They are on the warpath, and they're going to go kidnap this girl."
Right.
Not Shavon at that point.
Ladoris.
Ladoris. And he doesn't. I see. That's the thing. I think that was a good point. I thought that
Right.
the prosecutor made in her closings is really pointing that out.
Did you see the comment? Somebody said, "I think they let him go because he was the actual killer."
Well,
We don't know.
I mean, we'll never know.
It's possible.
Well, there's no physical evidence
Right.
to say who killed her.
Right.
The gun that was used to kill both Michael Titus and Shavon Randle is found in Michael Titus's hands, and what Desmond Jones said, again taking it with a grain of salt, was that they had wanted to make it look like Michael Titus killed himself. But I don't know about you, but you don't normally shoot yourself in the head twice. That takes some. That takes some.
Not to
doing.
laugh at that, but
No,
yeah.
I know it's not funny,
Right.
but it is. I mean,
Right. Yeah, not to make
you have
light-
to.
yeah.
You're laughing at the absurdity of it.
Right.
It's like you know, if you're going to stage a suicide, at least just shoot him in the head once.
Yeah.
I mean that, and the medical examiner testified there was no way that his wounds, like, if you get the first shot, there's no way he's going, okay, I'm going to go do the second shot. It's not happening.
Let me make sure this actually worked.
Exactly. Okay, so a couple of questions that folks had out there. People wanting to know if Kendall Perkins is in jail. No, he is not currently in jail to my knowledge. He was charged with aggravated robbery in connection with the robbery at the motel room. By the way, the drugs were never recovered. He told someone, I believe it was, I don't know if he told the authorities or if he. Anyway, there was testimony that he threw it into the Trinity River, but the drugs, that 100 pounds worth of drugs, was never recovered. Folks are asking whether or not Ladoris had an immunity deal. If she had an immunity deal, that would have come out, right? I mean,
If she would have testified.
well, she did testify.
Oh yeah.
You
Yeah.
missed it.
No,
So
that-
you should have gone back and watched her testify.
Yeah. That would have been a part.
That would have been part of the
Yeah.
questioning. Did you get a deal? I mean, they
Right.
would have had to notify the defense.
Right. That would have been something to impeach her credibility.
Right. So if there's some deal, it's, again, I think they want her testimony in these trials more than they want
Yeah.
to try to charge her with someone.
Right. And is there a federal component here? Are they being charged? I know Owens is actually under federal custody.
No, isn't the no Fields.
Fields is
So Darius Fields gets 18 years in federal prison for guns, and LaPortia Polly, who's in the motel room when the drugs are taken, she gets 4 years for supplying guns to the crew. And I keep wondering, are we going to see LaPortia Polly at one of these points at this trial? But so far, or at any of these trials, but so far we haven't.
Right.
And I don't know. It would be, but you're right. And the other thing is that the defense waived the opening statements too. They didn't do openings.
Yeah. It's almost like
I mean, do you feel like they didn't do enough?
I don't cast aspersions on attorneys, and I don't like to critique if
but
they did
that's
enough
what
or
you're here
not.
for.
Yeah, I would have done it a bit differently. But they sat with this evidence longer than I have, and I think they made the educated and informed decision to forego an opening statement and a closing. Well, no, they did the closing, but putting on their case in chief.
Right. I mean, if you were defending this, was there anybody else you'd put on besides Mom? I mean, putting him on the stand is
well. So they questioned the state and the law enforcement agencies involved. They questioned their investigation.
Right.
So I would have probably put on a forensic expert, someone who has an investigation background, to really illuminate and explore and explain why that investigation was woefully deficient, because that's what their argument is. So I would have probably gotten an expert, and I understand that this defendant is probably indigent, but you can get the county to pay for that.
Right. Right.
So I don't know.
You would have tried to get some kind of expert to poke holes in some of what they're claiming.
Yeah, I would have pulled out all stops. I mean, the duress argument is more of a kitchen sink argument, so I think you got to provide some type of kitchen sink, tangential kitchen sink, elements to kind of support that argument. They didn't do that, and like I said, they've had the opportunity to prepare for this trial, and they sat with this evidence longer than I have, so they probably saw something that I'm not seeing.
They must have some reason why they didn't.
Right.
And there must have been a reason why they didn't put Mom on the stand.
Right.
You would think. I mean,
Mom
maybe
might have a criminal record, or not to make the assumption, but she might have some character
there may
issues.
be a reason that you don't put Mom up there.
Right.
Somebody's asking about LaPortia Polly and if she's due to be released. All right, I'm trying to look, folks, here. Because she got 4 years on the gun charges, and I'm trying to look and see if there's a release date on her. I'll have to keep looking, but I'm not aware that she's. I mean, typically, and typically when you get federal time, it's not. The feds, they like to keep you for most, if not all, of your sentence.
Right. 85%.
Yeah, it's pretty. Well, I mean, I guess if it's 85%, she got 4. Well, I don't know. I'll have to look that up, guys. I'll try to find that out. Which, what? When you think about this, can you recall a case like this? I mean, this is just the depravity of anybody that would be involved in a scheme that involves the kidnapping of a 13-year-old girl. It's hard for me to just wrap my mind around anybody that would be involved in something like that.
Right. I mean, the term evil was used by both sides in their closing arguments. Of course, the state said there were 4 evil people involved, which was everybody, including Desmond Jones.
And of course, it's up to the jury to decide who the evil people are, so to speak.
Right. I mean, at the end of the day, I think you can stipulate that this was an evil crime. Now, the level of involvement of all 4 people who wasn't involved, like you said, that's a matter for the jury to make a determination of. But yeah, I mean, this is one of the more heinous crimes I've seen, at least in Dallas County. It's so unfortunate that you have this 13-year-old girl used as the means of getting back drugs, and then ultimately being murdered in a way that, she was actually executed, shot twice in the face or in the head, in the chest. It's beyond comprehension.
Yeah, no, it's one of the more disgusting, despicable, and I've told folks this before. I covered this case, and that's why I so strongly wanted to do this sort of type of coverage, because I was so appalled by what happened.
Right.
Some people have actually gone online and looked, and they've determined that LaPortia Pauly is due to be released in November of 2020, so later
Oh,
this
wow,
year.
okay.
So, well, I mean, this all happened back in 2017, so if she was in custody the whole time, I guess you could get to close to what you would have to serve. So I guess it's
Right.
possible, given that there is a lag time between when something happens and when someone is charged. Hold on, I was trying to. There was another question someone was asking. Someone was asking, when are the others due for trial? So, Laquan Wilkerson, who was called frequently in this trial Chuck, is set to go to trial in June of 2020, and Devontae Owens is set for July of 2020. So we're heading on trials this summer for the other folks. Do you think that now there was a lot of forensic evidence presented in this case, a lot of DNA, a lot of cell phone stuff. Do you think they have a lot more on these other guys? I mean, they presented a lot. I mean, Laquan Wilkerson's DNA being found on this tie where
Right.
Shavon's blood is. I mean, there's a lot.
Right. I think they have enough for Laquan Wilkerson. Yeah, I mean, they might be holding back some evidence, but I think they're going for a full and complete thorough case on each of these folks that they're trying. So I don't think they held back anything, for one. And two, if they're going for the enhanced engaging in criminal activity enhancement, I mean, they're going to take the scope of the entire crime and then build that enhancement on top of that.
And they may have learned some things from this trial that
Oh,
they'll
yeah.
do differently. Every trial you do, you learn something
Right.
differently about how
Right.
you're going to present something.
Right.
Because initially they were going to play the 3.5-hour interview with Desmond Jones, and I think after they saw the jury, I was struggling to
Yeah.
pay attention when they played the hour and 40-minute one, because it was audio and it was
Yeah.
hard to understand. And I think they opted that next morning not to play it. They just did excerpts from
Right.
it. And I think they learned a lesson. So I'm sure with every trial you kind of learn about,
Right.
okay, this is how we need to do
What's
it.
the most effective means of getting this evidence in?
So Chris Henderson wants to know, will the prosecution want him to testify against the other defendants? Well, I can't see any way that he would testify.
I mean, he didn't even testify in his own case. And they have his
And
statements
he has
already.
a Fifth Amendment right.
Right.
And so
Right.
I cannot see them doing that. Okay, so Winshay Gritton, I hope I'm not mispronouncing that, wants to know, is the jury being secluded? No, that is really rare for a jury to
Right.
be secluded. I mean, the only trial,
Costs money.
in the few years ago when Eric Williams, he was a former justice of the peace who killed the DA and his wife and a top prosecutor, they secluded that jury during punishment. And in Amber Geiger, the judge took the extraordinary step of secluding that jury for the duration of the trial, which
Right.
I can't recall ever happened.
Which was understandable for that trial.
Yeah, that trial had a tremendous amount of interest, so it's pretty rare for a jury to be secluded. So I don't see any reason why they would seclude this jury. You only do that when you think there's some. It's just rare.
Right.
And when you seclude a jury, you're taking them away from their lives
Sequester.
and their phones. I mean, it is a real.
Right.
I mean, it's a real. It's a
real
huge-
commitment for the jurors,
Exactly.
but it is their civic duty. So maybe we should see more juries sequestered.
You think?
Yeah, why not?
What do you think? Yeah, I don't know. That's a tough one. I think,
I mean, it's tough, but
no, it's really hard. I mean, and of course that would cost the county a lot more money. Do you? Okay. So Candace M wants to know: do I think this trial will go into Monday? Well, my crystal ball is not completely working, but I am certainly planning that it could.
I got a trial Monday too. So in that actual court,
Yeah, so I don't know.
So-
It's really hard to say because
if he gets convicted, then you got to go to punishment.
right. and I mean, I don't know who all you put on punishment, and there's probably bad acts that we've not heard about yet that would come up in punishment. So
I mean, over under, did they get a conviction today?
Don't ask me that. I don't know. What do you think?
No, I don't.
You don't think they did? You don't think they get a conviction?
I think we get a conviction probably Monday morning.
Oh man, this is going to go into Tuesday. Don't say that. No offense, guys, but I have other work that I have to do.
There's always other work, though, Tanya.
There is
It's not
always
a good
other
excuse.
work, but my other work still has to get done. But I don't know. It'd be interesting to see if it goes into Tuesday. I am hopeful that we'll get a verdict today, and that we'll start. Well, because of course, even with punishment, then you still have statements in that. Because the thing about punishment is it's its own little mini trial.
Right.
So I don't know. It's really hard. My gut says we go to Monday for sure.
Right. And I don't see the defense putting on a lot of evidence during punishment.
I mean, it was pretty much kitchen sink.
But you know what? So I mean, a lot of strategies involved, especially if you don't put on a case in chief. We're just going to wait until punishment. So maybe they're thinking this is just a punishment case.
Well, and that was certainly what some of the other lawyers this week thought when they were talking was that they felt like this was more of a punishment situation.
Right.
That it's going to be really difficult for a jury not to convict given the circumstances and given 6 statements. I mean, he's acknowledging, I'm there. I'm when this kidnapping is going on. I'm there during the planning. I mean, for kidnapping of Ladoris.
Right.
I mean, so it's hard to see how.
I mean, that makes perfect sense. I'm pretty sure the state didn't offer him a favorable plea deal.
I'm guessing not.
So they probably got to an impasse during pretrial negotiations, and I could see his attorneys, especially with how they presented the case, saying, "Well, you're not going to give us a favorable deal. We're just going to take it to a jury for punishment."
Do you think every one of these cases goes to trial, or do some of them plead out and just take a very, very long sentence?
Well, I'm pretty sure they charge these cases extremely high because, one, this was a high-profile kidnapping and murder.
Right.
So, I mean, I'm sure the state probably gave them a punishment recommendation so high that nobody would take it. So that's why they're saying, well, at least in this case, we're just going to take it to the punishment phase. Let a jury decide what his fate should be.
Yeah, we'll see. Will be really interesting to. I will say that most of our YouTube jury thinks we're getting a verdict today. So,
okay.
YouTube jury is, of course, during
Facebook jurors, YouTube jurors.
Well, during the Amber Geiger trial, I was monitoring Facebook more, but this time we're just doing YouTube and the website. So the people want to know what verdict would we render. Now, as you can imagine, I cannot give my opinion because as the journalist involved in this, I don't get to render verdicts. I didn't do it during Geiger, and I won't do it during this one. Would you render a verdict?
Well, so I patterned my commentary on the likes of like Troy Aikman and other guys who comment on sports, and they're always unbiased. So I'm going to be unbiased and not provide what I think a verdict should be. I think both sides presented. I believe both sides presented compelling evidence and arguments that could cut both ways. So I wouldn't be surprised if the jurors determined that Mr. Jones was under duress. And I also wouldn't be surprised if they came back and said that he was an active participant the entire time, and he should meet the fate that his co-defendants might face going forward too.
I think there's a likelihood though that they might go with a lesser included, maybe the aggravated kidnapping. I mean, he did acknowledge that he's a lookout during the kidnapping.
Right. So he could get the aggravated kidnapping, which is logical. The murder, there's not a lot of physical evidence linking him to the murder.
There's none.
So, if they come back with the aggravating kidnapping, I think that could be plausible. So they have some options. It's always good for jurors to have options, especially when you're a defense attorney. So, and I think his defense team acknowledged that, or they pointed it out. You have the opportunity. They said you don't have to start at murder or start with the engaging of criminal activity. You can start anywhere on this board and determine where you want to land at.
Right, and you got and somebody's asking if they all have to agree, and the answer is yeah, they do. I mean, all 12 of them have to agree unanimously what they think the verdict should be. and it's the same in punishment. Obviously, if they can't agree, then we end up with a hung jury.
Right.
I
think they try this again too.
I think they would. I would be shocked if we had a hung jury here. I mean, that's, I thought in Hess we might have when Christopher Hess, the police officer, Dallas cop, went on trial, I thought a hung jury was possible there. And I even thought Geiger was possible. But I'd be shocked if we saw a hung jury. I mean, that happens.
Right. They get caught up on this notion that he truly wasn't involved or didn't want to be involved. That's why he told his mother immediately about what happened. I mean, could I see folks getting hung up on that?
It's his statements, though. I mean, when you're confessing that you're there, you're the lookout, you're part of the lookout.
He's giving them everything, though.
I mean,
he's pouring his soul out, assuming that he's telling the truth.
Well, basically, the defense wants us to believe that, again, that he's under duress, that he, and that when he had the chance to tell what he knew, that he did it.
Right.
And then I think it was Fishburne that said, well, as he got more comfortable and believed he was safe, he told them more and more.
Right.
You think the jury's gonna buy that?
I mean, this whole haircut thing in the middle of the, I mean, Jesus Christ.
Okay, so Julia 0824 wants to know, what if they convict but the jury is hung on sentencing?
I can see.
I can see
Judge
what
Holmes.
happens then if that happens?
For one, I don't think Judge Holmes would allow that to happen. I think she keeps them there until they come out with a decision.
But let's say they just say, well, we just can't decide as punishment. Of course, usually
Right.
when I can't recall a case where once they convicted, they couldn't agree on
Right.
punishment. That's
a lot of times when they determine the conviction, they already have in their mind what they're going to give them in punishment.
Yeah.
If they come, especially if they come back with a lesser included.
Can they do another jury? If for some reason a jury did hang on punishment, do they have to get another jury up there? Is that what happens?
I mean, that's a heck of a question.
I don't think I've ever seen it happen.
Yeah, I've never seen that.
I think it would be.
It's probably good to figure out.
Okay, so somebody wants to know, if this jury comes back with a guilty verdict, will the same jury determine his punishment? Yes.
Yes.
But again, that punishment phase of a trial is a little bit, you essentially have the guilt and innocence portion of a trial. It's like basically part one,
right?
And then part two is punishment, and part two is its own little
it's
like its own little trial.
Right. You have opening and closing statements if you so choose to have them, and you have your case in chief on both sides.
Right. And somebody wants, Eric P. asked, the jury selects sentencing. Yeah, he is elected for the jury to determine his sentence. He could have chosen the judge, but he didn't.
Yeah.
And most people want a jury of their peers to make that decision. All right, folks. Justin and I are going to go have lunch. We'll be back soon.
Right.
Type up your questions in the comments or send me an email, and I will, when we get back from lunch, we'll answer them, and maybe when we get back from lunch, we'll have a verdict. We'll see.
Okay.
I
personally wouldn't. I wouldn't bet on a verdict coming that quickly, but.
Well, they do have like 20 pages to read, so it could take them a while. Okay. All right. Well, we're going to go have lunch. I appreciate you joining us. We'll be back in 45 minutes or so. We'll talk for a while when we get back. And again, appreciate you guys joining us. Thank you. Okay, folks, we have a light. This is that red light that's in the courtroom. That's the light that the jury punches to say, hey, we've got a question. Hey, we want to go to lunch. If I was a betting person, I would bet on they want to go to lunch.
Yeah.
Wouldn't you agree?
That would be a safe bet.
Because we were trying to go to lunch, and we were about to walk out.
We're
when
literally walking out for lunch.
And
So I think that's what they want.
Yeah, and so we'll see here in a second what this is, but that's my guess, is that this is about going to lunch. I mean, I don't know,
Me and Tasha were just talking though. Judge Holmes is a workhorse, and she likes to get through these trials. So she might not let them go for lunch. She might just order lunch for them and tell them to deliberate through their meals.
I would not be surprised by that at all.
All right.
And the other thing was that Tasha, who you guys who were with me on the not the Geiger trial, the Hess trial, know is that she could also order them back for Saturday deliberations. Oh, you want to put me on cam? All right, I know you guys want to see me out there. Anyway, so yeah, I think that likely they're wanting to go have lunch.
Right.
Of course, there's an off chance. I'd be shocked if they come back with a verdict this fast. I mean, this is a pretty lengthy jury charge.
Right. And they have to go through the transcripts of the statements, and those transcripts are very important when it comes to piecing together the engaging criminal activity component. If they come back with a verdict this quick,
then they couldn't have read anything.
They couldn't have read anything. That means they would have went in there already knowing that what they would have determined what the verdict would be already. So yeah, I would assume they just want lunch. They want a break. They've been here all morning. They probably want to get out and stretch their legs. Some people probably might want to smoke a cigarette or something like that. Who knows? And I think it would behoove Judge Holmes to allow these folks to take a break, especially if she's intending on having them work late or work into their weekend, to give them a break now and kind of overload them with work on the back end.
Well, and I know this. I mean, one of the reasons why I always try to go to lunch on the breaks is that it helps me.
Because you're hungry?
Well, that and yes, I'm fat. But it also helps me clear my mind. Mm-hmm. Get my mind right.
Yeah.
And just kind of I think sometimes there's been a lot of research that basically shows that people need a break. You need a moment to clear your head, like you said. Go smoke a cigarette.
This
take a walk.
This isn't a decision that these jurors are being asked to make, that they make on a daily basis.
No. Probably most of these people have never
been on a jury before.
Never been on a jury before. Probably
never a criminal jury, at least.
And this is, and we've talked about this before. This is an unusual charge. Mm-hmm. It's an unusual situation. I can't recall the last time that you had a kidnapping and murder that was charged under the engaging statute. I mean, it certainly seems appropriate,
right?
But it's unusual.
Right. I mean, it's unusual. I mean, I'm sure these folks have never seen anything like this before. And also, I mean, whenever a civilian serves on a jury, especially when it's involving a case like this, or even just a DWI, I talk to folks all the time. They talk about, oh my God, I served on a jury 20 years ago, and it was a DWI. I mean, this is going to be something that these folks remember for the rest of their lives. So, especially with a case of this magnitude, with this type of weight and girth, I'm sure these folks, they want to take a break now because they just went through days of evidence. They went through emotional.
There's a lot of DNA.
Right, a lot of DNA. Emotionally charged closing arguments. I'm pretty sure they sent in word to the bailiff letting the judge know, or this is my assumption, that they just want to take a break.
Yeah, I'm trying to text Rebecca Lopez. She's at the courthouse to try to see if she knows why we have a light.
Right.
Unfortunately, Tasha, have you heard something? This is kind of frustrating.
Yeah.
I don't know. I don't know what's going. I mean, like I said, I think the likely thing is lunch. That would be the.
Or maybe they accidentally pressed the jury button.
And then this, well.
Jury call.
I don't know.
Because we haven't heard anything yet.
No, I'm not here. I've got my sound. I've got my earpiece on. I'm not hearing anything in the courtroom. So I don't know. And then suddenly we're back on the jury light. I don't know. I'm trying to decide if it's safe to go have lunch or not. So Well, folks, I think what I'm going to do is I think we are going to break, and hopefully this is just going to lunch, and then we'll see what the deal is, since they're not really coming back and saying anything that allows us to know exactly what's going on. If I hear back from Rebecca Lopez with exactly what's going on, we'll post it in the comments. But I wouldn't put it outside the realm of possibility to have a verdict in the afternoon. But they do have so much to go through. There's 20 pages of, or I don't know how many pages the jury charge is, but it's lengthy, and they do have to read it. And then they've got all the DNA evidence. They've got all these transcripts, because he gave, well, at minimum 5 hours of interviews with the authorities, because we know 3.5 and about an hour and 40 minutes. And then there was a 16-minute one, and I don't know, there was a whole bunch of them. So, I mean, there's a, depending on what they decide to do, whether they decide to go through all of that or not. And do you find that most juries do? Do they take the time to go through all of it?
I've never been in a jury.
But have you talked to jurors afterwards?
Yeah, I mean, jurors sometimes will tell you that, I knew this guy was guilty or not guilty already before we even went back to deliberate. But most often than not, they at least give it the effort of going through the evidence. So, I mean, with a case as heinous as this, I could see some jurors saying, I already have my mind made up. But at the end of the day, they still got to go back there and compel and persuade the other jurors to think like they're thinking also. I don't think it would have been within the matter of 20 minutes that they've done that already.
Right. Well, I don't even think they'd have time to go through the jury charge at this point.
Right.
All right, folks. Well, I'm going to risk it. I'm going to go. Justin and I are going to go to lunch, but again, if we get word of what exactly is happening, they will post it in the comments. And okay. I just got a response from Rebecca. She says the jury wanted a calendar and some DNA reports and photos. So that's what the jury asked for. So I don't know. That calendar, that's that calendar they put up in the room in the courtroom that explained, like the chronology.
Yeah.
And
that was defense's exhibit, right? No, it wasn't.
No, that was prosecution's. Yeah.
Right.
So that but they had put that up to help understand what's happening each day. And then, of course, they asked for some DNA reports and photos. So, they're clearly taking a close look at whose DNA is where and that kind of thing.
So maybe they started with the murder aspect to see.
Maybe.
To get that off the board first, if that's what they're trying to do.
Could be. It's a hard one, and then this is a complicated case.
The chronological order, maybe they're trying to say if his statements corroborate or been corroborated through the calendar. It seems like they're trying to see if he's truthful and he has some type of credibility with the statements that he provided.
Well, and that what that also tells me is that they're taking a close look at everything.
Right.
Which I think is
important.
Which is what we want a jury to do.
Right.
So, all right, folks. So Justin and I are going to go grab lunch. If we hear any more, we'll post them in the comments, and we'll be back soon. Thank you so much. Hey folks, just a short time ago we got another red light and we are getting word that there is a verdict. So this jury's been out for about an hour and a half, and it looks like they're about to bring Desmond Jones back in. They've got the door open to what's called the holdover, which is where they would keep him when he's not sitting in court. Okay, Farron, yeah, we did go eat. I'm back. I've been back. I've just been kind of, and I'm sorry I took longer than a 45-minute lunch, Lasanda. I wasn't sure what I could talk about when they were on break, because we've kind of belabored everything. If you guys have questions, go ahead and put them in the comments, and I'll do my best to answer them. Again, this jury went out about, I think, said around 11:30ish, and they've been out. They had lunch. They asked for drinks not long ago, about a half hour, maybe what, half hour ago. They asked for drinks. Sorry, guys, So, they've been out deliberating, about 2 hours. So that's it's given them time to go through the jury charge. And then Rebecca Lopez, who's our reporter down there, had said that they had asked for that calendar, some DNA reports, and photos. So obviously they have made their way through their jury charge, and they're going to come up with what they're going to decide. They're going to decide Desmond Jones's fate. We heard this morning closing arguments. The gist of the prosecution's argument was he is a willing participant in this whole thing. He is present. Every opportunity he had to stop this from happening, he didn't take it. They talked this morning about how this robbery of the drugs happens on a Monday. There's a planning on Tuesday to kidnap Shavon Randle, Shavon's cousin, and that Desmond Jones goes and gets his hair cut, doesn't take the opportunity to inform the authorities, and then on Wednesday when they go to the house in Lancaster to kidnap Ladoris, instead they find Shavon and her cousin who has Down syndrome, and they take Shavon, they put a pillowcase over her head, and they bind her. Desmond Jones has told the authorities that he was a lookout during this. He described, and he later on led the authorities to the bodies of Shavon Randle and Michael Titus. The argument of the defense has been he was scared, he was afraid, he thought he just met these guys, he thought they were going to kill him, so he had no choice, he was under duress, and they're basically saying that the moment that he is quote unquote released away from these guys, that he goes back to his mom, that he's at his mom's house, and he tells her what's happened, and then she contacts the police, and then of course that then leads to the authorities finding the bodies. And over the course of about a week, he gave the authorities 6 statements, the longest of which was 3.5 hours, which is I don't know if I've seen a case where a defendant has given so many statements. Wow, we can see a lot of movement in the courtroom. I mean, I'm making a guess here, but I kind of feel like they're going to bring Desmond back in here in a second. Okay, Larica Rivers wants to know, will LaPortia be charged with just the guns? Well, so far that's what she's been charged with. She's in federal prison. She got 4 years, and according to the YouTube jury out there, they went and looked on the federal site, and she's supposed to get released later this year. So it'll be interesting to see whether LaPortia Polly could end up testifying in some of these other trials. We've got 3 more trials to go. Well, there's Desmond Jones walking back in, about to find out his fate and what this jury has decided. They basically have 3 options here. They can convict him of engaging in organized crime. That's a first-degree felony, punishable by 15 to 99 years in prison. There are 2 lesser includeds. The lesser includeds are murder and aggravated kidnapping. Both are first-degree felonies. They are punishable by 5 to 99. So, the jurors could... All right, we're about to hear some sound. Okay, let's listen to what's going on in the courtroom. I think hold on a second. Don't turn my mic off yet. Sorry, guys. I'm sorry. I do this to them all the time. It looks like the jury's about to be brought back in. You can see Desmond Jones sitting there. You almost can't imagine wait a minute, he just left the room. As you can see, we have zero control over this thing. And Justin just walked back in. I don't know where, oh, okay, hold on a second. Yeah, thank you, Donna's World, for reminding me about LaPortia getting out in November.
Pardon me?
You got all the evidence back, right?
Okay, I think we're hearing a little bit of sound coming out of that courtroom. The verdict's back in, Justin. Yeah, Justin just walked back in. He actually has real work to do for his job, but we do appreciate him coming over here and spending the day with us. And all of the lawyers who have come this week, they come over here. They're spending their entire day doing something. They don't make any money doing this with us. They're just coming over. I just take you to lunch. That's all I do.
I thought I got paid for this.
No, there's no payment. No, so I mean, and a lot of the lawyers that come here, they really want to help folks understand what is going on, here in the courts, why things are happening. Oh, okay, so Robin Mallow wants to know, will the judge decide the sentence or the jury if he's guilty? Desmond Jones has elected for the jury to decide his sentence, which is not uncommon. I think the jury's about to come back in. Oh, go ahead.
I thought that was mine.
All right, I think what do you think? The jury about to come back in, Justin?
That's what it looks like.
Thank you.
And it has a page number on it.
Just kind of echo your sentence. Oh, here's the judge.
There we go. The verdict is, Jay Phillips, the verdict is in. This jury's been out roughly, like I said, about 2 hours. And so they have, here's the judge. I think we're about to see what this jury has decided. I mean, you think based on 2 hours that probably...
That's quick. I think that might bode well for the state, honestly. But we shall see.
Okay. I'm just being told that the verdict will be read in 15 minutes. And you know this, Justin. They're going to give everybody time to get back to the court.
Right. Exactly. They're going to have everybody time to get back. I'm sure, maybe defense counsel probably went out and got lunch, or, so they want to make sure everybody can get back and convene, and everybody be there for the verdict to be read.
Yeah, and this is kind of not uncommon. And a lot of what you guys are seeing is y'all are seeing kind of how the sausage is made. I mean, this is the way that the courts are. They don't move on our schedule.
It's not like Law and Order.
No, it's not like Law and Order at all. And those of you that have stuck with us throughout the week have seen that a lot of the stuff that gets presented in court is pretty tedious. I mean, it's, when...
DNA evidence, all this other stuff, cell phone records.
It's sometimes it's hard to follow, but these are like the important, building blocks of who is where and where they're at and what they're doing.
Right. Well, it's important. You mentioned earlier that you guys have been covering cases since the Amber Geiger case. And I think it's important that we're in the courtroom actually getting a chance to show the public how the sausage is made. I went to a judge's forum the other day, and I told them one of the things that we need to start asking you guys is to start allowing cameras in the courtroom. We don't need to have these proceedings under a shroud of secrecy. Let's have people actually watching and tuning in and learning. Yeah,
and I know when I started covering, courts and police, many years ago, since the mid-'90s, cameras in courtrooms back then, that was really unheard of. I mean, really OJ was probably the first big trial, where you had, a case aired like this. And it's only been within the last 3 years or so that Dallas County judges have been really open to this.
You showed me the video of Jace.
I mean, the fact that we have streaming capabilities now, and
I guess she found out.
we can have cameras that aren't huge and clunky in these courtrooms. There's a way to get it done without causing a spectacle for the jurors.
Right.
Because a lot of times judges they like to say that, I don't want to cause a spectacle for the jurors, so that's their
Right.
scapegoat.
Well, what we do is we have what's called a pool cam. So
Right.
there'll be every day
Yes, till
different
1:55.
news stations will take turns being the pool camera.
Till 1:55.
And then
Sorry.
now during the Amber Geiger case, Court TV actually was pool cam every day, which was good.
I was actually in that meeting with Court TV to get cameras into their courtrooms.
Oh wow, were
Judge
you?
Tammy Kemp wasn't going to allow that until a couple of Court TV reporters that I knew that came down to lobby for that actually got it done. So.
Well, and I think that was the first time that we did this style of coverage where we're sort of doing, and I hate using the word play-by-play, and maybe it's because I don't have a better word for it, where we're basically sitting here Monday morning quarterbacking everything that's going on in that courtroom, but
Right.
trying to explain to folks why things are happening, because people watch Law and Order and it's like they cut to the chase and then it's
cut
all
to the
over with,
chase.
but that's not the way that
Right.
that's not the way the court system works.
Right. Oh, yeah. These trials take days, maybe weeks. I mean, you labor through mountains of evidence. It's important for lay people to really understand how we get justice not only in Dallas County but nationwide. So I think this is a good educational type of project that you guys
I
provide.
think it helps people to understand that. I mean, it shouldn't be all a mystery, right?
It should. It should.
But if we were, it's probably not a good sign for Desmond Jones that they're back this quickly.
No, it's not. It's not. But we never know what a jury might say. So, but if we had to make a guess, I don't think it's a good sign for Mr. Jones.
No, and I think it's really hard to buy. I mean, this is I could see where a jury would say, "You're there.
Some of these
You're the
comments
lookout." Yeah, I know some of these comments are amazing.
Don't read them.
Yeah, I know. Well, and sometimes when I'm laughing, I'm most certainly not laughing at the situation with Shavon Randle. It's just that I'm reading some of these comments, and it does have to make me chuckle a little bit. It says, can the jury also make, Falcon Hoof asks, can the jury also make recommendations, I think is what they must mean. Well, so when the jury comes back with a verdict, obviously they've got three choices here. Mm-hmm. They can find him guilty of engaging in organized crime.
Right.
Again, that's 15 to 99.
Right.
They can find him guilty of
Aggravated kidnapping.
Aggravated murder, and murder, and then that's 5 to 99. So actually, in this particular case, finding him guilty of engaging in organized crime is the higher charge.
It's the higher charge because it incorporates the murder and the kidnapping, and it provides an enhancement.
Right. Which is, I think, I've racked my brain trying to recall a similar case, and I can't recall one.
Right.
Typically most people are charged with murder. And of course you get into capital murder, which carries the death penalty
Right.
or the possibility of life without parole. When you have, like, if you could directly prove that Desmond Jones kidnapped her and then killed her, that would have gotten you into capital murder territory.
Yeah. Well, what's interesting is, and this is why the feds were involved initially, a lot of these organized crime cases get tried at the federal level, so we don't see them at the county level. Which is really interesting to see that this isn't being tried at the Earl Cable Building. It's the Earl Cable Building. That's the name of the federal.
Don't get me to lying on how
Right.
to pronounce the federal.
Well, at the
building.
federal building. So it's really interesting that this case isn't being tried as a federal offense.
Well, they did. I mean, they did try Darius and LaPortia on those gun offenses.
Oh, the gun offenses. Okay.
So I don't know. I mean, I could see why Dallas County would want to try
Right.
this.
But if it's a RICO case and you have two people being tried on an aspect of the entire criminal, I guess, engagement, you would have thought that Desmond Jones would have been tried at the federal building too. But I mean, that's kind of getting into the weeds.
Yeah.
It's not really important for this particular commentary.
And Lisa wanted to know if can he be sentenced to death? No, he cannot be sentenced to death. The most he could get is 99 years in this particular case. Now, had they been able to show that Shavon was sexually assaulted, Justin and I went and reviewed the penal code on this morning. If they could have showed she had been sexually assaulted, then it could have been life without parole.
Right.
So, Fair and Strange wanted to talk about cover one of your cases. Well, you've actually got a case in Holmes's court on Monday, so
Yeah.
whether or not,
Well, depending on how long this goes, so if they go into punishment phase and take forever, it might not start Monday. It's going to start next week, but
you got a murder case.
Yeah, it's a capital murder case. Yeah.
Is he facing the death penalty?
They haven't made a determination yet, so we'll find out. But he was arrested when he was 17, so I don't think they can seek murder for a 17-year-old.
Oh, okay.
I believe that to be unconstitutional.
Yeah, I do think that's right that they were ruled on that. Farron was asking, are they in the same jail right now? Okay, Devontae Owens, Desmond Jones, and Laquan Wilkerson. So Laquan Wilkerson, Devontae Owens, and Desmond Jones are all in the Dallas County Jail. And Dallas County Jail, like I said yesterday, is a really big place, so it's not hard to keep them separated.
It's one of the largest county jails in the country, right?
Right, yeah, it's a huge place. So, and Mocha Love 98 is letting us know that one of them's in the West Tower and two are in the North Tower. And actually, y'all can go over and look at the Dallas County jail inmate log and see exactly what she's talking about. It's really easy to cover.
YouTube jurors, you can be YouTube sleuths too. So
That's right. Well, they've been really good about that here. Jesse Florence wants to know, does WFAA cover court like this a lot? Well, we've done it. We did it with the Geiger trial. That was the first time we ever tried it. And that was I remember when my bosses asked me to do it, they said, we want you to sit with a legal expert and talk about a court case. There was really no instructions. It was just, go do it, and it was a learning. Thing, and then we did some with the Christopher Hess case, but we didn't do the whole trial. And so we do. This is something we do want to do every couple of months. And
well, the Hess trial was 2 weeks ago.
Yeah, I did do it some with that one, but we didn't do every day. It's a big time commitment because I am on the investigative team, so all my other work again does not go away. It still has to be done. So I promise that I will do this as much as we can. There are trials for Devontae Owens and Laquan Wilkerson coming this summer, and if at all possible, if I'm able and if the judge will allow cameras, then we'll do them.
All right.
And so let's see. No, we haven't cut the feed. We're on right now. You're asking me. Well, right now we're just the courtroom. Whenever court is not in session, the photographer's under orders to have the camera on that state seal of Texas, because of the state of Texas seal. And the main reason is we have to be very careful not to show the jury. And so we're really, obviously you have to protect the jurors. You have to make sure that they're, and especially in a case like this where you have. There's still, Jess, I don't know if you weren't able to probably watch the whole trial this week because you do have like a job that you do.
Yeah, I just got back from New York yesterday.
Right, and so there were actually a couple of suspects that they never identified.
Really?
Right, yeah, there's a couple of people that were never identified. So, I mean, they obviously have to, be very careful about these things. Albin says let me get you to answer this. He says most jurors do most jurors make up their minds during openings?
Some have. I've been back to talk to jurors before, and they said they already knew how they were going to, rule.
But that's not the way it's supposed to work.
No, it's not. It's not. A juror's supposed to sit through trial, hear every piece of testimony, look at every piece of evidence, deliberate with their fellow jurors, then come to a decision.
Right. And that's what we want jurors to do.
The thing about picking a jury, voir dire, you're supposed to weed those folks out who have preconceived notions and they have their minds made up already. So, if you're a good lawyer, or if you have two good lawyers on both sides, they would have weeded those people out beforehand.
Right. Januta Harris wants to know, can they go back and charge the cousin for withholding information? Boy, I cannot tell you how many people have asked that question.
That is the hot button question.
And look, I get it. I mean, it is infuriating when I listen to Ladoris Randle's testimony and you realize that she has important information. She knows the names of Darius Fields and Devontae Owens.
Yeah.
And she's getting these ransom calls and she's not telling the police every single thing she knows. And this is at a point where the authorities are really, they don't know what's happened to this girl. They just know you have a 13-year-old girl that's been snatched from a house.
Yeah.
There's this, and they know that every single second that passes
Counts.
by
Right.
is a second that makes it more likely that Shavon Randle does not get found alive. And that's
Right.
exactly what happened.
That's
So we'll
exactly
never
what
know
happened.
the answer as to whether or not her giving all the information she knew would have made a difference.
Right.
And it's really, and yeah, Farron's getting tired of people asking about that question. But it is infuriating, no doubt about it. No doubt about it, guys. Now, if y'all got questions, feel free to ask them while we're sitting here just chatting while we await this verdict. If you were, I mean, what do you think? Do you have a more likelihood about what they'll do? I mean, more likely to go with engaging, more likely, I mean, okay, let's say this. Let's say they go with aggravated kidnapping. Why would they go that route?
I think all the elements have been met for aggravated kidnapping, so I can see them going there that direction. So lesser included. So typically the lesser included are easier to come to a conclusion on. But since they're reaching a verdict so quickly, I would think that they are going to charge him with the engaging, or convict him of the engaging in criminal activity. That's what it seems like. Just from the evidence that we saw, I mean, everything was there to say that he was a part of this and criminally engaged in this activity. Extremely quick verdict. But you called it though. You said you thought we were going to get a verdict this afternoon, and we did.
Yeah, I didn't feel like it would go more than a couple hours. Judy Marie wants to know, she's asking if, well, they couldn't prove if Shavon was sexually assaulted or not. Well, there was no testimony to that effect. And I guarantee you, if they could have shown that Shavon Randle was sexually assaulted, that would have come out in court.
Right.
There's no way that they would have allowed the medical examiner to get up there and not testify to that. If that was the case. And they also used bleach on her body. So, we're just never going to know the answer, I mean, to be able to say whether or not. And the sad reality is, other than Desmond Jones' statements, we really will never know exactly what happened here. Because obviously the prosecution is saying, Desmond Jones, in their mind, is doing everything he can to mitigate his involvement, to make it seem like he was,
Right.
in this under duress. Okay, so Crystal Connolly does not like the music. Nick, you guys can blame Nick Blackhall. He is the maestro of the music.
Nick has
he
the
picks
aux
the music.
chord.
So if y'all got some better suggestions, y'all need to. Because I don't know. I don't have anything to do with the music, folks. I think we did change the music from the last trial that we did. Edna Carter wants to know what's the maximum sentence if he's guilty on all counts. Well, what they would, 99. And if they're going to find him guilty, then they'll find him guilty. Because if you find him guilty of the engaging in organized crime, then you're finding him guilty of those lesser included as well. Of lesser included being murder and aggravated kidnapping.
They're bringing him out.
Yep, they're coming in. I'm guessing we're about to see this verdict.
He didn't seem
I'm
too
sorry.
pleased.
Cheryl does not like the music. I don't know, guys. Somebody wants Billy Joel. I'm guessing there's copyright involved on that. Probably
Yeah,
cost us a lot
she
of money to
gotta
do
get
Billy
sued.
Joel. Dizia Johnson wants to know when's the next trial. One of them is scheduled to go on trial in June. Let me see who that is. Laquan Wilkerson is scheduled to go on trial in June. And then Devontae Owens is scheduled for July. So, we'll see what happens there. Makeup of the jury, it's 7 women and 5 men. It's a typical Dallas County jury. It's very racially diverse. I mean, it's pretty typical. Okay, so Queen Pudding does not want Billy Joel, guys. Okay, all right, we're about to cut the mics because we're about to get a verdict.
Please be seated. Members of the jury, to maintain your anonymity, I'll be referring to you by number instead of by name. No disrespect intended. Jury number 6, has the jury reached a unanimous verdict?
Yes.
Is your verdict as follows? We, the jury, unanimously find the defendant, Desmond Armand Jones, guilty of engaging in organized criminal activity as charged in the indictment.
Yes, sir.
Would either side like to have the jury polled?
No, ma'am.
No, Your Honor.
All right, then, ladies and gentlemen, we're going to go straight into the punishment phase. What says the state?
The state's ready, Your Honor.
Please proceed.
Your Honor, I'll waive opening statement at this point, and I'm ready to call my first witness.
Thank you.
The state at this point calls Shavon personally to the stand. Family and about a little bit about who Shavon was. Tell me what kind of kiddo she was.
Shavon was real outspoken.
How was she with her older sisters and her little brother?
Oh, she was the boss.
What do you mean?
Shavon was the boss.
What do you mean when you say that?
No, she kept them in line. You would think she was the big sister. She acted like she was the big sister, but she wasn't the big sister.
What was
she
what was
kept
the
them
age
in line.
difference between Shanice and Kayla and then Shavon?
Okay, Shanice and Kayla are 18 months apart, and you got Kayla and Shavon were exactly 2 years apart, almost a little bit off, but a little bit over 2 years apart.
Talk to me a little bit about, I want to focus on the kids first and then talk about you. Has this crime affected your entire family?
Yes.
Would it be fair for me to say that y'all have a large, great, close-knit family?
Yes.
Many cousins, aunts, uncles, granny, everybody, right?
Yes.
Has everybody been hurt by this?
It really has. It has affected our family in so many ways, especially when you feel like, with us being who we are, we're supposed to be able to protect our kids, our nieces, our nephews. And with this happening, it's like we wasn't able to do that. We couldn't do our job. It was nothing that we could do because we didn't know what was going on. It was just a matter of trying to figure out what's going on. How can we get her back? We gotta get her back. Y'all, we gotta get her back. And we never got her back. They took her from us. And we miss her every day. Every single day I think about it. It's not one day when I don't think about her. My babies, I stay strong for them. I stay strong for my babies because my son, he lost his best friend.
So, hold on, Shaquana, let me ask you about that. And Judge, may I approach? You may. You said CJ, your son, right?
Yes.
Were he and Shavon close?
Yes.
Has he struggled with this every day since we lost her?
Every day. That was his basketball buddy whenever they wanted to go down to the basketball court. Just as kids, every weekend we went to different parks with their daddy and they watched him play basketball with his cousins and stuff. And it's like, it was just, we had a park right around the corner from where we stayed. Everybody in the neighborhood knew who Shavon was, and it was like, once he lost that friend, like, I mean, I know that was his sister. I know she wasn't no boy, but it was, Shavon just felt like if the boys can do it, she can do it. She can do it, you know, and she wanted to go play basketball with him every day. She'll be out there in the yard just tackling them down and everything. And it's, I mean, we took a big loss. We did, we really did.
Talk to me a little bit about Shanice and Kayla. Have they also, I mean, obviously everyone has struggled with it, right?
done got really kind of strong in her ministry. She's dancing for church and everything. She's gotten a little bit stronger in that, you know, she's kind of took it there. And when you see her dance, I mean, it's amazing. You'll see it all in her. And
when you say dance, it's praise dancing, right?
yes,
Which
yes.
is a way to...
She call it ministering, yeah.
Right, so to minister within your church, right?
Yes.
And then talk to me, so that was Shanice. Tell me about Kayla.
Kayla, like y'all know, she's a senior this year, so it's hard for her because she wants her sister here. She wanted her sister here to see her graduate. That's basically the plan, you know. But, you know, and Kayla, I think Kayla's really the one that kind of bottles it in. You know, and that's what really hurts me the most, when you want them to talk about it, but they don't want to talk about it, because when you talk about it, it brings back so much, and then you just keep questioning. And, you know, I know we're not supposed to question our God, but it's like, why? Why take something that is just so... She wasn't nothing but 13, y'all. She was 13 years old. That's it. My baby had just turned 13 years old, and they took her away from us. Her sisters never are going to get a chance to get her ready for her little homecoming dances or for her prom. We not going to get to see her walk across the stage at her graduation, and she not going to get to see her sisters and her brother walk across the stage for their graduations. And I feel like it's just not fair. I feel like it's just not fair. Y'all took away from us.
Judge, I'll pass the witness.
We have no questions, Your Honor.
Your Honor, at this time, the state would re-offer all of the evidence from guilt, innocence, and rest.
Thank you. Mr. Fishburne?
May I see who I have?
Yes, sir.
Yeah. May we approach the bench?
Yes, sir. Ladies and gentlemen, I'm going to briefly retire you to the jury room. Please don't run off, because we're going to probably bring you back shortly.
All rise.
Okay, so folks, you can see the lawyers are up at the judge's bench, about to do a sidebar. The jury's been sent out of the room. I don't know if they're about to do a hearing or what, but obviously we've just heard this jury's verdict. They have found him guilty of engaging in organized crime. The minimum sentence he can face is 15 years and up to 99 years.
For the record, the gallery may be seated, please.
Okay, so I think we're about to have a hearing of some sort.
We're on the record outside the presence of the jury. Let the record reflect Mr. Jones has been sworn. Mr. Fishburne?
Mr. Jones and I have talked about him testifying at the punishment phase of the trial in case that occurred, and now that it has. Mr. Jones, is it your decision not to testify? That is your decision, is that correct?
I can't hear him.
Are you going to testify? Yes or no? That's all we have on that.
Thank you.
And our witnesses are in fact here.
All right.
So we are ready.
Okay.
I'm sure he was a nightmare to work with for his attorneys.
So it looks like he's elected not to testify?
That's what it appears to look like. It's really fascinating.
Out!
Or is he gonna?
You sit down. Jones, sit down. Sit down.
Tell him jump, nigga. Jump.
Oh, wow.
Sit down.
Yeah, they talk. Read.
So Jones seems to be clearly aggravated. I mean, his body language was very interesting since the. Here we go. The jury's coming back in.
All right, the jury's coming back in, guys. Let's listen to what's happening.
Please be seated. Mr. Fishburne, please call your witness.
May I proceed?
Yes, sir.
Call Dominic Jones.
Good afternoon. Please raise your right hand. You do solemnly swear or affirm that the testimony you shall give in this cause will be the truth.
I do.
Thank you.
May I proceed?
You may.
Would you please state your name for the record?
Dominic Jones.
And how are you related to Desmond Jones?
He's my older brother.
And how old are you?
23.
I'm sorry?
23.
Tell the jury a little bit about your brother, your relationship with your brother.
Desmond is my older brother, and we have a great relationship. And
Ma'am, I'm sorry to interrupt you. Would you pull that microphone closer to your mouth, please? Thank you. Yes, thank you.
he's my older brother, and we have a great relationship. And he's always been there for me, and he's always been protective of me, and been protective of me, as well as our other siblings. He's always a person, like if I ever needed anything, or if I was ever feeling some type of way, or just anything, he's always been there for me. He's always been somebody who I can count on, who I can call on, and through everything. He's a person that's a happy person. He's not evil. He's not somebody that will do stuff like this, what happened. Like, that's not the type of person he is at all. He's always been somebody, when you see him, that he goes above and beyond for the people he cares about and protects. And he's just, I've never been some feared or seen him that violent or nothing like that. That's not the type of person he is at all. He's not that type of person. He's always been there for me. He's always been somebody.
Throughout this period of time, this case has been pending almost 3 years. Has Mr. Jones expressed concern about still protecting his family, still being kind to them?
I'm going to object that calls for hearsay.
Sustained.
She don't even matter no more, bro. She fuck them, I swear to God. Mom, I don't need. Really tell me, I swear to God, I don't need. Y'all, please, this shit.
I'm good. I'm good.
Can you tell if we have the mic in the holdover? If we have the mic on in the holdover?
Walk around and see.
Yeah, would you go ahead?
All right.
Ms. King, would you come up here a second?
Wow, folks, I'm going to talk here for a second while we're waiting to see what happens. That's, wow, Justin, I don't think I've ever seen. Okay, wait a minute, the judge is starting to talk again. Hold on.
Yeah. Chambers, please.
Yes, Judge.
We'll go in chambers.
Judge, do you
Clearly
want
the judge is
to
not
just
happy.
stay put?
She can stay put if she doesn't mind. If you'll just stay there, please.
She's telling the sister that she can stay on the witness stand for now. The jury's been sent out.
Oh my.
Have you ever seen anything like that, Justin?
I haven't seen anything like that except for maybe on court TV.
Yeah.
That's a highlight right there.
Wow. I mean, you know, obviously, you know,
Right.
the jury finds him guilty. Then Shavon's mom goes on the stand. You guys noticed that Shavon's mom opted to have her face obscured
Right.
this time. But I mean, some very emotional testimony from
Right.
Shavon's mom. You know, basically telling you know, Desmond Jones she wasn't nothing but 13. And basically, you took away my baby.
Right.
I mean, it's heartbreaking to listen to a mother, and then, you know, you see Jones starts to react in the courtroom, and the judge yelling at him, "Sit down, sit
Right.
down."
I mean, Shavon's mother had every justification to get up there and confront one of the people who killed her baby. you could see his body language from when the verdict was read up until now. It's like he was bubbling. It was almost like a volcano.
Well, it's hitting him. I've
Right.
been found guilty. I'm potentially going to go to prison for up to 99 years.
All right, I'm at least going to be there 15. He knows he's not going home anytime soon. I don't know what his attorneys talked to him back in the holdover, said to him back in the holdover cell, but even when his attorney got up to tell the court that Mr. Jones wasn't going to testify, you could see how distant he was from the attorney, how he wouldn't speak up and say, I do not want to testify in guilt or innocence. When I saw that him and his attorney had a disconnect. And once you as an attorney lose your client, you don't know what your client's
Did
about
he
to
really
do.
think he was getting off? Did he
I don't
think this
know.
jury was going to find him not guilty? Really?
I don't know. I mean, from what we just saw, I think he thought that he was going to get off. And a lot of times, and I've never been in that situation before, but I've had plenty of clients, they think that they're going to get off for the crimes that they committed. They think that there's something there that's going to provide them an opportunity of, going home at the end of trial. Maybe he was in denial. I don't know. But what he just did in front of the presence of the jury, I don't see how his attorneys can rehab that.
Well, no, they can't.
He was tackled by 3 officers, maybe 4.
Several, and taken out of the courtroom. For those of you who came in a little bit late, y'all may want to rewind and go watch this part that we just saw, because it was something that I can't recall in a long time. Well, I don't know that I can recall it seen in a courtroom, actually. He initially gets upset outside the presence of the jury, and the judge tells him to sit down, Mr. Jones. And then when the jury's brought back in and his sister's on the stand and she's saying, we have a great relationship, he's always been there for me, he's not evil, and then all of a sudden, I'm just going to say it, all hell breaks loose, and you've got multiple, bailiffs taking him out of the courtroom and in the presence of the jury.
What he did was he nullified his sister's testimony. She starts to say that he's loving, he's family oriented, and he explodes. Everything that she was getting ready to testify to, it's not going to matter. I don't see how he gets rehabbed at this point.
Well,
I don't know.
Because the jury saw that. The first time the jury didn't see what happened, but the second time, when he's being physically restrained and taken out of that courtroom, how
they
mad?
dragged him out.
How mad is Judge Holmes right now? What does she do?
Judges are ringmasters, they're umpires, they're referees. They need their courtroom to operate with a sense of decorum, and that showed everything but. Judge Holmes is a professional. She's a great judge. I think she'll be able to pivot from that point and get everything back under control. But I'm really just concerned for defense counsel and how they're going to approach what just happened. You got to provide your attorney every opportunity to fight for you.
Well, and he just made that really hard.
He just made it almost, it's incomprehensible what he just did.
Did he just show, and then this is what some people I think out there in our YouTube jury would argue, did he just show his true character there? He certainly didn't show a lot of smarts.
I would hate to say that he showed his true character, because in that moment that was extremely traumatic for him, being convicted of a murder. But nevertheless, whether it's his true character or not, that shows something about who he is.
That anger, you could just saw the anger just.
Right.
Because throughout the whole trial, he's largely been sitting there quietly, very little emotion, very little reaction from what I saw. That's the first time.
Guilt or innocence is for the defense team when they,
you're trying to mitigate.
They're mitigating, they're providing redeemable qualities and characteristics. He just worked against his interest.
Okay, I think the judge just walked back in. Mocha Love 98 would like me to go interview Mr. Jones and ask him why he didn't have that much anger and energy when the baby was being taken away from her home. And you got to wonder, the jury's asking that question too.
Yeah. Wow. This is. And I just saw one of the YouTubers. They made a comment. Mr. Jones basically provided all of the statements that got him into this position. And now, during guilt or innocence, that might be the final. He provided the final nail in his coffin, so to speak. I mean, he has worked against his interests throughout the entirety of this investigation, now up until the point to where he's getting sentenced.
I mean, at the moment when he needed to show contrition, I mean, his sister's on the stand when this happens, and she's trying to show him as
She's trying to save his life.
Well, I mean, he's not, folks. He's not facing the death penalty. But
Well, not-
if you get
right.
99 years, that you're spending the rest
That's a
of your
virtual. That's a virtual death sentence in jail.
We're back on the record outside the presence of the jury. Do I have any objections from the state or the defense to continue the hearing with Mr. Jones in custody in the holdover with amplification of the proceedings in the courtroom going back into the holdover? Any objection from the state? Any objection from the defense? All right, we'll proceed that way then. Members of the gallery, the court will not accept or tolerate any outbursts of any sort from the gallery, any gestures, any words, certainly any comments. If that happens, I will hold you in direct contempt and you will go into custody today. Thank you very much. Will the bailiffs get the jury, please? Yeah. Mr. Adams, can we make sure that there's amplification back into the holdover, please? You can't? I don't.
Thank you, darling.
Okay, so what we just heard is the judge is going to have it to where he can hear the proceedings, but he'll be remaining in the holdover, and so he's not going to be present in the courtroom. And she asked both sides if they objected, and it sounded like neither objected.
Right.
So if I'm the defense, I don't want him brought back in.
Well, you know what? I would have went back to go talk to him before we agreed to that if I was his attorney.
Well, presumably, I'm assuming they did, but
Well,
I don't know. Maybe not.
We saw what happened, so he got carried out, and then they almost immediately went back to chambers.
Okay.
Yes, please. Oh, here it is.
All right. Okay.
The button is pushed up here.
That's good.
Which one are you looking at? For this blue one, it says holding cell. That's been overridden. Oh, okay. So none of these mean anything anymore?
All right.
Whoa, we're not ready yet.
Go ahead, Judge.
Testing.
It works.
Can I have just 30 seconds? I'm gonna go get a couple more call the bailiffs. Since everybody's
Yes,
settling
thank you.
in. I've got a whole.
Are we ready, Gomez? Do we have enough bailiffs on hand?
Yes, ma'am.
All rise.
Please be seated. Members of the jury, to prevent any further disruption, we're going to continue the hearing with the defendant in a holding cell. There is amplification back to the holding cell so that he can hear the proceedings. Mr. Fisher, please proceed.
We pass the witness.
Thank you.
Judge, I have no questions for Ms. Jones.
Thank you, Ms. Jones. You may stand down and you're free to leave the courtroom or stay. So, as
Defense rests.
what's his estate?
State rests and closes, Your Honor.
It's closed.
All right, members of the jury, that means that you've heard all the evidence that you will in the guilt-innocence phase. In the punishment phase. As we did in the guilt-innocence phase, I'll read you the charge of court. You'll hear argument of counsel, and then you'll retire to deliberate on the punishment phase of the trial. Charge of the court. This is a relatively short charge. Charge of the court. Members of the jury, by your verdict, you have found the defendant, Desmond Jones, guilty of the offense of engaging in organized criminal activity as charged in the indictment, and it has been determined, as provided by law, that the jury shall assess the punishment of the defendant. The court has received and accepted your verdict of guilty, and you will no longer concern yourselves with the innocence or guilt of the defendant, and shall now limit your deliberations under all of the law and the evidence in this case to the question of punishment, which it is now your duty to assess. Our law provides that a person convicted of engaging in organized criminal activity shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice for life, or for any term of not more than 99 years nor less than 15 years, and an optional fine not to exceed $10,000 may be imposed. You are instructed that engaging in organized criminal activity, the offense of which you have found the defendant guilty, is a first-degree felony. Under the law applicable in this case, the defendant, if sentenced to a term of imprisonment, may earn time off of the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less, without consideration of any good conduct time he may earn. Eligibility for parole does not guarantee that parole will be granted. It cannot be accurately predicted how the parole law and good conduct time might be applied to the defendant in this case if he is sentenced to a term of imprisonment, because the application of these laws will depend on decisions made by the prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. You are instructed that in determining the punishment in this case, you are not to discuss among yourselves how long the defendant will be required to serve the sentence you decide to impose. Such matters come within the exclusive jurisdiction of the Board of Pardons and Paroles and the Governor of the State of Texas, and are no concern of yours. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this phase, the defendant has elected not to testify, and you are instructed that you cannot or must not refer or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever as a circumstance against him. You are further instructed that your verdict must be unanimous and shall be arrived at by due deliberation and not by drawing lots or any other method of chance, nor shall you add any combination of numbers together and divide the answer thereto. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court and be governed thereby. It is signed by me, Tracy Holmes, Judge of the 363rd. The final page again are the verdict forms, and they read as follows. We, the jury, having previously found the defendant guilty of the offense of engaging in organized criminal activity as charged in the indictment herein, now assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for life, and you can add an optional fine up to $10,000. Or we, the jury, having previously found the defendant guilty of the offense of engaging in organized criminal activity as charged in the indictment herein, now assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for, and there's a blank for you to enter a number between 15 and 99 years, and a fine again, any amount up to $10,000 or none. Ms. Falk?
Judge, I'll waive my right to open and reserve my right to close.
Mr. Lehman?
Yes, Your Honor, may it please the court?
Thank you.
Ladies and gentlemen, so what to say? I will just say that obviously Mr. Jones is a troubled young man and needs some time to think about things. I think he needs some time for quiet contemplation, where he is in his life and why he finds himself here. He is 22, we'll be honest. I think that what we should do is think about putting him in middle age so that when he gets out, we don't have to worry about further behavior like you saw today and like you found him guilty of 27. So I'm going to ask for 20. And I'll leave it to your grace and discretion.
Thank you, Mr. Lehman.
Thank you, Your Honor.
Ms. Falk?
May I proceed, Your Honor?
You may.
I have this entire closing argument thought out, right? And we're going to get to it here in a minute. But what I need to start with, what I have to start with, is what I knew we would see at some point this week. It was the Desmond Jones that I know. When someone shows you their true colors, it is on us to believe them. Him at middle age is just as scary as him now. Him at 40, him at 50, him at 60 is just as scary as him now. Because I cannot imagine it's worse than the one that you all have heard this week. If you are involved in the murder of a 13-year-old girl and you never show remorse, you know what should have happened? Not that. His poor sister, who had to come testify for her own brother, should have been able to say nice things about him, and that couldn't even happen because he is who he is. And I am done talking about him. He doesn't deserve one more minute of our time. They do. They do. CJ, Kayla, Shanice, Kiki, Dee, Shaquana, Brittany, Charles, Rosina, every other aunt and uncle and grandparent and husband, they deserve our attention. Shaquani told you exactly what I was going to tell you without me knowing that I was going, or her knowing that I was going to tell you that. Shavon will never be able to go to homecoming. She won't get to watch YouTube videos to figure out how to do her hair and makeup with her older sisters. She will not get to go with us to Kayla's graduation. She will not get to help us box up Kayla and get her ready to go to UTA next year to start the nursing program. She will not get to spend Christmas with Shanice. She will not get to go play basketball with CJ. And it is because of Desmond Jones and the rest of that crew. The only thing left for each of us to do here today is to end it. And it is to end it with an exclamation mark to this crew, to this clique, to this combination. It is to end it with an exclamation mark to all of our community, so that if anyone else out here in Dallas County thinks that the way they're going to get back their money from a dope rip, that they're going to get back their inventory from a dope rip, is to take a kid, that we will not tolerate that. There is literally no reason to give Desmond Jones anything other than life. There's just not. I know that that is a hard thing to do, but in this case, it's easy. Because at what point do we want that man who can't even be part of our proceedings anymore, That man who was so dangerous that he involved himself in all of this, and you have agreed that he did that. And he solidified that we did the right thing in convicting him. At what point are we comfortable with him being back out? There's not one. So we end this today by giving him a life sentence because there is no reason to show him mercy. The only reason to show him mercy is to show that you are a decent human being. And the way that you do that is by assessing no fine. So you sign that first piece of paper, the first paragraph with life, and right here, you write none. That none shows that you are a good human being. That none shows that you give mercy when mercy is not called for. Because you know who wasn't shown mercy? Shavon Randle.
Members of the jury, we stand in recess until you've reached a unanimous verdict in the punishment phase.
All rise.
Okay, so the jury has now retired to the room to deliberate Mr. Jones's fate.
Please be seated. The gallery may please be seated.
Oh, let's see. Is the judge going to say anything? Hold on one sec. Don't turn off the sound yet. Let's listen. Okay, I think they're just going to, I think there's just some movement in the courtroom. I don't think there's actually going to be any more proceedings while we wait for the jury to come back. Wow, there's just a lot that we've heard since this guilty verdict came back. I mean, really, frankly, a lot, pretty shocking. And again, if you guys are joining us late, you should go back and re-listen to what happened in this courtroom after this guilty verdict came out, with Mr. Jones having to be physically restrained and led out of this courtroom.
Oh my.
Basically, what I gathered, it was hard to hear the defense attorney, but what I gathered was that he was begging the jury for mercy and asking them to consider that one day Mr. Jones will be an older person who may not be the same person that he is today.
Right.
And Jen Falk saying basically that that they needed to render a verdict and that not think about him anymore. They actually put up on the screen, let's end this today. And then the last thing that the jury would have seen is this this puzzle with these missing pieces.
Right.
So, you think this jury's going to be out long?
Oh my! I mean, this is the hard part about administering justice, right? Justice has to be even-handed, unbiased, and provided in a very even way, regardless of what you've seen or what the crime is.
Yeah, the jury's going to go back in there. They're going to think that guy, he had to be let out and restrained by deputies.
You're right. And I would have liked to see his attorney fight for him a bit harder than what he did. I mean, he went up there subdued, hat in hand, basically saying that, look, I got no more for you guys. Just show some mercy.
I think that's...
I would have, no, just hear me out. I would have liked for that attorney to go up there and say, look, this looks bad. This is terrible. But get into some statistics. At this point, this is where the sentencing statistics matter, right? Brains don't fully develop until age 25. The Sentencing Project stated, and this is through data.
That's true.
This is through data. People age out of criminal conduct by age 55. You know, so I think this is the time where you really hone into that and say, look, if we're really serious about ensuring justice is done, if we're serious about ending mass incarceration, as I know Jen Falk is serious about that because I've talked to her about it, you know, we need to really try and find the middle ground here. I know what Mr. Jones just did was terrible. I know what he got convicted of is horrendous. I mean, he's involved in criminal activity, and it involved the kidnapping and the murder of a 13-year-old girl. And what he just did in court did not help him at all. But he shows he's in dire need of rehabilitation.
That's true.
But is he? Do you think he'll be able to get that? Now, and like I just said, the data suggests that people age out of criminal conduct by age 55.
Well, and there's certainly studies that have shown that, and and I had a cousin who committed a horrible crime in California, and was sentenced to, I think it was 25 to life. And because of changes in incarceration practices in California, he ultimately was paroled after 20 years. And I know that Tommy is a different person at 40 than he was at 19. Well, and there's certainly studies that show and he committed an awful crime, shot a man during a dope deal, and did ultimately get released. I mean, but he was a very angry young man the first 10 years or so, and was where he needed to be. So, you know, I don't know. I get what you're saying, but I can also see this jury seeing what they saw and just going back and saying, you know, we're gonna lower the boom on him.
Well, the jury, they're not sentencing experts, so I can definitely see them going back, taking what they saw.
That's where a good defense attorney would.
Precisely, and I think his. You know, earlier I tried to be a bit more even in my analysis of the attorneys and how they presented their case, but how he went out there and fell on his sword without trying to swing it at all. His client needed him more than ever at that point.
Right.
And I believe he failed him in that moment.
Well, you know, you had Desmond's sister on the stand, and they could have opted to let her continue testifying.
Right.
Why didn't they?
Exactly.
I mean, there's no harm.
There's no harm in it.
Why don't you put his mother on the stand?
I mean, there's nothing worse that could happen at that point. You know, so, and I would have liked if I were trying this case, I would have asked for some time to get back and kind of gather myself as an attorney. Because, I mean, that shakes you. I'm sure it shook
because once this jury renders a verdict on what the number of years he's getting, it's not going to change.
It's not going to change. I mean, so, you know, admittedly what he did was terrible. And I'm not arguing against that. If anybody that's watching this and they're saying, oh, how can you say that he doesn't deserve a life sentence? I'm not saying that he doesn't deserve to get punished. He clearly does. He clearly needs rehabilitation. Now, what Jen Falk said, a good human being, she referred to what a good human being would do, and the implication is lower the hammer. I don't think a good human being would do that.
But you are right that there are a lot of studies that a person at 20 is not necessarily the same person at 40 or 50 years old.
Right.
And I did see that with my cousin. That,
right.
You know, and I've in his case, I read his parole paperwork. I mean, it was a pretty awful crime. Certainly not on the level of kidnapping a 13-year-old girl and being involved in the killing, and you know that. But and I know in his particular case, he now actually works for a juvenile justice nonprofit trying to help kids like he was once.
And I'm sure he's effective at what he's doing.
He is, and he was, you know, he had a meth addiction, and he was selling drugs to feed his meth addiction, and he killed a man.
Right.
And it was, I mean, in my family, it was very, very hard, you know, because when that happened, I remember my aunt didn't want anybody in the family to know for quite some time because she was embarrassed by what had happened. But so, I mean, obviously you can see folks here basically saying he doesn't need rehabilitation. I mean, there's a lot of anger. I mean, look, this is a 13-year-old girl. I get it.
Right.
I mean, I've talked about this before. I have an 8-year-old.
Right.
And if somebody had done this to my child, I don't know if rehabilitation would be I think would be on my mind.
Yeah, but you wouldn't be in the jury.
No, I would not be on the jury.
Look, I understand why folks wouldn't agree with my position, but you know, at the end of the day, and I think overwhelmingly, people in this country have stated that we need to end mass incarceration. And one way you do that is making sure you don't overly incarcerate.
Right.
Incarceration is supposed to serve as rehabilitation. If this person, when he's 45, 50, can show that he doesn't harbor the same type of, you know, criminal mens rea that he obviously has shown today, then he deserves the opportunity. I'm not saying he should get out, but he deserves the opportunity to go to a parole board and prove that he has been rehabilitated.
Right, and I would encourage you folks out there that are watching this, it's really worth going out and reading the research on this. That there are a lot of studies that show that our brains are just not fully developed. I mean, I know when I was I made some really stupid decisions when
Right.
I was 20 and 21 years old. Certainly not on the level
Right.
of anything like this, but just dumb decisions.
Right.
And your brain and your personality does change over time.
And what Jones has stated throughout the course of this investigation is that he's a follower.
Right.
He was low on the totem pole. He got roped into this.
I don't even think even the prosecutors would disagree with that. They're not
Right.
certainly not trying to paint him out to be the kingpin.
Right.
Kingpin of this
Right.
thing.
He showed that he's a follower. He can't make decisions for himself, and he's emotionally unstable.
Right. Okay. So let's recap here, because we've got folks that are joining us who weren't seeing what happened earlier. If you didn't see what happened earlier, I really encourage you to rewind to the beginning of the punishment phase, or when the jury came back. Okay, so let's back up. So the jury comes back, they find him guilty of engaging in organized crime, and then we're immediately going into the punishment phase of this trial at that point. And so then we had Shavon Randle's mom took the stand. She requested this time to have her identity obscured. I'm not sure why. But she did, and it was a very emotional testimony from her, talking about that Shavon wasn't. She says she wasn't nothing but 13, and she talked about how that she misses her every day, and how this has devastated their family. And then she also talked about, I think she was talking, in my sense of it, talking about the guilt you feel as a parent. We're supposed to protect our children, and she felt, she says we couldn't do our job. How could, and then she talked about the terror they felt when they were trying to get her back. I mean, Can you imagine those days when your child has been kidnapped and you realize this is going on?
I see moms losing when they lose their kid at the grocery store. So I can only imagine. I mean, it was really tear-jerking when she got up there and was talking about her daughter, and just the sheer terror that she
wish I could have
experienced.
saw her, because I could hear her pain, but I wanted to see her.
Right.
But I understand. It's this, but it
But
was.
how? I mean, she was brave to get up there and explain that odyssey that she went through. I just feel so bad for her.
Well, no parent should have to go through the loss of a child. Okay, Vixie P, we will recap it. Okay, so I'm walking us through this. So then the state. Okay, so folks, we had the mother. She testified, and then the state rested, the defense rested, and then all of a sudden the jury's not in there, and there's this outburst, and the judge is yelling, "Mr. Jones, sit down. You sit down." And I don't know about you, I couldn't understand what he was saying. I haven't had a chance to go back and replay it and try to listen to it closely. So if any of you folks have replayed
no,
it,
the outburst was in the presence of the jury.
there was the first one wasn't.
Right, the first one, I believe, he was telling the judge that he elected to not testify in guilt or innocence.
Oh, was that what that was? Okay. Yeah.
But the way he was communicating to the judge was very disrespectful. He wasn't.
And Judge
he wasn't
Holmes is
speaking
not
up.
going to put up with that.
No, she's not.
She's not going to play, and that's clearly so. Anyway, so we had that first little outburst, and again, that was outside the presence of the jury, and so then the jury's brought back in, and his sister's on the stand, and certainly jump in here. You went back and looked at some of that. Walk us through that. So the sister takes the stand.
So his sister takes the stand. She is trying to redeem her brother, and you can see how desperate she was in making sure that she showed that his character wasn't as the character that was displayed during the trial. She was saying how loving he was, how much he cared for his family, how much he supported her. And,
I wrote down, she said, he wasn't violent or nothing like that. That's not the type of person he was.
That was the last thing she said.
Right.
That was the last thing she said. She said that he wasn't violent. And almost immediately, he contradicted that. Just on the turn of a dime.
But I just don't know why. There was an objection from the prosecutor.
It was an objection
about something.
Well, I think the whole time, and like I mentioned earlier, I could see Mr. Jones, he was just brewing under his collar since the conviction was read out. I mean, you could just see him, how he was squirming in his chair. You could see how he was interacting with his defense team, how distant he was from them.
Right.
I mean, I think the whole time he's just sitting there, and I think he just got to a breaking point.
Is it maybe just that the reality? I mean, did he really think I'm going to walk out of this a free man? Did he really have that in his head?
Well, whenever you make the decision to go to trial, you're thinking that there's a possibility that you can win, right?
Right.
So, I mean, I'm pretty sure he had that, in the back of his mind, thinking that, all right, we're going to go to trial. I got 2 attorneys that are pretty good.
And these are good attorneys.
Their record speaks for themselves. I have some issues with how they tried this case, but
it seems like they got rattled too.
Yeah, they got rattled.
They got rattled, and they're like, oh.
I'm sure they might have seen that before. I don't know. They've been practicing for a minute, but that is something that doesn't happen every day.
No.
That courtroom's going to be buzzing about that for a while.
Oh, absolutely. And so then, he has this outburst, and his sister is, saying Desmond.
Right.
And you had at least 3 bailiffs that had to take him out of the courtroom. And then the decision is made that they're going to leave him in the holdover, but have him have audio so he can hear what's going on. And they both sides agree with that. And I'll be honest with you, I thought we were going to continue with testimony.
Yeah.
I thought, okay, they're going to put the sister back on. We're going to hear some more from the sister. She's going to say,
how great of a guy he is.
He's a great guy. I'm really, he's under stress. It was something.
Right.
Something. I just don't understand why you decide.
The defense should have asked for a 15-minute recess or longer.
Why don't you put his mom on the stand? I just.
All right. Well, before you make any decision, you just take a step back and say, look, we need to talk about this. Because I didn't see them going back there to confer with their client. I think after they took him into the holdover room, they immediately went back in the chambers. And that's when the decision was made.
So Kimberly Munoz is saying he was shouting at someone in the seats. Yeah, I think that was Kimberly. I think that was on the first outburst that he was yelling at someone behind him. I couldn't tell exactly what he was saying, but that first outburst is the one where the jury's not in there, so they didn't see that. They saw the more serious one.
Yeah.
And then we had the defense basically say, and again, I had a hard time hearing the defense attorney, but I heard him say something about that, you need to give Mr. Jones some time to think, but not
right
the remainder of his natural-born life, in other words.
Right.
But it was pretty short.
That's essentially what we've been talking about. The statistics say that, being in prison for your entire life is not going to serve any real fundamental purpose. But I still would have liked for his defense team to try and rebound from that. They didn't even.
It's like they gave up.
Yeah. Like they threw in the towel. If you look at it like it's a boxing match, they felt like that was just, he was getting brutalized and they just wanted to put an end to it.
Rebecca Kamishka asked, can he use this outburst for a retrial?
No. No. He can file an appeal all he wants, but I don't see an appellate court or Judge Holmes using that as a basis for a retrial.
Katie Spagnola says that she thinks he was mad at his attorney.
Oh, yeah. I think there was some issue there. We saw the distance that they had between each other when he elected not to testify. That body language, it spoke volumes about how he felt about his attorneys. Or maybe it's just how he felt about the situation in general. But, he wasn't a man who was too happy in that moment.
I just have to think maybe he had somehow made himself believe that he was not going to get convicted.
Yeah.
That maybe he thought that the jury...
That's why he went to trial.
Yeah, he thought, I'm going to get found not guilty. Hey, Tasha, did we ever determine exactly what he said? No. Well, sorry, guys, I'm trying to figure out if we ever heard.
I can explain some things, but it's going to take too long for me to do while you're talking.
Oh, I could put a mic on you if you want to get over and explain it to folks. Come on.
Come on, Tasha.
Come on, Tasha. Tasha's got a T-shirt on.
Three's a party.
She's being difficult. And can you send me an email? Gosh, I'm sorry, guys. I'm just trying to figure out, because it's like it all happened so fast that and you have to put earphones on to really try to figure out what was being said. Do you think that this jury's going to come back pretty fast? I feel like.
Yeah, they came back with a quick verdict.
2 hours for guilt innocence, and given what happened in The punishment phase, I have a hard time believing they're going to be out very long.
Yeah, I mean they're going home tonight at the end of business hours.
They may go home before that.
They may go home before that.
It's 3 o'clock. I'd almost be surprised if we're still here at 4.
Right. Right.
Yeah, Maria Amador wants to know, what did he say, Tasha? Yes, Tasha needs to answer the questions for us. Well, she's going back to try to look, and people are saying, Teak McQueen says, come on, Tasha. Folks are wanting to know exactly what was said.
Yeah.
I have the chants going. Tasha.
Exclamation
People want
points.
to know. Chris Murphy's asking about contempt of court. I mean, I don't see who you would hold in contempt of court. I mean, he's going to prison. He's going to prison, so I don't know. There's not really much more you can do to him over for the outburst.
I mean, he's going to get penalized for the outburst. It's going to be by the jury.
And then someone, J Max Boom, saying there are family members here. Can we please be more respectful? Look, I apologize. We certainly are not trying to be disrespectful to Shavon. Her. She is, and I've said this before and I'll say it again, I wanted to do this with this trial because this trial, I mean, this case should have made national news.
Right.
No 13-year-old child should be kidnapped and murdered.
Right. Right.
The way this little girl was.
Right.
She deserves every bit of attention that we're giving this trial.
Let's explore that. Why didn't it make national news? Why do you think that's the case?
I'll ask you that question.
You know, I mean, I've covered cases that have gotten national attention, and I've covered cases that have only gotten local attention that I felt should have gotten national. And it pains me to say it, but I think the fact that is this
a 13-year-old white girl?
If it was a 13-year-old white girl, or if there was a white or black element involved, I think more people would have been attuned to what happened in this case. But instead, it's black on black, so to speak. I hate using that term, but it involved drugs.
Right.
So
there's a seedy element to it,
yeah,
but Shavon is innocent.
Shavon is innocent. She, beyond all doubt, I mean, this is a 13-year-old who hasn't even lived her life yet. And she gets, I mean, tortured and executed.
I mean, that's what this was. This was an execution. You know, when you shoot somebody 4 times, you're making sure that they're dead.
Yeah.
I mean, that's just, and I can't get around. J Max Boom says she wasn't talking about us being disrespectful. I just look. I just really always want to be careful because I know because when we're up here and we're kind of gabbing, so it's sometimes easy to fall into appearing that we're not sympathetic.
Or we're cavalier.
That we're right, and and most certainly not. But
and I'll say this about you, Tanya. I mean, I've known you for maybe 3 years. I mean, you've covered some of my cases, and I watched some of the work that you do. You're extremely serious about these cases that you cover. I mean, you probably lobbied for this to be live streamed.
I did.
So yeah,
I wanted to do this case.
But one of the things about our jobs is that it's not. I don't think we get desensitized to it. I mean, we're always sensitive to it. But for folks who don't see this on a daily basis, I think we're able to kind of internalize it and still keep
it's
a level of levity.
Well, I've covered. I've been a police reporter since 1995, and you know, it does. I mean, I've read some, and you know, you've probably seen autopsy photos. I mean, I've read and seen stuff, and I know the same like a lot of homicide detectives I know, and I've known people that have worked child abuse cases. You know, it's hard, and you know, you go home and you hug your kid tighter at night.
Right.
You know, I'll go home and my son, I will hug him tighter because I mean, you know, and I maybe my poor son because I've done this for so long, he doesn't get to just go to anybody's house.
Yeah.
I mean, I am very cognizant of what can happen, and I wouldn't say I'm paranoid, but I'm cognizant.
You're cautious.
That I'm cautious, and so I think that and I did. You and I, where did we first meet on a story? Was it with?
It was the Lindo Jones.
Oh yeah, there was a young man who was shot over in Mesquite. We met at the hospital, right?
No, you met me at McDonald's right across the street from the hospital.
Yes. Yeah, I mean, I've done a lot of work. I did a series called Dying in Dallas for a couple of years, which was basically And I'll tell you, the genesis of that was that this was before we had this really big spike in murders, but I felt like we had gotten to where murders were just kind of like a brief. And I felt like that we needed to tell the stories of the families that were losing people, and that's what we did. And so I was proud of that work because I wanted to. I mean, if I ever get to the point where I don't care about people dying, then I'm probably. If I get that callous, then it's time to go do something else.
Right. No, I agree, and I feel the same way. I mean, I see folks in my line of work. I mean, they're so cold, and they get to a point to where they're just numb to all of it.
Yeah. No, it is. And I think that's also why, like, when you go to a crime scene, you'll see people standing around laughing and joking. And they're not laughing and joking at the death of someone. It's just that it's
another day.
It's a human nature to gotta, like, God, I mean, if it's like you could just.
If you get shaken every time you go to a crime scene,
you get to the point where you can't function.
Right.
So
Right.
Hey, if you guys have questions out there, I would be happy to answer them. So Venetia Davis wants to know: was Desmond's lawyers court appointed? I mean, I'm assuming
possibly.
so, but I don't know exactly.
I mean this is a capital murder, organized crime case. I think if you're.
I'm guessing that he doesn't have any money. So
right.
I'm guessing
if you're pricing it
yes.
out, that case is probably worth $500,000.
Wow.
And I doubt he paid these guys $500,000.
And I doubt they charged $500,000 to the county in Dallas.
Right. So yeah, I would presume that this was court appointed.
All right, we're on the. Nick, do you know why we're suddenly focused in on the button, or is it just? Well, they just moved back to the button, so they. I don't know. Maybe the photographer that's working the cameras just decided to move the camera. So that red button that we're watching is whenever the jury has a question or they have a verdict, then we'll see it'll show red. Mm-hmm. Folks are asking, will you cover whole trials of other people involved? I want to. The other trials, or 2 other trials for June and July, depends on if the judge allows live streaming, and it also depends on what I have going on in my normal work. My guess is that we will, if we're able to, we'll live stream them, but whether or not I'll be able to sit here and do this is another subject. We'll have to see.
The trials you guys have picked, I mean, Hess was good, but.
Yeah, we didn't do the. Christopher Hess was a Dallas police officer who was tried recently. For you guys that don't know, for the death of a woman, and he was found not guilty. So, but yeah, we did a little bit of that trial, but we didn't do the whole thing.
This was a good one, obviously.
And again, I really felt like this trial deserved, this kind of attention. Oh, okay. So Guerrero Steph 2 wants to know, why wouldn't he testify for himself? Why doesn't he testify?
Well, we just saw that he probably didn't have the fortitude to withstand cross-examination.
No.
So that probably would have been a complete debacle. And yeah, I don't think he would have served his interest.
Yeah, I mean, losing his composure in front of the jury was, I mean, it's one thing to do it outside the presence of the jury. It's a whole another thing to do it in front of the jury.
Right.
I mean, these people are going to decide your fate.
I can only imagine what they're saying back in that jury room.
Yeah. Okay. So, go ahead.
Yeah. No. Yeah. I finished my point.
Katie Spinola says, I believe he did not testify due to being overwhelmed with anger towards his attorney, which is sad. The family deserved an apology. Would it have made a difference if he'd have gotten up there and apologized?
I think it would have. If he would have got up there and showed contrition, possibly. Contrition always, kind of, makes the wound feel a little bit better, I think. But I don't think he had the fortitude to withstand that.
Well, no, I mean,
so,
when you have to be dragged out by 3 deputies, that's not really.
Right, yeah, because, I mean, so at this point, I mean, it's really a moot point to expect or want for him to go up there and apologize. I don't think he had it in him.
Okay, we got Tasha standing in front of me. Tasha, do you have the answer to my question?
I do.
Would you like to come talk to our people and tell them?
I have no way to.
I'll give you my mic. All right.
Tasha,
I'm going to hand Tasha the mic.
Making her cameo appearance.
It's not a.
Oh, you go ahead and sit down for a
I don't
second.
wanna sit. You just stay put. Stay put. Stay put. Just sit down.
Okay, I'll stand behind me.
I'll just talk to you.
Okay.
All right.
You gotta get in front of the camera though.
No, I'm fine.
Okay.
It's like
go
she's
ahead.
calling in.
Okay, go ahead.
No. So I spoke to Rebecca Lopez to get a little bit more clarity because we could watch a little bit from the videos, but it was really hard to hear everything that was going on. Basically what happened was some of Michael Titus's relatives were in the courtroom and they were basically talking smack to him, and they were saying in not friendly terms that he was a coward, that he should have said something, that he could have done more to talk to police, say where Michael Titus's body was. And so that was the first outburst that we saw. And when the judge told him to sit down, when the judge said those people needed to leave the room and keep their composure, some of them did, but some of them were still mouthing off to him while his sister was testifying. And that's why he erupted. Apparently that carried out into the hallways as well, where some of the family members were still arguing with each other.
So Desmond Jones's family and Michael Titus's family.
Correct.
Okay.
So it was interesting because you heard during the trial that they were apparently friends. The defense attorneys were saying, that he got involved because of that. He was just hanging out with his friend. So understandably, there could be a lot of anger about that. So that's what happened, everyone.
What about on the second time?
This is my T-shirt. That is what happened on the second time. You weren't listening, Tanya.
I'm sorry.
See what we deal with all day?
Sorry, I have issues.
So I think that covers it.
No, but the first one was over the Michael Titus thing. The family members.
Yeah, but some of them were still in the courtroom,
sitting
behind him, talking at him, muttering and saying, in much more explicit terms, calling him a coward. I'm sure you can think of some words that could be used for that. And so that's why he was reacting that way.
Some adverbs and adjectives to go with.
Have you covered trials involving Judge Holmes before?
Yes.
What's her general?
What's her demeanor?
Yeah.
I mean, I feel like we've gotten a pretty firm grasp of her demeanor. Yeah. She's firm.
She's tough.
She's very tough. She's a very small woman, so I'm always supportive of small people being firm. As you can see, I'm still shorter than Justin here. No, she runs a tight ship, and her bailiffs are on top of it. They took him down super fast. She wants to keep the order and wants it to move quickly, and wants to stay respectful of that. So,
what did you make of them not going ahead and letting the sister finish testifying and all that, and just going straight to closings in the end?
I mean, what do you say? I mean, Justin, what do you say at that point? What else do you say?
I don't know. Can you rehabilitate it a little bit?
I mean, she was upset too. I mean, she wasn't.
Yelling Desmond,
she was yelling Desmond, and then was getting into it with the family outside later.
Oh, she got into it with the family too?
Yes. Yeah. And that's from Rebecca, who's actually at the courthouse. So.
Oh wow.
We're just having to figure it out here.
Wow. It's a lot of hurt families today.
I mean, that's the hard part in these cases, I think, is you've got people on all sides sitting in a courtroom listening to the worst of the worst being shared about their relatives, whether it's the victim or the people involved. I mean, yes, it sounds like Michael Titus was involved. They're trying to say he was Shavon's killer, but he's also dead now, so that's a grieving family. So it's a lot of emotions. It can get really intense, and it's sometimes in cases where it doesn't get all the attention, all the publicity. I know this one has gotten more, but I mean, I've seen some people fall out at the courthouse because they're so upset.
Yeah.
Have you ever seen somebody be taken out of court like that in punishment, or like that?
Seen people taken out of court. That was pretty extreme. Usually they calm down. They calm down and they can come back in. The fact that didn't happen, that he had to listen to it, he never came back in the courtroom, I think is interesting.
You think he's in the courtroom when the verdict's read? The final verdict? The punishment verdict?
Doesn't he have to be?
I don't know. I mean, does he have to be in the room when they read the...
If both sides stipulated to him not, if they agreed to him not being there.
I feel like he needs to.
Yeah, I think he needs to be.
I mean,
at this point, any more outbursts can't hurt him anymore.
Yeah, they'll have decided. So.
Right.
Yeah.
Wow. Anything else you want to add?
No, can I leave now?
Yes, you can leave.
Somebody said they liked your T-shirt too. So.
Oh, this is actually a WFAA special. We got these made after the El Paso shooting. So
Oh, wow.
several of us are wearing it today.
Nice.
It is work related. What? Oh, yes, you can still get them somewhere. We'll share a link.
All right.
Sorry, Queen Bee says I'm not paying attention. I have a little bit of attention deficit disorder, guys, sometimes. Oh, Maria Amador. Apparently people now want you, Tasha. So they've given up on me. Well, you know, it's you wonder, like, after the first outburst, maybe should the people that were in the audience that were causing the problem, should they have been removed from the courtroom or something?
Right. I think they should have, because there was so much writing on what's going on in court. I mean, maybe Judge Holmes felt like her admonishing them.
Maybe she thought, because this is rare.
Right.
I mean, it's rare. I mean, to have a defendant be taken out like that.
Right. You know, I mean, we keep on talking about his defense team not having much to work with after his outburst, and I can sit here and Monday morning quarterback or, you know, armchair quarterback this thing to death because I'm not there. I can only say what I would have done or would have liked to have done, but when you're in the moment, I can only imagine what's whirling through your head. I mean, litigation strategy
Right.
probably goes to dirt at that point. You know, I mean, wow.
No, it is a wow. And again, for you folks that or oh, Maria's saying she's not giving up on me. She said I may have I do have other work. But I promise, guys, that on the next trials, I'm going to force Tasha to get back up here more with me. I forced. I shouldn't use the word forced, but I got her to help me out with the Hess trial. That was when you were racing through traffic to get here.
Yeah.
And she has covered all of the officer-involved shootings that we've had in Dallas County. And so she has like an amazing perspective of those cases because as a reporter, she's covered all of that.
She has, yeah. That's how I know Tasha.
Yeah, I mean she's shy of the cameras, but she knows a lot.
Right.
She's covered more court stuff than I have. My background is more as a police reporter. Even though I've covered a lot of court stuff, she actually was a courthouse reporter for the Dallas Morning News. So she just has more, you know, just like day-to-day experience covering courts.
Yeah.
And so, all right. Well, folks, if you've got questions, now is the time to answer them. We're kind of, I don't know if we're killing time.
They're saying we're better than Court TV.
Are we better than Court TV? Well, you know.
All right.
Apparently, I have the gift of gab.
There you go. Need to give her a bonus, man.
That's for sure. No, but guys, I really encourage y'all to rewind. If you're coming in now, rewind to the part where, Nick, do you know roughly where that is on this video, roughly-ish, how far in that is? When they come back with the verdict and then this whole string of events gets started. I think it only lasts probably 10 minutes. It's worth just going back and watching it because it's pretty extraordinary what happened to see two outbursts.
Around an hour and 3 minutes ish.
If you it's around is that when they start the punishment part, Nick?
That's the second one. The first one way harder.
Well, the second outburst is about an hour and 3 minutes in. If you go a little further back, you can kind of, you know, see the big, you know, the start of this when they come back with the guilty verdict, and then it starts us on this downward path. I mean, it's pretty amazing what we saw.
I mean, it shows the full range of emotions after you get convicted of a crime like that. I mean, I've never seen that.
Sorry, so clarify they have to rewind an hour.
Rewind an hour.
So rewind an hour, roughly. Yeah, go back about an hour, and you'll see it, guys. I mean, you know, when the judge starts reading, and then you see the guilty verdict, and then mom gets on the stand. Oh, Leighton wants to know if Tasha's married. She has a boyfriend, so, and I'm married, so. But anyway, Okay, so Tracy Whitehead wants to know, do you think that the jury is arguing over the actual years he should get? What do you think? Okay, what's going on in that room back there right now?
Hopefully somebody is the voice of reason back there and stating that, although he had this outburst, we shouldn't use that against him. I know.
Now you know human nature.
Yeah, I know human nature is gonna, run counter to that. But, yeah, I mean, we talked about them coming back a lot sooner than this with the decision on punishment.
I actually thought they'd be back by now, frankly.
Yeah. So I mean, I think this speaks to them actually taking this seriously. And I applaud them for that if that's what they're doing, if they're actually being deliberate about the decision that they're about to make. Because what's in front of them is life in prison.
Right. Hey guys, have y'all like cut out that part, like, and posted it separately? Okay, if you guys want to go look, we've actually pulled out that part and posted it on our YouTube on our YouTube site. Let me go back. I was trying to answer these questions. These comments are starting to roll past me pretty fast. Okay, Redneck 1 wants to know, has it ever been determined who actually killed Shavon Randle? No. No, it has not been. Desmond Jones, in one of his statements to the authorities, told investigators that that Michael Titus, who was his friend, had killed Shavon Randle because she saw his face, and that Laquan Wilkerson then was ordered by, I believe, Devontae Owens to kill Michael Titus because of killing Shavon and because of the loss of the dope.
Right.
So I don't know that they used bleach on her body, so there's really no way to ever know for sure. I mean, and you can only believe so much of what Desmond has to say.
Only so much.
Yeah. Mike Morrow says, can you replay it for us and comment? Like I said, it's you'll have to go, because of the way this feed is, we don't have the capacity to roll this back and replay it behind us. I mean, maybe on our next trial we'll get to the point where we can kind of do that sort of thing. Nick is, we'll definitely put Nick and company to work on trying to figure that out. Felicia Nickelberry wants to know, will KP, that's Kendall Perkins, get time? Okay, so for you folks that are joining us, Kendall Perkins is Ladoris Randle's boyfriend and the father of her children, and he is the one who allegedly and is charged with stealing this 100 pounds of dope. He has not been tried yet on that aggravated robbery charge, and it remains to be seen what will happen. And so I don't know. We'll see. We'll see what happens. Now, the dope was never recovered. It was told to the authorities that the 100 pounds of dope was dumped in the Trinity River.
Oh, really?
Do you really believe that? Come on, 100 pounds of pot? Really? Come on, folks.
That's $250,000 worth of dope.
I mean, that strains my my belief abilities. I have a hard time believing that.
Right. I'm just gonna say no comment.
Yeah, well, I don't believe it. I mean, I'm sorry. Okay, so looking here at the questions, thanks. Well, now, Becky, don't be sending people over to NBC DFW. No, you got to stay here. Don't send them to another station. We don't do that on our YouTube feed. NBC hasn't been providing someone doing play-by-play like we're doing. Oh, see there, Debbie Reisinger says, that's right, we got a separate video posted on it. It's about a minute. I'm reading these questions. Okay, so any guesses on how much longer they're going to be out?
I don't know. Maybe 30 minutes, an hour. I think we get a verdict before 5.
I don't know if I can chit chat for 30 minutes or another hour.
Yeah,
my ability to do that is pretty good. I mean,
right.
Tasha always says I can just talk and talk and talk and talk and talk. Every time they try to cut the mic, I keep talking. So
Tasha and Tanya have a love-hate relationship.
Well, we've known each other a long time,
yeah.
So I tend to be a bit on the bossy side, folks. And she is nodding her head. Yes, she is bossy. Dizia Johnson saying the family is saying that Desmond should have said something sooner so that Shavon may have been found in time.
Oh, yeah,
Why aren't they saying that about Ladoris?
transferred intent to Ladoris. I can see that. I mean, that's plausible.
Well, I'm sure Shavon's family.
We got a light.
Oh, we got a light, folks. We got a light. I'm thinking maybe we got. Okay, so Anna D says the freak out. We've only posted the second one. They want us to post the whole little segment, folks. Okay, well, we'll get it figured out, folks. We're gonna work on it, folks. Sorry, there's a lot going on back here. WB Mitten wants to grab Justin some dinner and discuss your strategy. You've got some fans out there, my friend, but we had fans the last time.
Yeah, we had fans the last time.
Okay, we got a red light. I don't know. Let's see. Let me turn the volume up on my earpiece and see what's going on. I'd be shocked if we don't have what they're going to sentence him to at this point.
Yeah, I think.
I mean, this doesn't feel like a question.
Right.
This feels like a. This feels like we're about to hear how many years in prison he's going to serve.
Right.
Would you say upper or lower?
I hope for a moderate sentence.
What's a moderate sentence?
25 to 30. Gets the possibility of parole. I think that's appropriate for what we saw today. I know there's folks probably that want to see him in prison for the rest of his natural-born life. I can understand that sentiment, but how I'm oriented as a criminal justice reformer, that's what I look for in every case, is that it follows the data and not emotions.
Let's see, while we're waiting here. Juninda Harris wants to know, will they allow Desmond back in court? I don't know. We'll see. I mean, I think it depends on if he can agree to not have any more outbursts. I mean, there's certainly nothing else he can do to hurt himself at this point. I mean, he's already done that in what he did earlier. Let's see. Allison Alexander wants to know, do you guest speak at high school criminal justice classes? Are you talking about me or Justin? I'm not sure if she's asking. I mean, I have spoken at college classes, so I have done that. In fact, I've got one next week that I'm doing, which reminds me that I have not prepared for that.
I need you to prepare for these.
I'm gonna have to prepare for it.
Feature investigative journalist.
Yeah, let's see. Brad Leak says 20. What do you got? What does the rest of the Facebook jury think? Queen Pudding says 25 to 30. Chardee says 20. Kebra McDaniel says, will there be victim impact statements from after the verdict?
I mean, it could be. But
yeah, I mean, it's possible. I mean, we've already seen Shavon Randle's mom. I don't know. I mean, you could see other family members.
But I mean, with him exploding like that in court, I don't know.
All right, we're getting some sound in that courtroom, folks. Jamie Bryant wants to know, Justin, have you ever been scared of a client you defended?
No. I haven't.
I mean, I know I've certainly had people that I've interviewed that I've thought to myself, boy, I'm really hope they don't know where I live. I mean, I've certainly had that. But
Well, I only represent innocent people, so.
Oh, okay. Is that what it is?
Yeah,
okay.
that's what it is.
Okay. Everett Blaylock wants to know, will Desmond stand trial for Michael Titus, and will he get more time? I would be shocked if they had a separate trial on the Michael Titus case. I mean, the Michael Titus was originally in the indictment, and it was actually struck out of the indictment. I don't know why. I don't know why they would have done that, but they did. Why do you think they would have done that?
Maybe they're saying that because Titus might have been the shooter, so they don't know who the shooter was. But there's still,
maybe it's just to make the case cleaner.
Right. So there's transferred intent. So I'm thinking they're transferring Titus's.
I don't know, but I doubt there's another trial. Do we got it?
Is audio still on?
We lost the feed. Are you kidding me?
Nope. Last time this happened, somebody kicked the power cord out.
Man, they're trying to get. They're really trying to. Okay, I think we got sound back, folks. It seems like at every single critical juncture, we're like, there's something happening, and I'm like, okay, what the heck?
Again.
Cody wants to know why wasn't the cousin charged with aiding and abetting, my sense on that is that they want her to testify more than they want to try to charge her.
It's plausible.
Yeah, I mean, because I'm sure Ladoris is going to testify in all the other trials going forward, and you know this. All the legal experts I've talked to have said that it would be very difficult to make the case.
Right, it would be.
I mean, not saying it's not outrageous and indefensible, but.
Well, I mean, I think it should be a practice that you don't indict people that you can't make a case for.
Well, that I don't disagree. I don't disagree. I mean, but her testimony was infuriating for sure.
Let me see the lawyers
Right.
up real quick.
Okay, hold on. We got something here. Sanaya Gray saying the story is all over the place. Well, you're not kidding on that.
Yeah.
I mean, frankly, I don't think I'm still kind of shocked at the events. Okay, what sentence could he get? Okay, the minimum is
15.
15. The upper end is 99. So, and had they found him guilty of a lesser included, it would have been 5 to 99.
5 to 99, right.
So, I mean, we'll see what this jury decides. But you know, these juries they're average people.
Right.
They're not people that are. I mean, these are just normal people that are going about their lives. They're not spending their days at the criminal courthouse. So
Right. These are folks who have 9 to 5s, and you know, sometimes you might get a lawyer in there every now and then, but most likely they're not. They're not defense attorneys or police officers or.
yeah, people keep asking if Desmond's going to be back in the courtroom. Well, that is the $1 million question. I do not know.
Well, they put him in the holdover and turned the mics on, so.
I mean, do they have to allow him to be present for?
No, they don't. I mean, at this point, it's not prejudicial.
Right. I mean, what's going to happen is going to happen at this point.
Right.
I mean, I just have to wonder if the defense had planned on putting more witnesses on before all that happened. I feel like they would have.
Yeah, I believe they would have.
Motion for new trial notice.
It's a motion for new trial.
I don't know. I'm listening here. Let's listen. Oh, okay, guys. So Desmond is back in the courtroom. He just took a seat. So the answer is yes, he will be in court.
Let's hope he can keep his composure.
All right, we're going to cut the mics.
Yes, sir. May I see the lawyers up here real quick?
All rise.
Please be seated. Juror number 6, you have remained the presiding juror, sir?
Yes.
And have you reached a unanimous verdict on the punishment phase?
Yes, sir.
And is your verdict as follows? We, the jury, having previously found the defendant guilty of the offense of engaging in organized criminal activity as charged in the indictment herein, now assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for 99 years and no fine.
Yes, sir.
And that is the unanimous verdict of the jury.
Yes, sir.
Thank you. Does either side wish to have the jury polled?
No, Your Honor.
Mr. Fishburne, the jury having found Mr. Jones guilty and assessed punishment, is there any reason at law why sentence should not now be pronounced?
No, Your Honor.
Mr. Jones, please stand. The jury having found you guilty and assessed punishment, it is therefore the order, judgment, and decree of this court that you be taken by the Sheriff of Dallas County and by her safely held, sir, for transfer to an authorized receiving agency of the Institutional Division of the Texas Department of Criminal Justice, wherein you shall be confined for a period of 99 years or until this sentence is otherwise discharged according to law. Good luck to you, sir. Members of the jury, thank you very much for your participation and your verdicts in this case. We're very grateful. The lawyers appreciate it if you'd remain briefly so that they can thank you and to get any comments you may have to offer, but you're under no obligation to do so. Thank you for your service and you are discharged.
All right.
They need to take that outside.
Jeff, Shaquana, Jimmy, everybody needs to go outside, okay?
Do you need to be on some muscle?
No.
Thank you for having us, Judge.
Thank you,
I
Alan.
appreciate
It's a
it.
pleasure.
I'll bring you muscle milk on Monday.
Okay.
Thank you, Ms. King.
You're so welcome. Thank you.
Thank you, Judge.
Okay, folks, as you can see, Shavon Randle and Shavon Randle's mom and the family just left the courtroom. Clearly, some emotional moments, and the jury has rendered their verdict. Desmond Jones has been given 99 years in prison. Now, that was the maximum sentence they could have given, and as the judge is reading this verdict out loud, Desmond Jones was it looked like he was kind of shaking his head, maybe the judge didn't feel like he was paying attention, so she, said, "Sir, sir," and then continued to read the verdict. And then as she's finished, she says, "Good luck to her. Good luck to you, sir." And then as he left the courtroom, you could see him give one last look. I don't know who he was looking at. Obviously, we can't see that, but definitely kind of a dirty look, like a very angry look. And now we're waiting to see if we're looking outside the courtroom now. Okay, here we go. So we're looking outside the courtroom now. You can see that looks to be Shavon Randle's family. You cannot imagine the emotion that this family must be feeling. It's got to be heart-wrenching, just gut-wrenching, because this is the first trial of 4 that they're going to have to go through. They're going to go through this 3 more times with 3 other defendants. And oh wow, you can just see the emotion. We're waiting to see if Shavon Randle's family is going to talk. you know, you know, and I think in all of this, the thing we can never lose sight of is the loss of this little girl who will never go to prom, never graduate from high school, and never get married. Wow, I'm starting to get emotional. Just I don't know why all of a sudden I'm watching the family and I'm, you know, and it you know, I think that's the thing. You know, you just can't lose sight of that. I mean, this little girl didn't do anything to anybody, and she did not deserve this. And I was just telling folks, Justin just walked back up, that you know, this is the first of. This family's going to have 3 more trials to go through.
Right. I can't imagine having to sit on 3 more of these.
No.
Poor mother.
No, and knowing how your child died, and you got to listen to the description, the medical examiner describe how she was shot, and hearing, you know, the circumstances of where she was found.
Right.
I mean, if I had to go, I mean, as a mother, to have to go through that.
Right.
4 times total. I mean, I don't even want to
I really
imagine
hope
it.
that her family are getting some type of grieving counseling.
I hope so. I mean, you know, nothing will ever bring Shavon back.
Right. Yeah.
But you can tell that there's a lot of emotion. You can see it just watching them, the emotion that they must feel.
I can imagine Jen Falk would be prosecuting the other 3.
You know, I don't know who's prosecuting the other 3. I know that the other 3 are scheduled for Devontae Owens, Laquan Wilkerson, and Darius Fields. They're all in Judge Holmes' court. Now, you guys saw, I mean, Judge Holmes is a tough judge, and she's not putting up with it. And we were wondering before they came back and rendered you know, before we learned that they were getting, you know, that he was getting 99 years, we were wondering whether or not he would be back in court. Then what we saw was that they had a whole lot of bailiffs in there, and he was handcuffed, and she wasn't going to put up with it. Were you surprised? 99 years? Oh, okay. I'm sorry. The feed I'm looking at on my YouTube is slightly behind the actual feed. Sorry, they just showed me another feed, another view, and you can see that they've set up the microphones. Presumably for the family to come out and talk. But were you surprised it was 99 years, Justin?
I'm not surprised. We discussed what the sentence could have been. I told you what I would have liked that scene, just from a purely criminal justice reform perspective. But you know, Jen Falk was very persuasive in what she laid out during punishment, and what we saw from Mr. Jones did not provide anything that had any modicum of redeemability to it. So I totally understand how the jury went back there and gave him a maximum sentence. You know, hopefully Mr. Jones, I mean, he has nothing but time to sit and reflect on his actions.
And he's got 99 years to think about it.
But he's eligible for parole. I don't know exactly when.
I mean, not anytime
soon. But, you know, hopefully he can, you know, rehabilitate himself, get involved in some programs in prison. You know, I see a lot of folks who have these long sentences. After a few years, they become actually credits to the other inmates there, and they're able to help them with their time in prison. So maybe he can get to a point where he can be a mentor for somebody else who's going through some of the same issues that he's faced, and you know, try and turn his life around.
Well, because, you know, and again, I talked about my cousin earlier. The man he was at 19 or 20 years old was not the person he was at 40.
Right.
But I have to think that outburst added a whole lot of years to his sentence. Okay, Tasha wants me to explain parole eligibility. Is he eligible after half the years? Huh? So when is he, after 30 years? Okay. Tasha's saying, see, we should have just put a mic on her. He's eligible for parole after 30 years. So he'll be,
right.
I don't know, he's what, 22 or something? So he'll be in his 50s. He'll be older than I am now when he's eligible for parole.
And I can imagine he has 30 days to file for an appeal. A lot of times that's pro forma. People do that just as a matter of course.
Right.
And he's facing such a long time, so I wouldn't be surprised if he did ask for an appeal. If he gets it.
Well, what is he? He has nothing to lose at this point.
No, yeah. I mean, he has absolutely nothing to lose. Now, if it's the same legal team that he had right now, I don't know if they're going to take another flyer out on him. He might have to find somebody else for that, especially showing how they responded to his outburst. They seem like they kind of threw in the towel a bit. But Mr. Jones has a lot to consider going forward, and not a lot of options. He didn't have a lot of options, but he does have some time to really think about what his life is going to look like going forward while he's in prison.
Well, and now you have to wonder, with these other 3 defendants that are awaiting trial, are they going to see what's happened to him and go, ooh, maybe I don't go to trial, maybe I don't risk this?
Right.
Because there was actually, in the case of the others, more physical evidence linking them.
Well, I know this emboldens the state. They just got 99 years on probably the least culpable member of the organized activity that we have here. So I'm pretty sure they're going to dig in their heels and try and go for 99 for all cases. That if anybody is capable of a hat trick like that, to use a hockey reference, I think Jen Falk and her co-counsel would be primed for that.
Well, and for me, I really liked their use of the puzzle. This picture of Shavon Randle with this puzzle, and then telling the jury that they could put the final puzzle pieces in. To me, that's pretty masterful storytelling, and really being a prosecutor or a defense attorney, it's about telling a story.
It's about telling a story, providing visuals, making it tangible. Breaking it down. You're going through DNA evidence, a lot of technical stuff. You want to make it something in which lay people can find it digestible and understandable. I believe Jen Falk. Although Jen Falk is brilliant, I think a part of her brilliance is making things make sense. I think she was able to do that. Now, also, the defendant wasn't likable at all, so it's not like she had it was a hard sell to get 99 years.
Well, once he has that outburst, the outburst in front of the jury is the significant one.
Right. But even the evidence that they had, it all came from him too. So I don't think.
Do we know, is the family going to talk? Do we know what's going on, guys?
Yeah,
sorry, guys, I'm trying to figure out what's going on here. And can somebody let me text Lopez. Let's text Rebecca.
Maybe the state's going to provide a statement.
I don't know. We're back here at the newsroom, so we're not always completely clear on what's going on over at the courthouse, because we're just literally not in the same spot, because this is going on in the newsroom and we're watching a live feed. I'm going to text her and ask her, is the family going to give a statement?
Excuse me, ma'am.
Okay, texting.
Here, you'll use this mic.
Well, you're just going to have to be very fluid.
What she responds. So for those of you that are joining us kind of late, it would again be pretty worth your time to go back and take a look at what happened. So the jury comes back, they render the guilty verdict, which frankly was honestly not much of a surprise. And then the mother takes Shavon's mother takes the stand, and talks about the loss that this family has endured, and then both sides rest, and sorry, hold on, and then the state rests, and then Mr. Fishburne. Then there's some kind of outburst there with Jones, that first outburst that's outside the presence of the jury. There's some kind of back and forth going on between him and Michael Titus's family. Michael Titus. Okay, Tasha's telling me that prosecutors are supposedly going to talk, but not yet. Okay. So I guess that
probably
means,
in the back talking to the jury.
Probably, yeah. It's hard to say.
It would behoove them to, since they have 3 more of these. Figure out what worked.
I'm sure they are. Brad Leak saying Mike T gets no love, bless his grieving family. Hey, look, no matter Michael Titus's family, ultimately he has a mother, and I actually in a family. I actually, when this first happened, I interviewed his family, and I mean before before we knew anybody was dead. Shavon's missing, Michael Titus is missing. And his mother showed me the text messages that Michael Titus had sent his girlfriend, you know, saying that basically he was in fear for his life. And there is no doubt in my mind that Michael Titus's family is suffering. You know, it's pretty clear based on the evidence we saw in court that Michael Titus was involved in this conspiracy. But that doesn't mean that his mother is not grieving the loss of her child.
Right. And the reality is we won't ever know his level of culpability.
Well, he's not here to tell us.
He's not here to tell us, and you know.
I mean, what we know is that his phone is traveling in the directions, and he's, you know, with these people as this is all going down. I see Rebecca Lopez showing up in my shot. So she looks like she's practicing for maybe her 4 o'clock. I don't know. I'm not sure what's going on, folks. This is part of what you're seeing is sort of the sausage making as it's happening. We're just kind of watching here and waiting to see what's going to happen.
So I actually got it.
Okay, Nick has some information.
So yeah, I changed to a different shot that we have.
Uh-huh.
We'll do a live shot at 4. We'll dip into that and listen to it.
Oh, okay.
As soon as they start going.
Okay, so folks, at 4 o'clock, Rebecca's going to be going live on TV, but we're also going to show it here on YouTube. So that'll be happening here in a few minutes. If that outburst hadn't happened, do you think we'd have saw a lesser sentence?
If that outburst had not have happened, we would have seen more witnesses to testify to Mr. Jones's character. Probably would have mitigated a lot of what we saw during Guilt and Innocence. I don't think he would have gotten 99 years if that outburst didn't happen. He really hurt himself, you know, and he's going to have to think about that. You know, if you can't keep your composure when you're asking for mercy, that's what guilt or innocence is. I mean, that's what punishment phase is. At least when you're presenting your side of the case in chief for that. Yeah, I think that hurt him. You got to be able to keep your composure when you're asking for mercy, because it shows that you're not contrite when you're having outbursts and being overly emotional. Are they having a press conference here?
I don't know here. I think we're waiting to see what's happening. So J. Max Boom says, Tanya, when the prosecutor stood up to object, Mr. Jones protested her interruption to his sister's character testimony. And I'll be honest with you. I mean, I do remember there was an objection. Of course, it all happened so fast, and I haven't been able to actually take the time to go back and like just listen to it and put my headphones on and do it. But I mean, I've never seen a defendant have to be taken out like that in front of the jury. I mean, that's just an extraordinary thing that we witnessed earlier. And again, if you guys didn't see it, I would encourage you. We've posted the second outburst. That was the one that was in front of the jury. I'm on our YouTube page, and I know they're working to splice some more of this testimony. But it's worth taking your time to go back and just watch the whole thing, because it was a pretty extraordinary moments in that courtroom. Something that you do not often see. I mean, it was some serious like court TV kind of stuff.
Right.
Queen Pudding says Mike T unfortunately made a decision that cost him his life, and his family is grieving. So.
Yeah, I mean, that's a family that's grieving too. I mean, you know, you saw his sister up there pleading for his life.
Yeah, and I mean, that's the thing, is that his outburst stops that testimony.
His outburst takes everything that...
They like took the oxygen out of the room.
Right. It took the oxygen out of the room, and it tightened the bars that are going to be around him for the rest of his life.
Yeah. Kat says, can you give us a bombshell tonight? Is that a TV show? I don't know. Bombshell, I don't know what that means. I don't know what that means.
So that means we can't give it to you.
I don't know. I mean, apparently I don't watch enough TV. I don't know. Mike Morrow says, can you post an outtake of the first outburst? Hey Mike, I know they're working on that right now. There's a kind of our web team back here, we're kind of all sort of managing this, trying to keep up as things happen. Poor Nick and Tosh are just doing their best. And let's see. Kate Spinola says he should have shown remorse and stayed calm. Well, I can't disagree with that.
Yeah.
Loretta O'Brien says, now you know how we feel in our living room, Tanya. Hurry up and wait. Well, there ain't no doubt. We're definitely in the hurry up and wait mode here. I've been told that the prosecution's going to come out and speak, so that's what we're kind of waiting on. And then, of course, Rebecca Lopez is going to be going here live here in a few minutes. Oh, okay. See, I never watched Nancy Grace. Vanessa Mack says that Nancy Grace used to say that bombshell tonight. Oh, well, I'm not a Nancy Grace watcher, so I guess I wasn't familiar with that.
How do you and your baby girls feel at this moment?
I mean, we feel relieved. We're not gonna get her back, but we feel it's an amazing feeling to know that we won't see him on these streets no more, to be able to do it to anybody else's child. And I thank God. Oh my God, I thank God. Yes. Oh my goodness. Somebody saw outside of what everybody wants to say. We got to actually see what it was, and I'm just happy we got our justice for Shavon.
That was just the beginning, and you were very persistent that you wouldn't give up. Is there anything you want the community members to know about this experience or just what you got going on today?
Well, we would like the community to know that we love y'all, and we thank the community honestly for all the prayers, all the support, all the way through. Every time I'm walking down the street and somebody notices me, they want to give me a hug and everything. We thank y'all for all of that. And I don't know where we would be without it. Like, we probably would have fell off ourselves because, just trying to just stay strong, period. But, we do. We love the community. We do. We really do.
You mentioned stay strong. And unfortunately, your family has to go through this another 3 more times.
Yeah.
Tough's not going to be for you all.
Yeah. Oh, it's going to be tough, but we're going to get it done just like we just got this one done. Yes. Yeah. We're going to get it done. Thank y'all.
Thank you.
Hey, all my news people.
Paul, are you and your team going to come to the microphone?
Okay, where do you want me to go?
Right in front of the mic. Step up. Don't be afraid of the microphone.
Come on. I'm only doing it with a group. Okay.
Tell us how you feel about winning this case, Ms. Paul and your crew.
I mean, I think the first feeling is thankful, right? Thankful of the jury and thankful for all the work that the jury put in coming to the right decision. Thankful that the family has had faith and patience. Thankful for our community for really rallying behind Shavon and her family, but also our community through the jury service process. And then relieved, right? We've all put in a lot of work. The jurers, the judge, Tommy, Crystal, all of the FBI agents, Detective Rohack, all the science experts, Lieutenant Ivey and Lieutenant Hodge from within our office, and I think relieved in that the right thing happened.
What message do you think this sends to people who do bad things in the community?
I hope it sends the message that I asked for it to send, which is that in Dallas County, we will not tolerate this. Judge Crusoe and the Dallas County District Attorney's Office absolutely will prosecute when you kidnap and murder a child in retaliation for a robbery.
This was an affront to everything that we hold to be right in our society. Right?
Absolutely. Absolutely.
Thank you.
Yeah? Thank you, guys. Thank you.
Will this team try the others?
Yes.
This team, this trio?
Yes. Right?
Absolutely.
Yes. Yes. It's going to be a long year, but we will be here every step of the way. And we will put in every hour that we need to in order to make sure that justice is done and the right thing happens for this family.
Thank you.
They ain't going to try, they going to do it. They ain't going to do it, they going to step on it. Okay?
Look, you better pass
No, everything's
Okay, folks, you saw Shavon Randle's mom, coming out basically saying that, the family feels relieved, and she said it was an amazing feeling that we will not ever see him on the streets again, and that she said we got our justice for Shavon. And then we heard from Jen Falk. She was the lead prosecutor in this case, and she was asked how she felt, and she said thankful. And basically she said that they were sending a message that in Dallas County, we will not stand for this. Mm-hmm. And then she said they'll be doing the other cases.
Right. Well, I'm glad that the family can, begin to start getting closure in this situation. I'm glad that the mother found this to be a punishment that she deems to be suitable. So I think it's good for them to, begin to mend their broken hearts, because I'm sure they have a huge one that's extremely broken from the loss of their 13-year-old daughter. Jen Falk did an incredible job. So did her co-counsel. I think they were able to communicate to the jury succinctly and in a way that took all of this complex evidence and made it make sense to them. Right. So they did a fabulous job, but I would like to see them talk about restorative justice now. You can't be completely retributive. I mean, retribution does not do anything for our society. We need to get to a place to where we get the sentences that are necessary to address certain criminal activity. But we also need to provide the folks who are getting sentenced and getting these convictions the ability to rehabilitate themselves and show that. And I never think, and I don't like hearing cheering when somebody gets sentenced. This isn't a cheerful event. You have a person who was murdered, you have a person whose life has been thrown away. This is a very sad situation for society. Now, I understand that the family has gone through this odyssey for 2.5, 3 years, and I understand that probably was just a release of tension and stress. I get that.
And they got 3 more trials to go.
And they have 3 more trials to go, but to see the prosecution high-fiving on camera and things of that nature, I don't like that. You can do that off camera. I get it, because they probably created a bond with this family that's unbreakable.
Right.
And I get that. This family probably looks at the prosecution team as family now, but do that off camera. Because you have another family, and I'm not trying to say that Desmond Jones needs to be, viewed as someone who's sympathetic, because what he's done today and what he's done over the past 2-3 years, what he did during that 6-day kidnapping odyssey of Shavon Randle, that's something that can't be. It's something that can't be undone, and it's hard to explain that, and it's unexplainable. It's beyond comprehension that anybody would, conspire with other folks to murder a 13-year-old over drugs. And I'm not trying to justify that. But I think as a society, as we move forward beyond mass incarceration, we got to look at how we convict even the most heinous of criminals. Right. So I would have liked to see that, and when I was a prosecutor, I was always taught, you don't show emotion. Even if you get a win, you're stoic. Because justice does not have emotion behind it. It's justice. Right. It's blind, it's balanced, it's even. And, I just wish that we could have seen that today. But I know that.
But it's hard. There's a lot of human nature that goes into
right.
All
It's
this.
a lot of human nature. We're not robots
no,
for sure.
No, we're not. And well, folks, I'm gonna spend the next few minutes wrapping this up. So we are at the end of a 5-day trial. It's been a long journey. Thank you so much for the folks that have stuck with us here. As you saw, Desmond Jones got a 99-year sentence, which was the maximum that this jury could give him for convicting him of engaging in organized crime. Mm-hmm. There was some, and again, if you didn't see it, it's worth going back and watching these outbursts. The first outburst was outside the presence of the jury. The second one was in the presence of the jury, and Justin and I both agree, it pretty clearly, that second outburst cut short whatever his team was attempting to do. And then they rendered a very severe verdict in this case.
And we suspected that verdict was going to be severe, and that's what they gave us. So.
And there will be 3 other people who are going to be standing trial in connection with Shavon's kidnapping and murder. She was shot 4 times, and there's a lot of DNA evidence, there's a lot of cell phone evidence, and I'm sure in the next trials they'll be bringing in Desmond Jones' statements. Those audio recordings will probably get played again, and the next person up for trial is in June, which is Laquan Wilkerson. He was referred to as Chuck during a lot of the trial.
Right.
And then Devontae Owens is set for July. And Darius Fields is in prison right now on federal gun charges, serving an 18-year sentence. So I'm assuming he'll be sometime late
It's important
this year.
to note that Wilkerson was pegged by Jones as the trigger man, right?
He was pegged by Jones as the trigger man for Michael Titus.
Oh, for Michael Titus, okay.
Right. And then of course Desmond claimed that Michael Titus killed Shavon because she saw his face. But again, there's no way to really know what parts of his statement are correct. Well, I'm going to wrap it up here. I do hope that we can do this on the other trials. I think that this little girl's life it's worth honoring her life to do this sort of coverage and to help people understand what's going on. So anyway, thank you so much for joining us, and we appreciate all your time. And thank you. Thank you, and thank you, Justin, for joining me today. And thanks to all the legal experts who took time out of their busy schedules to be with us. Thank you.